you.
Thank you for the serenade, Representative Babbage.
Mhm.
Not sure if you knew you were not
I don't know about other teachers, but all of my students sang that, as I entered the classroom. We're all in our places with sunshiny faces,
At least that's how you remember it.
Exactly.
And then he woke up.
Mm. All right, so if everybody could please activate your video if you haven't, and we can get ready to start. We'll start with our introductions. And then move on. So good morning, everyone. This is the Joint Standing Committee on the Judiciary. Today we have a full agenda. We're doing a number of public hearings on bills in the morning, and then in the afternoon we'll do work sessions. This is a busy time of the legislative session, and so committee members will either be joining us a little late or here now and have to leave for other legislative matters in other committees. So we'll do a round of introductions now and then have folks introduce themselves as they join us. And so at this point, we'll start with you, Representative Thorne, please. Could you introduce yourself?
Good morning. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in Penobscot County.
Thank you. Representative Evangelos?
Hey, everybody. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thanks. Representative Newell?
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the representative for the Passamaquoddy tribe. Thank you.
Thanks. And let's see, Representative Babbage?
Yes, how do you do? My name is Christopher Babbage. I represent House District 8, which is in the town of Kennebunk.
Thank you. Representative Moriarty?
Thank you. Happy sunny morning before the snow flies. I'm Steve Moriarty, representing Cumberland and part of Gray.
Thanks. And my co-chair, Representative Harnett?
Thank you very much, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thanks. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little sliver of Scarborough. Welcome, everyone. We'll get started with our bill hearings. Representative Sheehan, you have your hand raised. Go ahead. Oh, I forgot
to
you.
introduce myself. Of course.
I'm so embarrassed. I'm sorry.
No,
Go ahead.
Don't be. Good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. And again, my apologies to you and to everyone in House District 12 in Biddeford. All right, so we're going to start with our bill hearings this morning. The order of bills will be 738 and then 767. No, 737, excuse me. 767, 853, 1060, and then 1236. And as a reminder, mostly to the members of the public, these public hearings are the opportunity for the committee to hear from the legislators who are sponsoring the bills, as well as from members of the public who wish to testify. We'll ask questions, but then we reserve our, excuse me, our own comments and thoughts about the bills until the work session, which is what we'll do this afternoon on a different set of bills. And with that, I'll open the public hearing on LD 737. And we'll move our bill sponsor, Representative Tepler, onto the panel. Let's see. And Soupy, could you please bring Representative Tepler over from the attendee space? And Representative Tepler, before you begin, I owe apologies to our analyst, Peggy Reinsch, and our clerk, Susan Soupy Panette, because I also neglected to introduce them. We've got Peggy and then Soupy. Thank you very much. And Representative Tepler, welcome to the Joint Standing Committee on the Judiciary, and you can begin whenever you're ready.
Thank you. It is nice to see your bright, shiny faces. Senator Carney, Representative Harnett, and distinguished colleagues of the Judiciary Committee. I am Denise Tepler, and I represent House District number 54, which is all of the town of Topsom. And I'm very pleased to present to you LD 737, an act to increase the value of property exempt from attachment and execution. This bill began when I received an email from a constituent. She is a local attorney who works with clients in my area struggling with collections agencies and the burden of indebtedness. She was concerned with the growing number of her clients who were in danger of losing their homes because in the collection process, they had been left too little money to pay their property taxes and towns were placing liens upon them. The pandemic has exacerbated the housing crisis in Maine and has also, with increased unemployment, led to an indebtedness crisis that is further complicating housing concerns. Working people who were getting by paycheck to paycheck before the pandemic can find themselves in a spiraling crisis with one job loss, potentially leading to the loss of their home or to it falling in extreme disrepair. If a collection agency seizes the assets to the limits currently allowed, they can't even afford repairs on their car, putting them in further jeopardy. The bill makes 3 changes to current law, which will help ameliorate this situation for working Mainers, help keeping them in their homes and paying their taxes, which our towns would appreciate, and covering the basic repairs to keep their toilets flushing and their car inspected. First, it pins the value of a debtor's interest in their residence to the median price of a home in Maine and indexes that value over time. Second, it allows a debtor to retain 2% of the home's value and the amount paid the previous year in property taxes in order to meet the needs discussed above. And thirdly, it allows a debtor to retain their interest in a vehicle of $15,000 or less and in a vehicle worth $15,000 or less, and 2% of the MSRP, manufacturer suggested retail price, for that vehicle, plus the amount of excise tax paid the previous year. It also does allow some retention of monies in bank accounts that other people will testify about. As my constituent said, it seems to me that the hardest thing about being poor is not having money to fall back on when something breaks, and you either have to do without or go into debt to replace it. Some things are easy to do without. Other things are harder to manage without, like a roof, a furnace, or a working car. Updating this law to allow people to save money for these kinds of emergencies would likely help a lot of people who are already in debt save up some money to get out of debt. My constituent refers specifically to individuals experiencing poverty here, but we know the majority of Americans don't have adequate resources to address a personal crisis. Several other changes are made to the current statute, which update it and bring it in line with present-day values and other Maine law. For example, the bill asks judges to consider Maine's minimum wage, not the federal minimum wage, when creating a monetary judgment. This is an important bill to consider if we wish to encourage Maine people to work hard, save, and have the possibility of getting out of debt. If we retain a statute with out-of-date monetary values, we condemn many of our fellow citizens to spiral into poverty when they get into debt trouble, losing their home and their car, creating a hole that is deep and impossible to climb out of. Thank you for your consideration of this compassionate bill. I am happy to answer your questions, but there are others who will follow me with greater expertise in this area of the law. Thanks for your time.
Thank you, Representative Tepler. Committee members, are there questions for Representative Tepler? I am not seeing any, Representative Tepler. Thank you so much for presenting LD 737 to us this morning. And you can stay on the panel if you'd like while we complete the bill hearing.
Thank you.
Yeah, so at this point, I'll turn to the attendee list and ask everyone who is here to testify in favor of LD 737 to please raise your electronic hand and to please keep it raised so that I can efficiently go through our list of speakers. Okie doke. So we're going to start with Andrea Stark. And Andrea, I'm going to bring you over to the panel. It'll just take you a moment to arrive. It looks like Peter Hayden is also here to speak in favor of the bill, and he's already on the panel. So I will, Mr. Hayden, if you can activate your audio and video and begin presenting. And just to let you know, particularly on days where we have a lot of hearings and a lot of speakers, I will be running a 3-minute clock, after which you'll have some questions probably.
Thank you.
You can go ahead.
Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Peter Hayden, and I'm a private practitioner in Scarborough, Maine, in Senator Carney's small sliver of Scarborough, where I have run my own law practice since 2000. I work in 3 primary areas of practice: bankruptcy, real estate, and civil trial work. Previously, I worked in both New Hampshire and Massachusetts since 1988. And I still practice in both those states in bankruptcy. Currently, there is no explicit protection for the family bank account, which this bill will directly remedy. Debtors need 3 things in order to move on with their lives: cash, a modest, reliable car to get to work, and a roof over their heads. Every other New England state gives their citizens a better fresh start than Maine does. This bill will correct that. By way of example, I've cited in my written testimony 2 families in Maine. The first one is Tony, who with his wife lives in a rural section of York County and own a modest home with very little equity. Due to some miscommunications between them and their bank, the mortgage servicer misapplied loan payments that they were making to a different borrower account, and that caused them to get behind in their mortgage. Amazingly, the servicer admitted in a letter that it was their mistake that caused them to fall in arrears in the first place. However, for reasons we don't understand, the matter was referred to outside counsel for initiation of foreclosure, and then COVID struck. Fortunately, Tony and his wife were lucky. They both kept their jobs during the pandemic, albeit with less income due to reduced overtime. What they started to do was, at my advice, was to put some money aside so they were able to catch up with the mortgage once the banks and the servicers were, the stays were removed in order for them to work out their mortgage. Under the present Maine exemptions, their Save the Home Mortgage Fund, Mortgage Savings Fund, which has now grown to a low 5-figure number with over a year of escrowed payments, would not be protected under the current Maine exemption. They would not be able to use it to catch up on their mortgage. If they were to file bankruptcy, the trustee would take control of their funds and distribute it to all creditors and not allow it to be earmarked in their home. This bill would fix that problem. A final point about cash. The lack of any protection in Maine for cash is the most serious for our citizens. With cash, you can feed your family, you can buy or rent shelter, and otherwise take care of your family. Without the preservation for cash, there is no fresh start. For the sake of our most vulnerable citizens, I strongly urge passage of LD 737. Thank you.
Thank you very much, Mr. Haydem. And committee members, are there any questions for Mr. Haydem? Representative Harnett, go ahead.
Thank you very much, Madam Chair. Thank you for being here today, Mr. Haydem. We appreciate your time and your testimony. At the beginning of your testimony, you mentioned that Maine is out of step with our New England counterparts with regards to these issues. Could you give some examples of that briefly as to how other states treat this, and would this
Yes.
put us on par with these other states?
Every other state, including New Hampshire, our closest state physically, obviously, is allows a certain amount for two protections. One is for strictly financial accounts, and one is what we call in the bankruptcy world a wild card exemption, meaning if you don't use your exemption in your home or you don't use your exemption in your car, you're allowed to use up to a certain amount of the wild card in order to preserve other things to move on. Paradoxically, Maine protects value of a home, value of a car, and a substantial value in an IRA, but not cash. So the poorest of our citizens, who don't generally have access to many of those things, can only preserve up to $400, not explicitly by the financial account exemption, which doesn't exist in Maine, but by the wildcard exemption. Candidly, this is pathetically low. Every other state allows a multiple of some thousands of dollars in cash, either on their own or if you're not using the other exemption. So for instance, if you just lost your home in foreclosure 2 or 3 years ago, you're not allowed to put away while you're looking for something else, say last month's rent in a security deposit, which you need in any rental situation. Average rental, $1,000, that's a $3,000 nut that someone looking to rent a decent place is going to have to crack before they can move on from their now foreclosed home. That's the difference. Every other state allows it either directly through a financial, in New England allows either directly through a financial account exemption, or if you're not using the other exemptions, a wild card exemption. Again, this bill would fix that.
Thank you very much, Mr. Haydem. I appreciate the real life example.
Representative Moriarty?
Thank you, Madam Chair. Mr. Haydem, I have a question just to satisfy curiosity. In many cases, the exempt values are very precise numerical figures as opposed to rounded off sums. And I wonder how they were arrived at with such precision.
In the proposed modifications to the statute, I believe the way it was approached was we took the ones that were existed, found the year they were passed, and then applied an index like a CPI. I don't know exactly what index it was, but like a CPI to it to come up with those numbers. So that's why we have some, frankly, odd numbers in exemptions, and certainly rounding those is something we could do pretty easily.
That explains it. Thank you.
Committee members, any additional questions for Mr. Haydem? Go ahead, Representative Babbage.
Thank you, Madam Chair. Mr. Haydem, perhaps I should have asked the sponsor of this question, but can you explain to me what adhering the formula to the median home price income in the state, how that translates in a real money application situation?
Presently that's around $225,000, which is the median income. I'm sorry, the median house value in Maine. And I believe that was derived from Marius, which is the Maine Real Estate Information Service, which I believe is from the Maine Association of Realtors or some other professional organization. That's where we got that number.
But help me to understand what that means as far as bankruptcy protection.
What that means is that much of equity in somebody's home is protected from the trustee's sale for other assets. Again, other states in New England have a much more generous protection. Massachusetts is close to $500,000. New Hampshire is 200. Again, our closest state in both in scope and demographics is 200,000. So we would just be a little bit above that. Candidly, one of the challenges is the value of the home in Maine varies wildly from, say, Aroostook County down to York County. And the challenge is to come up with a number that's fair to everybody. But I believe using that statewide figure is the most equitable way of doing that. So essentially, if you own a home of a value of $225,000 with no mortgage, that much would be protected. If you own a home that was worth more but had a mortgage on it, the equity in it would be protected.
And current law?
It's $47,500 for an individual and $95,000 for people who are for a couple or someone who's disabled or over. It's either 60 or 62. I can never remember. And in my written materials, I cited a gentleman who's lived in Somerset County for a very, very long time, has a modest mortgage, lives in a modest ranch, has some credit card debt, but his mortgage combined with his double exemption, because he's over 60 and is $95,000, he can protect up to $130,000. But the risk for him of filing bankruptcy is under present law, the trustee could sell that house if he or she expected to realize any more money and distribute that money to the creditors. As he said to me the other day, his wish is to live out his remaining years in his home that he worked his entire life to save. And he makes $803 a month in Social Security. Half of that goes to a mortgage he got very many years ago. And yes, the value is high, but at the same time, it seems to me that encouraging an economic policy, a statute that encourages the behavior that Representative Tepler identified before from her constituent, to encourage people to fix up their homes, to continue to live in their homes, is a policy that would serve Maine citizens well.
Thank you, sir. Thank you, Madam Chair.
Thank you, Representative Babbage. Representative Thorne, go ahead.
Thank you, Madam Chair. Welcome, Attorney Hayden.
Thank you.
Thank you for coming to help us understand this bill a little better. You seem very knowledgeable about the nuts and bolts and mechanics of this bill. Not sure if you had a hand in writing it.
One of many, but yes.
Okay. And my question is, in the last line of the summary of the bill, it states that the bill adds a provision requiring that a court must consider the state minimum wage if it is higher than the federal minimum wage when determining amount of insulation payment. And I guess I'm not confused, but I'm trying to understand, because I think the bill is intended to help out the property owner make affordable payments. But then the last line seems to take into account if the state minimum wage is higher than the federal, then the court will take that into consideration when trying to figure out installment loans, which seems to undercut the purpose of the bill.
I certainly don't believe that was the intent, to undercut the purpose of the bill. Quite candidly, I did not have a hand in that particular sentence. Maybe Representative Tepler knows what the source of that was, but I think generally what I'm hearing from the people in the trenches at the disclosure hearings on some of the collections was that there's been differing standards applied to determine what wages are protected and what wages are not. That's my understanding. And I did not have a direct hand in that particular part of the bill.
Okay, I'll leave it at that then. Thank you very much. Thank you, Madam Chair.
You're welcome. Committee members, any additional questions for Mr. Hayden? Not seeing any, so we're going to send you back to the attendee part of the meeting and bring over our next witness. And while I'm doing that, Representative Libby has joined us. Would you like to introduce yourself?
Thank you, Madam Chair. My name is Laurel Libby. I'm the representative for District 64, which is part of Auburn and all of Minot.
Thank you very much. And let's see if all of that worked the way I thought it was going to. I think it did. Welcome, Ms. Stark, to the Joint Standing Committee on the Judiciary. And please begin your testimony when you're ready.
Hello and good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Andrea Bopp Stark. I live in Saco with my family and am an attorney at the National Consumer Law Center, or NCLC, and I'm testifying in support of LD 737 on behalf of NCLC and our low-income clients. This bill increases the Maine exemption limits on property, wages, and assets to make them current with inflation, which will allow Maine residents to keep their home and car, certain amounts in savings, and their hard-earned income that they need to live. And addressing questions from the panel, I will explain how these were calculated. The values were increased for inflation from September of the year the exemption was last reviewed to September of 2020, the most recent inflation numbers that were available to us at the time of drafting. And there's a link to the Bureau of Labor Statistics Consumer Price Index in my written testimony that you can refer to as well. This was used to calculate the increases. So we simply took the amounts that the legislature had previously decided were fair and increased them based on the rate of inflation in the intervening years, with two exceptions, the family home and the family car. We based those on the recommended levels by NCLC's Model Family Financial Protection Act, which you can also find a link to in my written testimony. The car, we increased from $7,900 to $15,000. The average cost of a used car in January of this year was over $20,000. That will get you a 2018 Toyota Camry. Nothing fancy, but very reliable and dependable. $7,900 is simply too low for families in Maine, where there is minimal public transportation, especially in rural areas, where residents depend on a reliable car for everything, for work, for school, medical treatments, going to the grocery store. It is vital to their existence. They need a dependable, reliable vehicle. And the family home went from a maximum of $95,000 exemption, as Peter Hayden explained, to the median state value in a given year, which was in 2020 was $255,000. We need to recognize the large growth in home prices since the exemption was last updated in 2007, when the median home price was only $185,900. That's a 37% increase since it was last looked at. Tying the protection of equity in a home to the median value ensures that Mainers aren't pushed out of their homes because of a credit card or business loan debt. I do have a chart in my written testimony that you can refer to about the increased values. And I will just say that LD 737 will help keep Mainers in their homes, at their jobs, and putting food on the table. And we ask for your support. Thank you.
Thank you, Ms. Stark, and thanks for proactively answering some of the questions that you probably would have been asked. Committee members, are there questions for Ms. Stark? Go ahead, Representative Evangelos.
Thank you, Madam Chair. Hi, Ms. Stark. I was just wondering, after listening to the prior speaker and yourself, something just ran across my mind. You are aware that in the last 6 months that people have been just pouring into Maine and buying up our real estate. And what was once a $200,000 house is easily now $300,000, and they're buying them without even looking at them. So this may complicate your limit on this bill because it's just the housing values have just skyrocketed, and I want to make sure these people are protected. So
yeah, it's incredible. It's incredible what a house is going for, even in my neighborhood now. The prices are soaring. People are leaving the cities and flocking to Maine, and I don't blame them, but it's true that is happening, and prices are through the roof. You're right.
So if the people from New York want to buy my house for 3 times what it's worth, I'm available.
Yeah.
But Representative Tepler, you might want to give that some thought before we get to the work session. Thank you.
Thank you, Representative Evangelos. Committee members, additional questions for Ms. Stark? I am not seeing any. So at this point, we'll give you our, oh, we have one from Representative Babbage. Go ahead.
I'm sorry. Thank you, Madam Chair. Ms. Stark, I just wanted to ask you to repeat once again for me, what was the national legislation perhaps that was used as a guideline for both the House and the car changes?
So the NCLC, the National Consumer Law Center, who I work with, put out a model Family Financial Protection Act. And there's a link in my written testimony to that model bill. And that's been used nationwide by several states. And so we decided to use that as a model for our numbers.
Thank you very much. Appreciate it.
All right, any other questions? Not seeing any. Thank you very much, Ms. Stark. And our next speaker will be Thomas Cox, and he's joining us as we speak.
I think I'm in.
You're in, you're activated, and you can proceed when you're ready.
Good morning, Senate Chair Carney and House Co-Chair Harnett and members of the committee. Thank you. I won't take too much of your time this morning. As you saw from yesterday, my background is I spent 30 years working for the financial industry. In the last 12 plus years, I've exclusively represented Maine low-income homeowners and also defended some Maine residents in debt collection cases. So that's my perspective. That's the perspective I bring to this. The United States Supreme Court back in 1970 said that the purpose of the bankruptcy code is to give debtors a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. And that's what we're talking about here today. And in my written testimony that I filed, I've tried to give an example of how these exemptions statutes not only operate in bankruptcy, but they also operate outside of bankruptcy. So an example I can give you is take a woman who was divorced 10 years ago, and there was a $10,000 credit card debt that her husband was supposed to pay, but he didn't pay. Come forward 10 years, that creditor can go to court and get a judgment for $10,000 against that woman. They can file an execution in the Registry of Deeds. That immediately becomes what's called a judgment lien against all of her property in whatever county that's recorded in, and it will be a judgment lien against her home. If the value of the mortgage on her house and her $47,000 exemption is less than the value of the house, that homeowner can force the removal of that lien. But if the value of her property is over the aggregate value of the mortgage and the $47,500 exemption amount at all by $1 or by $100,000, that creditor can then force a sheriff's sale of that person's home and take it away and keep, and first they have to pay the mortgage and pay the exempt amount to the homeowner, but then the creditor keeps the rest. And I submit that a $47,500 protection for a Maine homeowner has become far, far too low. I would like to submit another argument is that keeping Maine citizens down under the thumb of unwieldy debt loads is counterproductive to building the Maine economy. If Maine residents are discouraged from going out and trying to rebuild their lives because they have insufferable levels of debt, often caused by divorce, job loss, health reasons, or other causes beyond their control, then the Maine economy at large suffers because they can't afford to take care of their house, which impairs the values of other homes in their communities. They are impaired in trying to get back to work. They are a greater burden on Maine's public benefit system. So you're going to have to decide what the proper value of the exemptions are, but I submit that what we have now is a huge detriment to way too many low-income Maine people in rebuilding their financial lives. Another point I would make is that certainly FAME has opposed this bill, and the Maine bankers And Maine Credit Union have submitted opposition testimony, and they have a legitimate stake in this. I do not disagree with that one bit, but I also point out that there are thousands of debt buyer, debt collector bills filed in the Maine court system every year. That money goes out of state. It doesn't stay here in Maine's economy. So I think we also need to keep that into account. And my final comment is just a caution to you. There is also testimony that I think is really very helpful from two bankruptcy trustees. Andrew Dudley will be testifying and Anthony Manhart will be testifying. And I think they have good comments. I do want to caution you to note, though, however, that the bankruptcy trustees have a personal stake in this debate, because the amount of fees that they earn in doing their work is directly proportionate to how much property is exempt or not exempt. So do take their testimony to
Mr.
heart.
Cox, I'm going to interrupt you. I forgot to start the timer, but I think the 3 minutes is up.
Thank you.
And
That's all I have to say.
Let's turn to committee questions. Committee members, are there questions for Mr. Cox? I actually am not seeing any. Thank you very much for being here today. We'll move on to the next person who's testifying is Chet Randall, and he'll be joining us momentarily. Welcome to the Judiciary Committee, Mr. Randall, and you can begin whenever you're ready.
Thank you very much, and good morning, Senator Carney and Representative Harnett and members of the Joint Standing Committee on Judiciary. My name is Chet Randall, and I am the Deputy Director of Pine Tree Legal Assistance. I have been engaged in foreclosure prevention efforts and other consumer issues on behalf of Maine homeowners for over a decade through through Pine Tree Legal Assistance Foreclosure Prevention Project. I want to build a little bit off the testimony you've heard today and talk about an unexpected consequence of the low exemption amounts we have for homeowners. The consequence that I have seen through the foreclosure prevention efforts is a situation in which judgment liens by creditors, which could be third-party debt collectors or other credit card debt collectors, place a lien, as Tom Cox just testified, against a person's property. That lien can interfere with the family's efforts to avoid foreclosure, even as they're struggling with financial crisis and economic hardship. The way that occurs is that once the lien is recorded, if there is not sufficient, if there is a tool, as Tom Cox mentioned, that can require that the lien be removed, provided that the amount owed or the equity in the home does not exceed the limitations in the current exemption statute. If that's not the case, the homeowner may not be able to have that lien removed under Maine law. And the problem is that frequently and in most instances, banks require and loan servicers require that a homeowner remove any liens before they will be approved for a loan modification option or other foreclosure prevention option. And that is because those banks, even though it's in their best interest to avoid a foreclosure, as it is in the homeowner's best interest, don't want their own lien, their mortgage, to be secondary to any other judgment lien recorded in the Registry of Deeds. Our current exemptions for homes makes it increasingly difficult for homeowners to be able to force the removal of a judgment lien that interferes with their ability to obtain a foreclosure prevention option, even as they're struggling economically, even as they're recovering from their hardships and can now afford a monthly mortgage payment, even when the option for foreclosure prevention is in the best interest of both the homeowner, the bank or creditor who owns the mortgage, and the community, and can force a foreclosure despite the ability of the homeowner to resume payments or enter into a loan modification with the bank. This consequence is a significant reality for us, increasingly true for us in the current environment with the property values we've been seeing. For this and many other reasons, we support 737 and strongly urge you, the committee members here, to vote to pass on this important bill. Thank you.
Thank you very much, Mr. Randall. Committee members, are there questions for Mr. Randall? I actually have a question for you. I was wondering if you could please elaborate on the last point you addressed about how credit card debt is affecting, I think you said, the ability to prevent, to avoid foreclosure, and that's having that's impairing both homeowners and the lenders. Can you tell us a little bit more about that, please?
I can, and thank you for the question, Senator Carney. What I was trying to explain that under Maine law, as Tom Cox testified, a credit card debt collector can get a judgment from the court, obtain what's called an execution lien, and record the execution lien in the registry of deeds, and it becomes part of the chain of title in that property. When a homeowner has fallen behind on a mortgage and they owe payments and a foreclosure process has begun by the bank or creditor, there are foreclosure prevention options that may be available to that homeowner, including a loan modification. But the bank, in order to ensure its clean title and ability to foreclose on the property in the future, will not want to enter into a modification of their mortgage lien if it could be considered secondary in any way to that credit card judgment lien. And so the banks will often, loan servicers will require, and my example I cited in my written testimony was a Maine housing loan, where they require that the liens, those credit card judgment execution liens, be removed from the chain of title before Maine housing would approve a loan modification to save the home from foreclosure. The loan modification option that was available was in both the best interest of Maine housing and the homeowner to avoid foreclosure on their house. But the challenge in getting that lien removed as a result of the limited amount of equity exempted under Maine law made it very problematic to get that done. And that's what I'm trying to get at. This is a consequence of the low exemption amounts that we have in our Maine law that made that so difficult. I hope I answered your question, Senator Carney.
Yes, you did. So just to summarize, so even if a lender and a homeowner are ready, willing, and able to renegotiate in order to avoid foreclosure, the fact that there's this credit card lien that has been filed makes it hard for them to reach an agreement.
That's exactly right. Thank you, Senator Carney. That's correct.
Okay, thanks. Go ahead, Representative Moriarty. We're not able to hear you.
That's right.
Thank you.
Thank you. Mr. Randall, apart from the increases in the value of exempt property, are there any other changes in this bill which would adversely impact creditors' rights, such as changes in procedure, changes in options available to recover the loan or whatever the case might be, or anything of that nature?
There's nothing in this bill that would change a lender's ability to enforce the homeowner's obligations under a loan in the context of home ownership. And I am not aware of any other provision in the statute as proposed that would have effects on any other creditor rights. The same court process will continue to exist, the same right to obtain execution liens, the same right to attachment and garnishment continue to exist. It is only changing the amounts of money that are protected against collection to allow folks to get back on their feet. And then the example I'm using, to have liens removed so the families can move forward with preserving their homes from foreclosure.
Okay, thank you for clarifying.
Any other questions for Mr. Randall? I'm not seeing any. Thank you very much for speaking with the committee today.
Thank you, everyone.
And let me bring in our next speaker, who's Leo Delicata. And Mr. Delicata, whenever you're ready, you can activate your audio and video and introduce yourself to the committee. There may be a little glitch. I think I'll bring over another speaker just in case. And Perry O'Brien, I'm bringing you over as well. And would, Mr. Delicata, are you able to activate your audio and video?
I am.
Thank you. Welcome to the Judiciary Committee.
Thank you. I'm finally able to join you. I was having some technical difficulties on my end, and I apologize for that. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Leo Delicata. I'm an attorney for legal services for the elderly, and I'd like to read an abbreviated version of my full testimony, which will consist of a comment about the public policy behind exemptions and give you a story that will illustrate how the current values fail to help our clients. The public policy behind financial exemptions recognizes the wisdom of ensuring that everyone has a fair chance to maintain a basic standard of living and to avoid that level of poverty that prevents a person from participating fully in the life of a community. Fairness is the guiding principle that describes the policy's operation. A basic standard of living is measured by economic factors, and its definition changes as the economy grows. The fact that our exemptions are not continuously adjusted to reflect this dynamic is concerning, because it is all but certain that these figures are lagging behind what they should be. This proposed legislation provides the opportunity to once again bring our exemption laws into line with its guiding principle of fairness. In our practice, the fact that an exemption is part of a conversation with the client is not an academic exercise. It means that they are already in financial trouble and they need help. Most of our clients have worked all of their lives and have marginal savings. They were employed before private retirement plans were common, and but for their Social Security benefits, more than half of them would have no income at all. The poverty rates of older adults vary between our counties, with the lowest being about 9% and the highest over 17%. A woman whose husband had died, called us because she was feeling overwhelmed by credit card debt. She explained that her spouse was gone and that adjusting to one income had been a challenge, and she'd put some home repairs on her 2 credit cards. Her $1,100 Social Security check didn't go very far, and she had been working part-time so she could make the monthly card payments. Unfortunately, she developed medical problems and had to stop working. As a result, she had fallen behind on her payments and had received demand letters from card companies. We learned that all of her income and assets were exempt from collection. However, her home had an equity of approximately $155,000. In discussing her options, we explained that creditors could force a sale of her home if they successfully sued for the debt. She was proud that her home had been in her family for 3 generations, and the thought of losing it was unbearable. She decided that she would like to try a payment plan with the creditors, even though it might not be successful. She might even try to go back to work in spite of her chronic medical problems. This is just one of the heartbreaking cases that we have. The level of stress that clients like these feel is real and unremitting, and adjusting the exemption values would help cure their immediate problems and bring them some peace. And we hope that you vote to pass on this bill. Thank you.
Thank you, Mr. Delicata. And I wanted to ask you, typically when folks testify, they tell us the town that they reside in. And I was wondering if you could do that, please, for us.
Sure. I live in the city of Portland personally, but I work for legal services for the elderly, and we're a statewide legal services organization that provides free legal services to people over 60 who have problems with meeting their basic human needs. They're mostly low-income people.
Thank you very much. We have some questions for you. Representative Thorne, go ahead.
Thank you, Madam Chair. Welcome, Attorney Delicata. Thank you for coming on and testifying on behalf of this bill today. You had mentioned, and I'm trying to take everything into context as it pertains to this bill, that it is possible, and I'm trying to figure out how probable it is, that a credit card company that is owed money could force foreclosure, and you correct me if I'm wrong on that terminology, in order to get their, say, $10,000 owed to them. How often does that happen, that a credit card company takes action like that in order to collect what is owed to them by someone?
I think that the attorneys who have testified before me that actually see a large volume of these cases have a better handle on that. What I can tell you is this: the fact that that possibility is in existence puts an incredible amount of stress on older people. A lot of the people that we serve are, frankly, they're women who have lost their husbands or have been alone for a long time. And they are very, very stressed about any kind of bill or any kind of delinquency. And they'll get a letter from a credit card company, and they won't be able to sleep at night. And all of these things cause a tremendous amount of wear and tear on their physical and mental health. So the fact that they could actually lose their house is one thing.
Mm-hmm.
The result of actually having this level of what they perceive as crushing debt, and in the particular example that I gave, a person who has a multi-generational home, which a lot of older people in Maine have. In Maine, a lot of families, you get one house, and it gets passed down generation to generation. And the idea that this grandmother would have to lose sleep because these exemption amounts were so low. She was fine when her husband was alive. She had $195,000 as an exemption at the time. He died, and she ended up with a $90,000, $95,000 exemption, and her house was worth $155,000. She couldn't sleep at night. And that's really, that's really what we see. We see this level of real distress that these exemptions were designed to alleviate.
Thank you for that answer. Thank you, Madam Chair.
Welcome. Representative Babbage, go ahead with your question.
Thank you, Madam Chair. Just a clarification, Mr. Delicata. Good to see you again. The 9 to 17% variant by county is a percent of elderly in poverty of what population? Is it of seniors? Is it of total population? Is it what?
No. It's the total population, not the population of seniors in that county, but the total population in that county.
Okay. Thank you. Thank you, Madam Chair.
You're welcome. And I actually had a very similar question to Representative Babbage. You've described a range in county poverty rates. Can you please let us know if you know it off the top of your head, the counties that have the highest rate of poverty among older Mainers?
They're the counties that you would expect. There'd be Washington County and Aroostook County, and I think, now I can't remember what the third one was, but I believe Washington County is the 17% figure. It's a very, very, very poor place compared to the rest of our counties.
Do you have access to that information that you could provide to us for the work session? Maybe a chart that ranks all of the counties and gives us the percentage?
I don't have a chart, but I do have the information, and I can provide it. Yes.
Appreciate that. Thank you. Committee members, are there additional questions for Mr. Delicata? Not seeing any. Thank you very much for appearing before the committee today. And next we have Perry O'Brien. Thank you for joining our panel, and you can activate, welcome you to the Judiciary Committee. Please begin by letting us know your name, which is already displayed on the screen, but then also your town of residence. Thanks.
Thank you, Senator Carney, Representative Harnett, members of the Judiciary Committee. Thank you for allowing me to speak in support of this bill. My name is Perry O'Brien. I'm from Bangor. I practice law up here. I represent debtors, and I specialize in bankruptcy. I've been at it for almost 40 years now. I would indicate at the outset that the exemption statute that's before you has been in effect longer than I've practiced law. It came into effect in 1981. I started practicing law in 1984. So I've been working with this exemption statute for my entire career. Some of the exemptions have never been increased or updated. Historically, the exemption changes have been more targeted. The motor vehicle exemption has increased, the homestead exemption has increased, things like that. Things like the wildcard exemption, that $400, I don't think it's been increased in 40 years. The tool of the trade exemption, I think it went up to $5,000 in 1991, so that's been in effect for 30 years. There has never been a comprehensive look at this exemption statute and a comprehensive update of the amounts involved. So I think it is certainly something that's long overdue. And in that regard, I am in very strong support of this attempt to update and modernize the exemption statute. I deal with 4422 every day in every case and with every client. So I have a very good familiarity with the exemptions and the limitations under the exemptions. In a Chapter 7 context, bankruptcy trustees like Anthony Manhart will liquidate non-exempt property. So if it's not on the list, it will be liquidated. If there are amounts in excess of the available exemptions, those have to be liquidated, or the exempt amount paid to the trustee for the benefit of creditors. In a Chapter 13 context, where you do a plan of reorganization, I deal with Andrew Dudley on a regular basis. I file a lot of Chapter 13 cases. In the Chapter 13 context, you have to meet a liquidation analysis. That simply means that you have to pay in to the plan for the benefit of the unsecured creditors the amount of the non-exempt property. So you have $10,000 in non-exempt assets, you have to pay your unsecured creditors at least $10,000 in the plan. And certainly trustees have a benefit to liquidate property because they do get paid a commission. The higher the exemptions, the less property to liquidate for the benefit of creditors. But at the end of the day, I'd like to make it clear that I don't just represent poor debtors. I represent poor debtors. I represent a lot of working class debtors. I represent a lot of middle class debtors. I represent a lot of hardworking Mainers trying to get a fresh financial start. I represent a lot of business owners that need the benefit of protection under the bankruptcy law. So don't think that increasing the exemptions just affect poor Mainers. It affects a great array of Mainers, all of whom need protection under the bankruptcy laws and who are suffering financial hardship.
Mr. O'Brien, the 3 minutes is up, and I just ask you to pause there and let me see if committee members have some questions for you. I see Representative Babbage, is that a new hand or residual? Okay, Representative Moriarty, go ahead.
Thank you, Madam Chair. Mr. O'Brien, do the current exceptions reflect the 1981 levels, or have they been adjusted between now and then?
Some have, some have not. Some have been in effect for 40 years, some have been in effect for 30 years. The motor vehicle exemption went from 5,000 to 7,500 2 or 3 years ago. They increased the amount of retirement plans. The tool of the trade exemption, like I said, hasn't been updated in a number of years. The wildcard exemption hasn't been updated, I don't think ever. I don't recall it being updated. So it's kind of the exemption changes have been targeted and they've been good changes over time. And they've also been reactive. In a couple of examples, bankruptcy trustees went after certain property. One bankruptcy trustee, and I think it might have been Mr. Manhart, discovered that fishing boats, a debtor's fishing boat, was not protected under the exemption language in effect at the time because it said it had to be under 5 tons burden. it worked out that most fishing boats were over 5 tons burden. So the trustee said, I'm going to start liquidating fishing boats. The legislature very quickly acted an emergency piece of legislation and increased that to under a certain footage. So that was a very good change. Another sort of reactive change was a trustee looked at the statute and said the earned income tax credits not exempt, not protected. So the trustee said they were going to go after earned income credits. The legislature very quickly plugged that hole as well. So it's a mix of some exemptions have been changed and increased, and some have not. And that's why I think it's a great opportunity to do a comprehensive update of the exemption statute. And it is very, very much needed for the clients I have.
So is the list of exemptions in the bill comprehensive?
No. There are things that are not exempt, if that's what you're asking. Like health savings accounts aren't protected. Bankruptcy trustees can liquidate what's in a health savings account. The child tax credit is not protected. If a debtor gets a tax refund and a part of that is due to the child tax credit, that has to be turned over to a bankruptcy trustee because only the earned income and additional child tax credit is protected. The 5,000 tool of the trade exemption is not a lot for a fisherman. A fisherman's traps aren't protected. Gear, tender boats not protected. It has to be under that $5,000 tool of the trade exemption. So it's far from comprehensive. I don't want to move towards all the things that aren't in 4422, but certainly a consideration of what's not in there would be appropriate if you're going to do a comprehensive review of 4422.
Thank you.
Committee members, are there additional questions for Mr. O'Brien? Not seeing any. Thank you very much. Oh, Representative Newell, go ahead.
Thank you, Madam Chair. Please excuse my delay. Thank you, Mr. O'Brien, for being here and providing your testimony. It was very, it provided a lot of information. However, in looking at the list of written testimony, I see that you did not submit your written testimony. Am I correct?
Yes, you are correct. I was somewhat late to this process when I was asked to speak. It came about in a roundabout way. So I certainly can submit written materials if it's allowed post-hearing, and I'm more than willing to do that.
That would be appreciated. Thank you so much.
Thank you, Representative Newell. That was a great point. Representative Thorne, go ahead.
Thank you, Madam Chair. And again, I thank the committee for indulging me on this question. And just as a point of clarity, you mentioned, and I see MRSA 4422, and you seem pretty knowledgeable on that, Attorney O'Brien. And I'm wondering if, for a non-attorney, you could summarize what 4422 is in one sentence?
It is what a debtor is allowed to keep for property that is exempt from creditors. Creditors can't get at it, and bankruptcy trustees can't get at it. It's the minimum level of property that the legislature has indicated that a debtor should have. That's more than one sentence. I apologize for that.
Thank you. That helps me, though. Thank you. I appreciate that. Thank you, Madam Chair.
Yeah, and thank you as well for that good question. All right, it looks like there are no other questions for Mr. O'Brien. Thank you once again for appearing before our committee today. And then I think our final proponent speaker is Frank D'Alessandro. We do have some committee members who have joined us, but let's hear from Mr. D'Alessandro, and then we'll do a second round of intros. Go ahead, Mr. D'Alessandro.
Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Frank D'Alessandro. I'm the Litigation and Policy Director of Maine Equal Justice. And for your information, I live in Standish, Maine. But we're a statewide organization. We're here to testify in support of LD 37. We do that for several reasons, primarily because this bill proposes to increase the amount of property exempt from attachment and executions. In addition, the exemption set forth in this bill will automatically be increased to meet inflation. And we think that's really important. So as you've heard before, a lot of these exemptions haven't been updated in a long time. It takes a lot of effort to change the bill, and this is built into the process. Also, I would point out there are a bunch of people who are going to testify in opposition to this, but even the people who are going to testify in opposition, most of them, at least according to their written testimony, or many of them at least, agree that the exemptions are too low and they need to be increased. Maine Equal Justice also supports LD 37 because the increased protections will protect the wages of low-income Mainers by tying the amount of garnishment to the higher state minimum wage instead of the lower federal minimum wage. Even before the pandemic, 27% of Maine residents had a debt in collection with a total of $51 billion in debt. Nearly 60% of extremely low income households pay more than 50% of their monthly income towards rent and desperately need the protections offered by this bill. And I'd just like to point out, because this came out earlier, the impact of increased housing costs does not really benefit Mainers, okay? Because right now, without increasing the exemption for housing costs, while the price of housing has gone up, now there's a greater portion of the person's house that is not exempt and therefore subject to attachment. But if this person has to move into a new place, the cost of the place that they're going to have to move into has also increased. So here, if you don't increase the exemption now to reflect the great increase in housing prices right now, which increased 22% just in from September of 2019 to September of 2020, you're really making Mainers vulnerable and putting their ability to maintain their housing at risk. And also to answer a question that was asked previously, in my experience, if a credit card company has a $10,000 debt against the debtor, they're very aggressive in trying to collect that money. Also, the other thing to point out is the condition of most Mainers. Most Mainers, even before the pandemic, did not have the financial wherewithal to pay an unexpected expense of even $400. Currently, we really think that the protection for bank accounts is really important. Currently, in current law, there's no protections for bank accounts. And this amount would be this is an aggregate amount. It doesn't apply per bank account, it's total bank accounts. The wage garnishment should be, this legislature has passed a state minimum wage, making the determination that that's what's necessary in the state of Maine for someone to live, and what the minimum wage should be.
Mr. D'Alessandro, I'm sorry, the 3 minutes is up. So let's, if you could give us a one sentence wrap up and then we'll turn to committee questions.
Okay. And also there was a need to change that's not in this bill, a need to change the child tax credit. The current law protects a child tax credit, but only minimally. And if you remove, you could give the same protection to a child tax credit as all tax credits simply by removing the language of additional and putting all. And I think that was the intention of the legislature when they passed that protection.
Thank you very much. I know that there are some committee members who want to ask you questions. Go ahead, Mr. Representative Evangelos.
Thank you, Senator Carney. Hello again, Mr. D'Alessandro. Thank you for your testimony. Just a quick question. As you were testifying, something ran through my mind. This is a hypothetical, but not necessarily something that doesn't happen quite often. But so two people, let's say they're middle-aged, enter into a relationship, and then they get married. One of them had a bunch of credit card debt, and one of them didn't. The spouse that had the credit card debt passes away. These are, moderate income people, low to moderate income people. what happens to the surviving spouse? And do those credit card companies have a grab on the assets of the surviving spouse?
Well, if the assets have been turned into marital property, I believe that the creditor would have a claim against the estate. If like there was a house and the person who owed the credit card debt was not on the mortgage and it was not turned into marital property, that would limit the creditor's ability to collect against the estate.
So in the hypothetical, the two people, ended up getting a home and they're co-signers on the mortgage, and but the person who had the high credit card debt was embarrassed about it and never told the other spouse. What happens in that? Because I think these things, I mean, in the financial news that I read, there's always these cases they're talking about. What happens is the person who survives and didn't know about it on the hook?
Well, they could be. There was a statute passed by the legislature 2 years ago that talks about places limitations on the ability of debt collectors to collect on debts that are a result of economic abuse. And if that, you'd have to look at the facts of the case, but if it fell within that definition, then that would limit the creditor's ability to collect on the debt. I mean, the other thing to be clear is that this exemption statute doesn't apply to all types of debts. Like, for instance, child support, the collection of past due child support is subject to other provisions which specifically state that the exemptions in this title do not apply, for example, to the collection of child support debt.
Thank you.
Thank you, Representative Evangelos. Go ahead, Representative Harnett.
Thank you very much, Madam Chair. And this is a very quick question. Mr. D'Alessandro, thank you for being here. I just want to make sure I'm reading the proposal correctly, and I want you to focus on the adjustment of the median house price every year. In the event the median house price went down, that number could go down. Is that correct?
I believe that's correct.
Okay, thank you.
Committee members, are there any additional questions for Mr. D'Alessandro? I am not seeing any, so thank you very much for providing testimony to the committee this morning. At this point, we will move, well, first I'll ask, are there any other people in the attendee space who wish to testify in support of LD 737? If so, please raise your electronic hand. I'm not seeing any, so all those who are here to testify in opposition, please raise your electronic hand and keep it raised. I will start moving you into the panel. While I'm doing that, could the committee members who just joined us introduce themselves? I think that is Representative Libby. I don't know if you have already introduced yourself, but Representative Poirier and Representative Reckitt as well.
I don't know who should go, so I'll go. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Thank you very much, Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. And Representative Libby, I'm just being forgetful. Have you already introduced yourself? Great. All right. I think that covers everyone. If not, please raise your hand. Okay, I think we're all set. And we've been joined by Mr. Greenberg. And Mr. Greenberg, you can activate your audio and begin, please, by introducing yourself and telling us your town of residence, and then you can start your testimony.
Thank you, Senator Carney, and thank you, Representative Harnett and other members of the committee. My name is Stanley Greenberg. I'm a licensed Maine attorney, and I live in Winthrop. And I speak in opposition to LD 737, I have submitted some written materials and also some exhibits to the written materials, which I hope you'll have a chance to look at. But my basis for opposition is broken down into 5 parts. I won't be able to cover them all. I do want to reserve some time to rebut some of the statements made in support of the bill. Principally with the homestead exemption, my written materials trace the history of the homestead exemption, and it goes back to 1850, which was well before Attorney O'Brien started practicing. It was $500 then, and it measured increases over time. It's now at $47,500. When it was increased to $47,500, the legislative committee that reviewed that bill made a statement in the committee amendment that the amount was not going to be 100,000 as originally proposed, but 47,500, because that was more in line with the increase in home prices in the intervening period. Now, this bill, LD 737, abandons that approach. It just picks a number out of a hat, really, the median home price, which does not mean the median value of every main home. It means the median sold price of real estate in the preceding year, which is a statistic kept by the Maine Realtors Association. So it's the median sold price is the correct term. And that is currently well in excess of the $225,000 because of the factors that have been cited. But if you apply the measured increase in those median sold prices in the intervening period since 2008, when the last increase occurred, you derive an exemption figure of some $62,000 plus, not $225,000. So that applies the increase in the median sold price in the intervening years, 2008 to 2020, $62,000 plus, not $225,000. Now, the present law has some protections for people. There's a higher exemption for the elderly and disabled, which is $95,000. This bill abandons that protection. It basically says $225,000 is high enough to protect all the elderly and disabled people, which begs the question, well, if it's high enough to protect them, why does it have to be so high for single people? There's also a protection in the current statute that says that certain debts are not subject to the higher exemption amount. These would be debts that are the result of intentional misconduct. So these exemptions apply not only to the boogeyman of credit card debt, but all kinds of debt arising out of torts, arising out of commercial breach of contract cases, arising out of many other sources and not just consumer credit matters. So there's a protection for debts that arise out of intentional misconduct. Those are not currently subject to the higher level of exemption with real estate. I want to make
Thank you very much.
Thank you.
Mr. Greenberg, the time is up and I gave you a little extra. Let's see if committee members have some questions for you. Committee members, are there any questions for Mr. Greenberg?
And
Representative Babbage, did you have a question? I am not seeing any questions. Thank you very much for being before the committee today.
Thank you.
Next, we'll bring over Andrew Duddy, and he'll be joining us momentarily. And welcome, Mr. Duddy. Thank you for joining us. And if you could introduce yourself and let us know the municipality in which you reside, and then begin your testimony.
Thank you, Senator Carney. Good morning, Senator, Representative Harnett, and other distinguished members of the committee this morning. Thank you for allowing me to testify. Today, my name is Andrew Dudley. I am the standing Chapter 13 trustee for the District of Maine, and also a case-by-case Chapter 12 trustee for the District of Maine. And I currently reside in Topsom. I was appointed as the Chapter 13 trustee here in Maine in 2017. I've been an attorney practicing in the bankruptcy arena for over 20 years, representing both debtors and trustees during the course of that time. I want to start today by making it very clear that my views today and my written testimony do not represent in any way the position of the United States Trustee Program or the United States Department of Justice. They are my personal views as a resident of Maine and an attorney and trustee practicing in bankruptcy. I want to make sure everyone understands my role as a Chapter 13 trustee. Chapter 13 is a different bankruptcy than a Chapter 7. A Chapter 13 bankruptcy is a so-called wage earners bankruptcy where debtors make monthly plan payments to me and a court-approved plan, and I then disperse those payments to their creditors. I'm not a liquidating trustee. I do not take non-exempt property and liquidate it for the benefit of creditors. In a Chapter 13, debtors are allowed to keep their property. They simply have to make monthly plan payments to me in order to satisfy that. I have submitted some written testimony. I just want to make a few points. First, a number of speakers today have noted that there are people for and against this bill. There's no disagreement, I think, that the exemptions need to be updated, that they need to be increased. And this bill does do that for a number of things. But there are 4 specific areas that this bill fails at, which would urge me to urge you to vote that this bill not pass. Specifically, there's certain portions of this bill addressing the homestead exemption, addressing the vehicle exemption, addressing the cash and bank accounts, and the adjustment of these amounts all need to be revised or eliminated entirely in order to clarify this bill. The problem with this bill is that there are a number of provisions that are unduly and unnecessary, complicated, ambiguous, unwieldy. Specifically, those provisions, which I've outlined in my written materials regarding the homestead exemption and the additional add-on 2% of the median home price, those provisions seem to be designed, and I'm sure they weren't, but they seem to be designed to do nothing but increase attorney's fees for litigation, because a number of those issues, as outlined in my written testimony, are ambiguous, they're unclear, and when we're dealing with these exemptions, the way to truly help consumers in Maine is by increasing these exemptions amounts, but keeping things simple. Keep it clear, keep it concise, keep it simple. For the homestead exemption, simply increase the homestead exemption to a certain amount. In this case, the maximum homestead exemption, as you've heard a number of people say today, is $190,000. So simply increase the homestead exemption to $190,000 without regard to whether it's a single person or a married couple.
Thank you, Mr. Dudley. The 3 minutes plus some has expired, and let's just turn to the committee and see if there are questions for you. And I see that Representative Thorne has a question. Go ahead, Representative Thorne.
Thank you, Madam Chair. Welcome, Attorney Dudley, for coming in today and testifying on this bill. I'm wondering if you could elaborate. You made a comment that all this does is increase attorney's fees. What did you mean by that?
Well, what I mean, Representative Thorne, is that a lot of these provisions, specifically these additional add-on provisions, homestead and the vehicle exemptions, they're ambiguous, they are unclear, they offer a lot of opportunities for attorneys to argue about things that are going to delay folks who, say, for example, are in bankruptcy and moving forward in their case, for delaying even creditors who may be seeking to enforce judgments, all creating these issues because they're unclear, they're ambiguous, they're unwieldy, they're confusing, and it all leads to increased efforts on attorneys, both on the debtor side and creditor side, and potentially even the trustee side, of litigating these issues to determine what is the manufacturer's suggested retail price that we use for a car, for example. Is it a car? Is it the manufacturer's suggested retail price when the car was bought 10 years ago? Well, why should they get an exemption for a vehicle that's 10 years old at the manufacturer's price, which has depreciated substantially? So that's what I mean, is that these additional provisions, while I agree that the exemption amounts need to be increased. Certain provisions need to be revised or eliminated altogether in order to help consumers throughout the state in achieving their goals in bankruptcy, of getting a fresh start, of protecting their property, and having sufficient property and their home and their bank accounts to be saved. And those, my issues are all outlined in my written testimony.
Thank you. I appreciate that answer. Thank you, Madam Chair.
Committee members, any additional questions for Mr. Dudley? Go ahead, Representative Harnett.
Thank you, Madam Chair, and thank you very much, Mr. Dudley, for your oral testimony. And I did read your written testimony, and it's clear to me that you're urging us to vote ought not to pass on this as written. But you've, just so I'm clear, you've also acknowledged that some of the exemption amounts are out of whack, need to be adjusted, given the amount of time that has gone by. Is it possible that if that occurs and these numbers change at a work session, you might be in a position to change your position on the bill?
Absolutely. Again, you hit the nail on the head, Representative Harnett, is that the numbers in the exemption statutes in Maine as now stand are pretty low. And were the provisions that I've outlined eliminated entirely and some other revisions added and clarified, absolutely, I would totally support an increase in the exemption amounts for homestead, for a vehicle, again, as outlined in my written testimony.
Thank you, sir.
Committee members, any additional questions for Mr. Dudley? I am not seeing any, so Mr. Dudley, thank you very much for providing testimony to the committee today. I'm going to move you back to the attendee part of the meeting and welcome Mr. Norbert to testify before the committee. And please start by introducing yourself and telling us the municipality where you reside.
Thank you, Senator Carney and Representative Harnett and distinguished members of the Judiciary Committee. My name is Bill Norbert. I'm the Government Affairs and Communications Manager for the Finance Authority of Maine. I live in the town of Brunswick, and I'm a proud alum of the Judiciary Committee. I know the special place it is. I served there for a couple terms in a prior life, and I want to present you with some virtual chocolate. And I hope
that is not fair.
Hope to give you real chocolate when we can all return to the State House. And I know you'd agree with me. The committee has a lot of special parts, but the staff, in particular, Ms. Reinsch and Ms. Panett, are what make it so special over all these decades. So thank you for having me. I'm going to abbreviate my testimony. I want to point out that FAME is a compassionate and reasonable agency. We make every effort to work with borrowers. We've deferred all collections on loans during the pandemic, but we are a public entity with public money. And we do make loans that you count on us to make to commercial businesses, to students for student loans. And we take risks that others won't take. And we do that for public benefit. So I'm not an expert at collections, but our general counsel, Chris Roney, is. He regrettably could not be here today due to a board meeting with the FAME board, but hopefully he'll be able to attend the work session. But you know, our concerns, I think, were outlined by the prior speakers. Mr. Dudley in particular, I think, nailed our points about the housing. The housing allowance seems to us excessive. We favor reasonable updates to this statute. It's the right thing to do. We do take issue, though, with these, the housing part, which you can see in our testimony, the concerns about that, and some of the, the personal banking accounts. There are a lot of good businesses. Think of an oil dealer who, have deals on credit with customers who would be out of luck with this, and others. We just think the amounts are too much with respect to these two areas. And again, it's going to make FAME's work collecting on public money hard. So we do urge you to consider revising those amounts, but we do not have issues with periodic updates to this statute. So with that, I'm happy to cut short, answer any questions I can, but keep in mind, it's our general counsel who really has the most expertise in this field. Thank you very much for your time.
Thank you. Committee members, are there questions for Mr. Norbert? I'm not seeing any questions, but I did have a question for you. So can you talk to us a little bit more about how FAME takes, I think you said takes risks for the public benefit. And so
Yeah.
do you engage like in foreclosure actions against borrowers?
Yes. Sometimes we
Talk
don't
to us
like
a little bit
to.
more about that, please.
Yeah. Sometimes when a loan goes bad, we borrowers come to us. We do try and work in partnership with lenders, and we often collaborate with main banks and credit unions. Sometimes they're not comfortable making a loan to a business, and that's when FAME can come in and provide loan insurance, to guarantee the loan if it goes badly, so that we will insure it, and the state gives us that money, and we use it judiciously. And we do have low default rates because we work really hard with borrowers to make arrangements. But sometimes you can't help it, and you do have to go to collections. And sometimes it involves a house or a car, and that's tough. But yeah, so I hope that helps somewhat.
Do you share the concern that the current exemption amounts are too low? I'm thinking in particular regarding homes and cars, actually, because we know that Maine has a really significant affordable housing shortage, and we know that people need their cars to get to work.
Yep, they do, and they should. That's in the statute recognizes that people should have a chance to get back on their feet. And again, in addition to the statute, FAME makes extra efforts working with borrowers to give them a chance to get back on the feet, to get to work, to help pay back. Too low, I think we have outlined in the testimony the parts we think are too high. As far as the other parts of the bill, we don't take issue with those being updated. We don't take issue with some updates being made to housing and cars and bank accounts. It's just that the amounts in the bill are too much for each of those, we think. Basing, for instance, the housing on the median price, as Mr. Dudley just pointed out, instead of the median value. I mean, that's an entirely different thing. So I think it's about what you base it on and how high. It's really the amount that is our concern.
And just another follow-up question. So we had heard some testimony earlier comparing the exemption amounts in Maine to the exemption amounts in among our neighboring New England states.
Yeah, I heard that.
Have you looked at those, and do you have suggestions for where Maine's exemption amount should be set?
I have not. I do not have any suggestions today. I'm happy to check with our general counsel and see if we do, but I think there can be some common ground reached. I just think these areas have to be reworked.
Yeah, I think particularly with an organization that really is working for a public benefit, that it's important to kind of keep that in mind.
Absolutely.
I've monopolized the virtual floor here, and I see that Representative Thorne has a question. Go ahead, Representative Thorne.
Thank you, Madam Chair, and welcome, Attorney Norbert.
Thank you.
And I guess my question is just as a point of clarity, and everybody keeps referring to the amount of $225,000. And I didn't know if that was intended to be an up to amount, or, I mean, it seems like that number is there and everybody seems to be hung up on it. One says too low, one says too high. And I didn't know, obviously, each individual case is going to be different. Does that indicate that you can't exceed that number, or?
The proponents of the bill could best answer that, and the folks who testified who work every day in collections. But I think that it would be up to that amount would be exempt from any attachment or execution on a lien. So you could, if there's equity in the house after the mortgages are taken away in excess of that, then the creditors could go after that, is my understanding. But you do have other experts who could answer that, sir.
Okay, I'll leave that right there. Thank you.
You're welcome.
Committee members, are there additional questions for Mr. Norbert? I am not seeing any. Thank you very much for being here today, Mr. Norbert.
Thank you.
And bringing over Mr. Manhart, who will appear momentarily. Welcome, Mr. Manhart, to the Joint Standing Committee on the Judiciary. Please introduce yourself, and let us know the municipality you reside in, and then you can start your testimony.
Good morning, Senator Carney, Representative Harnett, and the distinguished members of the committee and the staff. My name is Anthony J. Manhart. I am an attorney that lives in Portland, Maine, and I am testifying in opposition to LD 737, primarily in my capacity as a bankruptcy, Chapter 7 bankruptcy trustee. I am obligated to say, as Mr. Dudley did, that the views I express are mine as a bankruptcy trustee and practitioner in Maine, and do not express any of the comments, views, or opinions of the United States trustee or the United States Department of Justice. So I've submitted written testimony, and I ask that you read that testimony as it provides a more fulsome statement of the issues that are impacted by LD 737. And I do suggest some common sense revisions to the bill. I think I echo Mr. Dudley and the other speakers that there may be some room to update the numbers in the 4422 section. But in sum, this change is a big deal for those of us who practice in bankruptcy, insolvency, and collections. The changes are not only significant, but troubling in many aspects. While framed as updates to the numbers of the exemption statutes, the bill proposes major changes to the exemption scheme. And just to be clear, these changes do not really impact mortgages or auto loan lenders, only unsecured creditors, and that's anyone from banks to credit cards to small businesses that loan money to their neighbors and to plaintiffs that have been injured. By way of quick background, bankruptcy trustees are prolific end users of these statutes, and we're constantly reviewing and applying these statutes. I commend you to my written testimony for more on the role of the bankruptcy trustee. But since my time is short, I'll just point out 3 examples of what I find problematic in the bill. The first is the concept of exemption stacking. So what that means is basically if this statute passes as written, even though the residence exemption is based on the home price of one home, married couples would be able to protect $450,000 of equity in their home and $30,000 in a motor vehicle and other exemptions in Maine, which would be one of the most generous exemption schemes in the country. And despite what the written materials and testimony from the National Consumer Law Center, which contains some creative ways of making Maine look bad, Maine is not that out of line with its neighboring states. The second area is the imprecise drafting, which will provide, as Mr. Dudley was saying, with areas for litigation about what the amount of these exemption is, particularly the median home price. Although Mr. Greenberg suggested where that number comes from, that's not in the statute. So the practitioners don't have a reference point for where to find that number. And finally, and I think it's important, and I think Mr. Greenberg pointed this out, and that the bill eliminates differentiation between Mainers of different ages, disabilities, and those that have children, which is in the current residence exemption. So again, I want to reiterate that protecting hardworking Mainers is important, but LD 737 does not do that. I would urge you to read my written testimony and vote ought not to pass for this bill, at least as it's written. Thank you for your time, and I'm happy to answer any questions that the committee has.
Thank you very much. Committee members, are there any questions? I am not seeing any. Thanks for appearing before the committee today.
Thank you very much.
And I think that brings us to our last person here to speak in opposition to the bill. And so I'll invite Mr. Caney to activate audio and video and introduce yourself. And in the meantime, could those who are in the attendee space who are here to testify neither for nor against, please raise your electronic hand and keep it raised. And Mr. Caney, thank you very much for joining the committee. You can begin when you're ready.
Thank you, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Bill Caney. I live in Saco. I am a Senior Vice President at Saco Biddeford Savings, and I am the chair of the Legislative Committee for the Maine Bankers Association, which is a statewide trade organization representing Maine's 28 banks and its 9,000 employees. I'm also the former chair of the MBA's Collection Committee, and as an attorney, I've handled collections for over 30 years. Our association supports the concept of a homestead exemption to provide some protection from attachments and executions, but we feel the increased exemption levels proposed by LD 737 are excessive. We have to keep in mind that this bill, while protecting debtors, also impacts all creditors, including Maine citizens who have legitimate judgments for things such as personal injury claims or breach of contract claims. And if these exemptions are increased, it's going to make it exceedingly difficult for them to collect any money from the people who legitimately owe it to them. To talk about excessive, in 2007, when the exemption was established at $47,500, the median sold price of a home in Maine was $194,000. Last year, the median sold price was $256,000. That's a 32% increase. If you increase the exemption from $47,500 by 32%, it increases it to about $63,000 per person. The proposal increases the exemption 473%. We think that is too much. I also want to focus for a second on the provision in the bill regarding bank accounts. The bank account provision says that every single account is protected up to $5,000, every joint account up to $10,000. So if a debtor is allowed to protect that much money and they're creative enough, they can have multiple accounts with $5,000 or $10,000 in each one of those accounts at the same institution, and all of that cash is protected. These exemptions are designed to provide a safety net. They are not intended to allow people to shelter significant amounts of cash and other assets to the detriment of their legitimate creditors. I think those particular provisions are the ones that we, the Maine Bankers Association, are focusing on, and we feel at this point, the way it is drafted, we're encouraging you to vote ought not to pass. And I'm happy to answer any questions.
Thank you very much. Representative Evangelist, did you have a question?
Thank you, Madam Chair. And hi, it's Mr. Caney, right?
Correct.
Okay. Did I hear you right? You wanted the exemption on a house to be 67,000?
If you use the increase in the median sold price from 2007 until 2020, the increase over that time period was 32%. So if you apply 32% increase to the 47.5, it comes out to roughly $63,000 per person now. So for a couple, that would be $126,000. And again, remember, that's the equity over and above people's mortgages on their homes. Most people in Maine have a mortgage on their home. So that's a pretty significant pad over and above their mortgage debt.
Given the rise in home valuations, though, wouldn't the $67,000 figure pretty well guarantee that people are going to lose their home?
Well, that's an interesting question because I've been doing collections since 1985. I have never done a sheriff's sale. I have never enforced an execution on a property. That is a very expensive process. And the suggestion that a credit card company with a $10,000 judgment is going to spend the money to force the sale of a house really doesn't make any sense. The concern, I think, is that execution sits there for a period of time. And at some point in time, when that house gets sold, it's going to have to get paid off. And again, if the exemption goes up and there's between the mortgage and the equity, there isn't any value left, then they can petition to have that execution lien released from their property. And that happens frequently. So I think that, again, while prices have gone up, most people's mortgages have gone up with it, ergo the equity in these properties. Remember, most people borrow roughly 80% when they're purchasing a home. So the equity in most of these cases is not going to be in excess of $126,000.
Well, I mean, for someone that's owned a home for 15 or 20 years and then they get into financial trouble and then we've hit this boom, I think the equity would be a lot more than that. But, you know, Senator Carney raised an interesting point. Whatever we do with the limits on this bill, there has to be a recipe for success to allow people the ability to climb out of their problem. If they don't have a car to get to work with, if they don't have a reasonable residence to live in, the likelihood that debts are ever going to be recovered is zero. It's the same thing we run into with in this committee with driving offenses, where people lose their license for minor offenses and they're unable to pay fines, and they're unable to go to work and get a job because they're unable to pay stuff. So I see the vicious cycle continuing. What we want to do is create a recipe for success and allow people to service their debts. So I want you to think about that. I don't think that 67,000 limit is reasonable. It's kind of like saying the federal minimum wage has stayed at $7.50 forever, and we should raise it to $10. Well, you know, you can't pay for anything on $10 an hour. So I don't think your number's high enough, but just think about that, would you, please?
Oh, we certainly will. I think we're trying to balance that with the interest of the main judgment creditors who are trying to collect monies that are legitimately owed to them. And that's not necessarily us as bankers. We're talking about our customers who in times get into contract disputes or are injured in an accident, and they're trying to recover the funds that they're owed from a judgment.
Thank you.
Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Welcome, Mr. Caney. Appreciate you coming and giving your perspective on this bill today. And I'm trying to understand, you know, some people are saying the number's too low. Some people say the number's too high. Is it, and you indicate that the latter of that is true. Is it possible that when it was initially set, the percentage, maybe that percentage number was too low in proportion to looking at exemptions, and that when that was corrected, it skewed that percentage up to 400 something percent? Is that possible?
Well, it's certainly possible, but if you look at an increase of that magnitude per debtor, that is a colossal increase. And again, it's unclear to me whether this is 225 per household or 225 per person. Again, that's a drafting issue. If it's 225 per person, so you're talking about a $450,000 versus a $95,000 protection of the equity in your home. Again, we're talking equity in the home over and above the mortgage amount. That's a substantial increase over a 14-year period. While it may have been slightly artificially low in 2007, I can't tell you. I can tell you what the exemptions are now. For example, Connecticut is $75,000 per person. As an example, Massachusetts is not $500,000 as represented by prior testimony. It's $125 per person. We'd be $100,000 more than that, I believe. That's substantially more. New Hampshire is currently, forgive me, I've got the stats here, 100 per person. And Vermont is 125 per person. So we would be substantially higher than all of our neighbors in New England with this change.
May I ask a follow-up question, Madam Chair?
Yes, go ahead.
Where this bill doesn't have a proposed sunset and there's no variable amount that would automatically adjust it from year to year, is it possible that the trending, that higher number may account for down the road be more accurate, and that if we adjusted it to present figures, that 5 years from now, that number would be considered low?
Well, I think there is an adjustment provision in the amendments to 4422. If you look at section A1 sub 2, it talks about starting in January 1 of 2022, the value is going to be adjusted to reflect the median home price in the state. I don't know who's going to establish that. I don't know how we're going to know about it, but and the question is, why is it that number? Because 225 is certainly not the median home price right now. And so if it's going to go up to that amount, it's going to go adjust that amount annually. And again, who establishes that figure? We do not know. And again, you have to add to that 2% of their tax assessed value plus the amount of their taxes. All of that gets added on to this exemption. So this exemption is going to become a very large number very quickly and way larger than any of our neighbors.
Thank you. That helps. Thank you, Madam Chair.
Representative Libby, go ahead.
Thank you, Madam Chair. Thank you for being here, Mr. Keeney. My question is, if we were to make such a dramatic change to the numbers with this bill, do you anticipate that that would discourage some lenders from lending to folks with less than perfect credit in the future?
I don't think it's going to have a significant impact on residential lending because we're lending a percentage of the value of a home. Where it will have a significant impact is in commercial lending, because in commercial lending, typically we're lending to a business and the owners of that business are providing their personal guarantees. When we're looking at their personal guarantees, we're looking at their financial statement, which usually includes the value, the equity they have in their home. That's resources available to us if things go badly. If the equity in that home is no longer available for us to tap because they have a gigantic exemption over and above whatever mortgages they have on their house, then we're probably going to have to take a mortgage on their residence as additional security for that commercial loan. In doing that, we're going to have to do title work, appraisals, and have additional closing costs, which are just going to add to the how much it costs to get a commercial loan in Maine for a small business.
Thank you.
Committee members, any additional questions? I'm not seeing any. Thank you very much for being here and providing your testimony this morning.
Appreciate the opportunity.
Our final opponent testifying is Mr. Pino, and you can go ahead with your testimony, starting with your name and your town of residence, please.
Thank you, Senator Carney. My name is Ed Pino. I'm a resident of Vassalboro, and today I'm representing the Maine Credit Union League. And just an FYI, Senator Harney and committee members and Chairman Harnett, I just found out today what you meant by electronic hand wave. I have been waving through this entire session. I did not know that there was a little hand down there. So thank you for pointing that out. The Maine Credit Union League represents 54 state credit unions and has 725,000 members. I'm here to submit testimony in opposition to 737. Credit unions are cooperative, profit-sharing financial institutions which are owned by the members. The losses of a credit union directly affect those members and how we can handle accounts, mortgages, and loans for others. We are hesitant to take action, but we do have to at time, but we do everything we can before we get there. The dramatic increase proposed in the bill are actually why we're opposing it. It is obvious that with some of the vagueness in the way it's written and some of the questions that I think other opponents have brought up, I think rather than go through my written testimony, you can see why we have heartburn over the bill. Now, we always want to work with the committee. We want to work with the proponents of the bill. And if this was a regular session, I think what I'd see happen is the chairs would tell us to get out in the hall and see if we could figure something out prior to work session. So I'm hoping that's what's going to happen here. I think one of the things that you have to understand on this is when we write these loans, that exemption comes into part of our thinking in who we're going to be loaning to and the rates that we're going to be asking for those loans. So it's really important, I think, for the committee, if in fact you decide to go forward with this bill, to go forward with the full understanding of what the effect on this is going to have in loaning to either the small businesses, which credit unions do, or its members. And then with that, I can wrap up. I'll take any questions.
Thank you very much. And thanks. 2 hours into this bill hearing, we really appreciate you being so concise and efficient. Are there any questions, committee members? I am not seeing any. Thank you very much for providing your testimony today. And I'm glad you learned about the electronic raise hand.
It'll be handy when I get to, I think it's the Innovative Committee this afternoon or tomorrow. So I'll be able to wave.
Great, thank you. And
Thank
that,
you all.
that brings us to our neither for nor against speaker, and he is joining us momentarily.
Come on.
Oh,
there we go.
There we go. Welcome, Mr. Sherry, to the Judiciary Committee. And please introduce yourself and begin your testimony.
Thank you, Senator Carney. I'm Sam Sherry. I'm a resident of Cape Elizabeth, where I am a constituent of Senator Carney. I am an attorney. I've been in practice. I have a small country practice on Forest Ave in Portland, which I've been in practice since 1992 and in private practice since 1993. Over the years, I have represented debtors and creditors. In the bankruptcy realm, I've represented debtors and creditors and trustee in Chapter 7, Chapter 11, debtors, creditors, committees, Chapter 13, debtors and creditors. My practice now is focused on representing creditors, primarily landlords. I was asked to come this morning, and it's kind of too bad I'm last because, well, too bad for me anyway, because I wanted to turn back to where Representative Thorne pointed us earlier. What's an exemption? What are we talking about? How does it work? And I'll try and do that in 2 minutes and 14 seconds. My client is a contractor. They do some work on somebody's house. They don't get paid all their money. They send a letter. They still don't get paid. They send the sheriff and start a process through court, which is constitutionally sufficient. The word for that is due process, and gives the homeowner a chance to come and tell their story. Even so, in the middle of that, as people talk, as people mediate, as people discuss, they don't get paid. Ultimately, there's a process where the court enters judgment in favor of my client, the contractor, and against the homeowner. The judgment isn't money. The judgment says you can't argue anymore about whether you owe money or how much money you owe, but it's not money. At that point, the creditor is able to put an involuntary mortgage, a lien, on assets of the homeowner. Not all of the assets. Some of the assets are exempt. Some of the assets don't get subject to the lien. That's what we're talking about this morning. The equity that someone has in their house, the added value that they have in their car, the money that they have managed to save up, that's there, available to provide justice to people whom the courts have said are owed money beyond dispute. I'll stop there. If you have questions, let me know. And if not, I appreciate the chance to speak this morning.
Thank you very much, Mr. Sherry. And thanks for that very great explanation of what a lien is and why an exemption matters. Committee members, are there questions for Mr. Sherry? Go ahead, Representative Babbage.
Thank you, Madam Chair. Mr. Sherry, perhaps you can briefly clear up two questions for me. What is the mission of a Chapter 7 or Chapter 13 trustee? And the second question is, if I have a great amount of debt, and which I owe creditors in Massachusetts, but change my residence to Maine, what happens there in that legal sense? So those are my two questions. Thanks so much.
Thank you, Representative Babbage. I want to say first that I've been asked to stop singing by every band that has ever asked me to sing. So thank you for starting my morning with a better voice than mine. Chapter 7 trustee. The point of a Chapter 7 trustee is that people come into this process, this debt and creditor process, and they come because there's a problem. Somebody has more debt than they have assets to clear up their debt. The job of a Chapter 7 trustee is to look in detail into somebody's financial life, to gather up all their assets and immediately give back to them all the assets which are exempt from the reach of their creditors. In those relatively infrequent cases where there is something that's left, the Chapter 7 trustee liquidates non-exempt assets and applies those proceeds for the benefit of creditors in the way that the bankruptcy code tells him or her to do. Is that a fair answer?
Yes, thank you. So they're presiding over this process.
Presiding is a legal term I wouldn't use. There are bankruptcy judges, and we have great ones in Maine, and we have a history of great ones in Maine. But they administer the process, yes,
Okay.
that is the job.
Thank you.
With respect to foreign judgments, as the members of the committee know, there are a bunch of different legal systems in the United States. There's a federal system, which generally happens across the country. There are different systems in each of the respective states. So if someone gets a judgment on behalf of a supplier in Massachusetts, if they go to court in Massachusetts and they win in the state court, that judgment from Massachusetts doesn't automatically apply in Maine. The supplier, the creditor, has to go up to Maine and start a process to bring that foreign judgment into the courts of Maine and to use the collection and exemption processes which apply in Maine. Again, is that a fair answer for you?
I guess, thank you for that. And I don't want to prolong this, but I did want to ask if the consequences of this bill would encourage or discourage flight for relocation so that an initiated legal recourse would have to be started in Maine.
I think that's a great question. It's not something I'm any kind of expert in.
Okay.
But what I hear is that in states like Florida, that people do come to Florida because there's a gigantic exemption, because people want to plan or scheme. Not to tell the committee its job, but in the abstract, exemption planning is okay. Exemption scheming means you're getting not a fresh start, but a head start. And that is not okay. So if people see that by coming to Maine, they can open up $25,000 bank accounts and hold on to $100,000 worth of cash, yeah, they're going to move up here to do that.
All right, that's all I wanted. Thank you so much. Thank you, Madam Chair.
Thank you both. Committee members, are there any additional questions for Mr. Sherry? I am not seeing any. Once again, thanks for testifying before the committee today, Mr. Sherry.
It's my pleasure. Thank you for the chance to do it, and thank you all.
Okay, and now this is just a final check with the attendees. Is there anyone here today who wished to speak in any regard with respect to LD 737? If so, raise your electronic hand. Not seeing any, so with that, we'll close the public hearing on LD 737, and we will open the hearing on LD 767, an act to allow the participation of Marine Patrol officers in proceedings for administrative suspension of a license or certificate. And the bill sponsor is Representative McDonald. This is a bill that was submitted by the Department of Marine Resources. And let me just check the attendee space. Oh, I'm sorry. I was looking in the wrong spot. Representative Harnett, go ahead.
Thank you very much, Madam Chair. Representative McDonald from Stonington is unable to be here to introduce her bill. So I will be doing that for her and promising you that this will be a much shorter public hearing than the one that we just had. As you stated, this is an act to allow participation of Marine Patrol officers in proceedings for administrative suspension of a license or certificate that was submitted by Representative McDonald on behalf of the Department of Marine Resources. Since the bill has been submitted, they have determined that there are problems with the bill, and it is Representative McDonald's request that the committee kill the bill at this point. But she did want us to hear from Deirdre Gilbert from the Department of Marine Resources to briefly explain why that has become necessary. And I believe that Ms. Gilbert is in the attendee room.
Thank you very much, Representative Harnett. And she is making her way here and actually has just appeared on our screen. Welcome, Ms. Gilbert. You can introduce yourself and proceed, please.
Thank you very much. Good morning, Senator Carney, Representative Harnett, and members of the committee. My name is Deirdre Gilbert. I'm the Director of State Marine Policy at DMR, and I appreciate the opportunity just to offer a brief explanation on this topic. The Secretary of State's office administers administrative license suspension hearings for DMR. They've been doing that for about 10 years now. There are very limited instances, I would say, where the department felt it might be helpful for a Marine Patrol officer to be able to ask a question during an administrative hearing. There is a legal prohibition on them doing that because they are not attorneys, so that would represent the unauthorized practice of law. So what we were originally proposing to do was create another exemption in that section of statute that would allow them to ask those questions. We had understood originally from the Secretary of State's office that their concern was just over that legal matter. But when that was further discussed, we realized that it actually creates an administrative and managerial issue for that office because they administer hearings on behalf of several different entities, and it creates kind of a challenge for them if the playing field is different across agencies in terms of what people are allowed to do. They just had a concern that it would create procedural issues going forward. They did not object to the notion of doing this, but they did indicate that they would no longer be able to hold those hearings for the department if this were to change. That is certainly not desirable from our perspective. We very much value the work that they do, and we would much rather keep that relationship than make this change. So with that understanding, we were happy to withdraw our proposal. And I did want to just apologize for taking the committee's time on this matter, and that we weren't able to sort this out before it got to this stage.
Thank you very much, Ms. Gilbert, and thanks for giving us the explanation this morning. And so with that, I'll close the public hearing on 767 and ask if there is a motion to move into work session on this bill. Representative Evangelos,
I make a motion to move into work session.
is there a second? Lots of seconds of Representative Poirier's second. And we'll move into work session. And is there a motion on ought not to pass on LD 767? Representative Arnett?
I would make a motion ought not to pass on LD 767.
And seconded by Representative Evangelos, is that correct?
Yes.
Is the committee ready for the vote? Is there any discussion? Not seeing any. And Ms. Panett has appeared to take our vote. Thank you very much, Ms. Panett.
Very welcome, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 11 members voting in the affirmative, none in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. And with that, we'll conclude, the work session on LD 767. And committee members, I just want to get a sense if people would like a 5-minute break or whether we want to keep moving forward. If you want a 5-minute break, just wave your regular hand. Representative Reckett would like a 5-minute break. And actually, I would really very much like a 5-minute break as well. So if we can return at 11:23, that's 5 minutes. It's an odd number, but we'll be back very shortly.
Hey, Peggy or Soupy, are you on the call?
I'm here.
I stepped out to see my aide. What happened?
Oh, they're just taking a 5-minute break.
Okay.
You were here to vote on that bill.
Yes, that I
Yes,
just
okay.
stepped out.
Yeah, no, you're good.
Okay. Thank you.
Yes.
I'm here also.
How's it going, Chris?
I was muted. Sorry. Great, Jeff. How you been?
Good. Yeah. Hope we can pick the pace up here.
I got that message.
Hi, committee members. If you could please activate your camera so that we can resume. Representative Evangelos was just noting that we are 2 bills in and have 3 to go. And it is quite a bit into our morning work session. So, I mean, our morning schedule of public hearings. So let's begin with our next bill, which is LD number 853. And the bill sponsor is Representative Matlack, and I believe she is present. I'm going to move her over to the panel and open the public hearing on LD 853 and welcome our bill sponsor.
Good morning, Senator Carney.
Good morning, Representative Matlack. It's nice to see you. Welcome to the Judiciary Committee. You can begin your testimony whenever you're ready.
Thank you. Good morning, Senator Carney, Representative Harnett, and respected members of the Judiciary Committee. My name is Ann Matlack, and I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Creehaven, and the Muscle Ridge Islands, all communities located within Knox County. I'm here today to introduce LD 853, an act to increase the fees paid to sheriffs and their deputies for service of civil process documents at the request of my county sheriff. From time to time, county sheriffs are requested by the state of Maine to serve legal documents on residents of their communities. For this service, counties are compensated for their work. However, the current remuneration is based on fees originally put in place in 1981. These fees have not kept up with the costs of serving civil process papers, divorce papers, civil arrests and custody documents, summonses, etc. Currently, sheriffs and their deputies are paid $4 for some services, $8 for other services. Had these fees kept pace with inflation, sheriffs would be reimbursed $33.60 for documents for which they are currently paid $4. It is time to bring the fees paid to the various counties in line with the actual cost for performing this work. You will hear elsewhere how this increase in fees will adversely impact the budgets for various state agencies. I appreciate the burden this will place on the agencies doing good work around the state, but I ask you to recall that property taxpayers are currently paying for services requested by the state at grossly inadequate rates. This bill increases the fees paid to the sheriffs to a more appropriate amount and reimburses sheriffs for the actual costs to perform these services. Thank you for your time, and I would be happy to answer any questions.
Thank you very much for presenting your bill to us, Representative Matlack. And I see that Representative Evangelos has a question.
Yes, thank you, Madam Chair. How's it going, Ann?
Doing well. Jeff, how are you?
I'm doing good, thanks. Just a quick question. When these officers are engaging in this work, are they off duty? This is a separate piece of compensation.
I don't. I think that the sheriff that will come behind me will be able to adequately say that. I don't know that it's off duty. I know that there are some who are paid outside of normal hours. I also know that there are certain counties where there are specific people who who their remuneration is based just on the fees. So it varies with the different counties and how they decide to do the work.
Okay, thanks.
You're welcome.
Committee members, are there other questions for the bill sponsor? I am not seeing any, and it sounds like there are others here to testify on the bill. Representative Matlack, you can remain on the panel if you'd like during the bill hearing.
Thank you.
And I'm now turning to those in the attendee portion of the meeting and asking anybody who is an attendee who wishes to testify in support of LD 853 to please raise your electronic hand and keep it raised. And I see Sheriff Kevin Joyce. And Sheriff, I am going to bring you over to the panel. And while he's coming over, if there's anybody who wishes to testify in opposition to 853, you can raise your hand and keep it raised in the attendee space. Thank you. And Sheriff Joyce, welcome to the Judiciary Committee. We're happy to see you this morning. And if you could please introduce yourself and provide your testimony.
Thank you. Good morning, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee, also Representative Matlack. My name is Kevin Joyce, and I'm the Sheriff of Cumberland County. I'm here to testify on behalf of the Cumberland County Sheriff's Office and the Maine Sheriff's Association on this particular bill. The need for this bill passage cannot be disputed. The state of Maine has not changed the fee structure for civil service since 1984. I know of no other instance where costs have stagnated at 1984 levels in any public or private sector entity than for the service of civil paperwork. This has created a revenue issue that is causing funds that could be used for other law enforcement purposes such as training and community relations to instead be used as a supplemental service for civil process. While considering this matter, I would ask each committee member to reflect on his or her own lives, to imagine a world where you had to support yourself on the same amount of money you made in 1984. While I'm not an economist or a research analyst, it did not take me long to realize the gravity of the situation. I provided in my testimony real-life examples. The wages, 315% increase since 1984. First-class postage stamps, 175%. Loaf of bread, 220%. Gallon of milk, 192%. Gas, an increase of 100% as of today, but we know how volatile that commodity is. New car, 217%. The cost of health insurance has increased 740% since 1984. And speaking for my agency, civil deputies in 1984 were making $11.09 an hour. Today, they're making $20.98 an hour, which is an 89% increase. I know that there was some concern from state departments like DHHS. Currently, we charge them $8 an hour. They could serve their own paperwork. However, they've told us, at least at Cumberland County, that it's cheaper to have us serve them for them at $8 an hour. I mean, $8 a service. Of course, that makes sense. Earlier this year, the lab went up on the cost of doing drug identification and analysis on behalf of the sheriff's offices and law enforcement in general. So prices are going up. This has not gone up to keep up with the cost of us being able to serve paperwork, and it's really digging into our budgets. Currently, the way it's set up, civil process should pay for itself. The income or revenue generated should pay for itself. It's really eating into, I'll speak for my agency, into the property taxpayers picking up what doesn't get served or what we don't get for revenue during these services. So that's my testimony. I ask you to support LD 853, and I'll be happy to answer any questions.
Thank you very much, Sheriff Joyce. Committee members, are there questions? Go ahead, Representative Thorne.
Thank you, Madam Chair. Thank you, Sheriff Joyce, for providing testimony for us today so that we can clarify this. And on a personal note, my son-in-law is one of your deputies down in Gray.
Oh, nice. Who's that?
Deputy Chandler.
Great guy.
Yeah.
Great guy.
This seems like something that's long overdue. based on your testimony and based on the statistics you gave us of increases in other items, up until now, what have you been doing to offset these? Have these gone against your budget, annual budget, or where's the disparity come into play?
Yeah, what we end up doing is like for 2020, 2020 is actually a kind of a tough year to use because services were down, we weren't doing evictions and stuff like that. But the reality is any overages comes out of the general revenue budget for the county. The hope is when we build a budget, we assume we're going to generate the revenue and it's going to self-provide for itself. To answer one of the questions that was brought out, all 16 counties have differing ways that they deal with it. I can tell you I've got 3 full-timers with a 4th that I haven't been able to fill yet that go out and actually serve on a full-time basis. I've got some per diems that I've got the 4th position to kind of roll out because really for me, the per diems have been, kind of hires that were done before I became sheriff. And quite frankly, I want to kind of professionalize that a little bit. So, another sheriff's office is rolled it in and tried to use law enforcement. So they're doing law enforcement and serving civil paperwork. The things that come into play is unions as well. I can't use law enforcement deputies to do civil paperwork. It comes from a different union, et cetera. So I know I'm answering a couple of questions that were given out, but we just try to make it work. But unfortunately, it's getting passed along to the property taxpayers in a lot of cases.
Thank you. I appreciate that. Thank you, Madam Chair.
Committee members, any additional questions for Sheriff Joyce? I am not seeing any. Thank you very much for your testimony this morning, Sheriff Joyce. And I don't think we have anyone here to testify on further on 853, but I'll just do a final check in with those in the attendee space. Is there anybody, if you're in the attendee portion of the meeting and you wish to speak on 853, please raise your electronic hand. Not seeing any, so that concludes the public hearing on LD 853 and brings us to our next bill, which is LD 1160. And that is going to be introduced this morning by our committee member, our fellow committee member, Representative Harnett. And you can proceed when you are ready, Representative Harnett.
Thank you very much, Madam Chair. Senator Carney and colleagues on the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. I am here today to introduce LD 1160, an act to reduce the burden on courts and promote the resolution of civil cases, because it would expand access to justice in civil matters by promoting timely resolution and fair compensation, and lessen the burden on our judicial system. Plaintiffs in civil cases have often experienced serious harm for which they seek compensation and other relief, including economic loss, property damage for personal injuries that dramatically impact their lives. Delays in resolution of civil cases can compound and amplify the damage for the injured person. Oftentimes, they may take on debt to cover those costs and losses, and/or feel pressured to accept an unfair settlement offer just to receive some relief. And as we heard recently during Access to Justice Day from the judiciary and others working within the civil legal system, there is an incredible backlog in civil cases in our state. This may result in delays for cases to move through the overburdened court system. These delays are real and have only worsened during the pandemic. Further adding to the problem, insurance companies are incentivized to delay, not settle, because of some gaps in our law relating to interest and bad faith offers this bill seeks to address. LD 1160 seeks to make 3 changes to Maine law in order to relieve pressure on our overburdened courts and to ensure justice by supporting fair, timely resolution of civil matters. The bill does three things. First, it adjusts pre- and post-judgment interest on civil judgments to 12%. Under current Maine law, a plaintiff in a personal injury case is often not able to receive compensation until significant time has passed since the incident that injured them. Sections 1 and 2 of this bill will ensure that plaintiffs are justly compensated for these expenses paid in the interim by adjusting judgment and post-judgment interest to 12%. As I stated earlier, during the time the lawsuit is making its way through the courts, injured persons often have to cover expenses related to their losses with high interest loans or credit cards. For a complaint filed today, the prejudgment rate would be 3.09%, and the post-judgment rate still only 6.09%. Both figures are far below the rate one might face on a loan or a credit card, and far below what an insurance company may earn through investments on that money while the case is pending. The change proposed in LD 1160 reflects basic fairness and equitable compensation. By increasing pre- and post-judgment interest, we help relieve negative impacts on lengthy process delays and encourage the defendants and all parties to settle worthy claims. I will note that the rate being proposed is consistent with most of our neighbors in New England states, and that this requirement will only take effect when a case is resolved at trial. Secondly, this LD amends the law governing unfair claims settlement practices by allowing bad faith claims against a third-party liability insurer, directly incentivizing settlement of worthy claims. As defined by the American Association for Justice, bad faith insurance claims arise when an insurance company wrongfully refuses to pay a claim or refuses to fully pay what the insured is owed. For example, if there is a case with an estimated worth around $300,000 and an insurance company makes a lowball settlement offer of $50,000, the injured person is forced to choose between accepting a low offer or a bad faith offer, or going to court to compel the insurance company to at least make a reasonable offer, let alone resolve a case. That delay means injured people can wait years to get a payment. This bill would help curb unfair practices and support just outcomes by allowing the injured person to file a bad faith claim with the court. Making this recourse available, again, will incentivize reasonable settlement offers and will provide a tool and peace of mind for injured parties if an offer is made in bad faith. Insurers should not be allowed to violate the duty of good faith and fair dealing with injured policyholders, and allowing these claims will help ensure that insurers do not place their own interests instead of those of the injured insured. Finally, it amends the law to eliminate subrogation on awards or settlement damages not exceeding $20,000. Subrogation of such awards was the law in Maine for years before it was repealed under the prior administration. This bill seeks to reinstate the previous law for the simple reason that insurance carriers should not be allowed to demand payback for medical coverage paid toward an innocent person's care as required by the policy. That innocent person, harmed through no fault of their own, has paid premiums for an insurance plan that provides medical payments coverage for exactly these kinds of cases. They should therefore be entitled to full benefits of that coverage, and insurers should not be allowed to double charge by getting both the premiums and then a payback via settlement. The injured person gets harmed twice, every time they pay their insurance premium and through the loss of subrogation on the final settlement. Making this proposal even more reasonable, the prohibition against subrogation would apply only to settlements of less than $20,000. The changes in LD 1160 reflect good practice, and they make the system fairer for litigants when faced, as they often are, with huge court backlogs and lengthy delays for resolution. LD 1160 establishes policies that balance out an insurer's potential incentive to delay. It encourages settlement of meritorious cases, and it provides appropriate tools to compensate for lengthy waiting periods or situations of bad faith. I ask this committee to vote ought to pass, and while I invite questions on this bill, I firmly believe the committee will be better served holding those questions for the persons testifying after me, as they are far more well-versed in the details and the workings of this proposal. Thank you very much for your time and attention.
Thank you, Representative Harnett. Committee members, are there any questions for Representative Harnett? Not seeing any. So at this point, go ahead, Representative Reckitt.
I just have a question that I should know the answer to, and it either flown out of my head or it never got in there in the first place. Could you define subrogation for me?
I think I'm going to leave that to one of the private attorneys who's going to be testifying after me.
Right.
I should know the answer to that question as well.
All right, no problem.
All right, and so that's the perfect lead in. I'm looking to those who are in the attendee portion of the meeting. And actually, first I'll speak to everybody who is here to testify on 1160 today. We are running very late in our work this morning, and we have a number of work sessions that will start at 1 this afternoon. And so I'm going to strictly enforce the 3-minute limit on speakers, and would also ask that if any portion of your testimony repeats what has already been said, if you could actually even trim it back a little bit shorter than 3 minutes. I think every member of the committee would appreciate that very much. And so with that, I'll ask everyone who's here to speak in favor of LD 1160 to please raise your electronic hand and keep it raised, and I will bring people into the meeting. All right, it looks like we have 5 people here to testify in support of 1160. So I'll start by moving in Walter McKee. And welcome to the Judiciary Committee, Mr. McKee. Please introduce yourself and proceed.
Good morning, Senator Carney, Representative Harnett, and members of the committee. My name is Walt McKee. I reside in Hollowell, and I have a private law practice here in Augusta. I can see the State House right from where I'm sitting. Many of you know me from my testimony in criminal cases, but half of my practice actually involves representation of people who were injured through no fault of their own, and often in car accidents. Let me explain what subrogation is. Subrogation is the right for an insurance company, your insurance company, if you're the driver who was injured, to take back monies from a settlement of award to compensate them for what they paid out. Let me just give you an example I think that will illustrate this. Let's say you got into a car accident and you had $10,000 of medical bills, and your own insurance company, let's just say USAA, for example, mine, pays the medical bills up front. The case is ultimately settled for $12,000 and with the other party's insurance company. So the person struck me, my insurance company, USAA, paid the $10,000, and let's just say Liberty Mutual, just to use just a general name, paid $12,000 in the claim. USAA, my insurance company, would have the right, as it stands under Maine law right now, to take back their $10,000 from my settlement. I wasn't at fault. It wasn't anything I did. I had $10,000 in medical bills, but USAA, my insurance company, I've been paying premiums for 25 years, will take $10,000 out of that settlement. I'll be left with $2,000. That's the right of subrogation, the right to take that money back, even though I've been paying premiums. What this bill does is says, look, for cases under $20,000, that right of subrogation, that right for your own insurance company to take money from your settlement, even though, again, you paid your premiums for that medical payments coverage, That would be eliminated for these, what we will call smaller cases, those with settlements or awards of less than $20,000. My position on behalf of my clients is that this is not fair, and they should not, the insurance company, your own insurance company, should not be allowed the right to take that money from the settlement. So I'll take Senator Carney's advice. I'll call it a short here. I think the example is helpful and hopefully productive, and I'm happy to answer any questions and provide any details.
Thank you very much. Committee members, are there any questions for Mr. McKee? Go ahead, Senator Carney.
Thank you. Thank you, Mr. McKee, for being here. My question is kind of broad, but I wanted to get your response to it. In Maine, we've been losing insurers, and also we have some of the highest insurance rates in the country, from what I have, seen in reports. How do you think this bill will affect that, and especially in the area of subrogation? And then also, if you could speak to what other states do around subrogation, I would appreciate that as well.
Sure. I haven't seen any loss of actually insurance carriers in the last decade or so. What I see is the same number of carriers that are still writing policies in Maine, as well as new carriers that I'm actually surprised to see from time to time coming into Maine. So maybe there's a figure out there that there are a certain number of carriers before, and that's changed, but I haven't seen it. And I deal with insurance companies multiple times each day and every day. Certainly in the automobile insurance market, that's a wide open market. It's a national level. Most people are having policies through some of the major carriers, as well as some of the locals as well. So I haven't seen that. I'm happy to hear about that. In terms of the policy amounts or the policy premiums, I don't have any really comparison at all, whether that's high or low or where we are. I know what I pay. I don't want to pay any of it, but I do that, and I'm not certain that ours are any higher. In terms of whether other states eliminate subrogation, in some cases, I just don't know, but I'm definitely going to look into that and provide you the answer. Somebody can really quickly figure that out. It won't be me. I'll find somebody who has that information. I will definitely get it to the committee for the work session.
Thank you.
Sure.
Committee members, any additional questions for Mr. McKee? I'm not seeing any, so I'll move you back to the attendee space and invite Mr. Terrence Duddy to activate your camera and your audio and proceed. Mr. Duddy, are you able to activate your audio and video?
Yes, can you hear me now? Something has just happened to my home computer. Can you hear me, committee?
We can hear you, certainly.
I very much apologize on the loss of the video here. Good morning, Senator Carney and Representative Harnett. My name is Terrence Duddy. I'm an attorney of 40 years here in Maine, in the last 38 of which I've been with Kelly, Remmel, and Zimmerman in Portland. I'm a former president of the Maine Trial Lawyers. And during that 38 years with Kelly Remmel, most of that, 90% of that, has been dealing with the Maine state tort system. And several things I know are absolutely true. That the delay in the resolution of cases, either because the insurance company won't settle before attorneys are involved, or a delay caused after a case is filed, simply means that there are a series of people who are not receiving money from these claims that the public is simply not aware of. Not only is the claimant being denied fair compensation over a period of time, if a case is not settled promptly and fairly, or dealt with in litigation promptly and fairly, but any number of Maine programs, particularly Maine Care, are losing money because in a huge number of our cases, of my personal injury cases, MaineCare has initially footed the bill. At the end of these cases, MaineCare gets a reimbursement of some percentage. When I was president of the Maine Trial Lawyers, that reimbursement over a yearly basis was in the 7 figures. So that in the truest sense, Maine Trial Lawyers are the attorneys for the Department of Human Services and for MaineCare because we return money to them when we process these cases. The one point I want to leave the committee with is that anything that is a reasonable piece of legislation that is going to encourage prompt settlement of cases and the efficient litigation of cases is going to promote returning a large sum of money to programs that need the money here in Maine, primarily MaineCare. And this bill, which is a reasonable series of steps that promote early and efficient settlement, is common sense, that it would promote not only compensation to the injured person, but compensation back to the taxpayers of the state. And I'll rest it there and take any questions.
Thank you very much, Mr. Duddy. And committee members, I see that Attorney Moriarty, Representative Moriarty has a question. Go ahead. We're not able to hear you.
Right.
There
Good
you go.
morning, and thank you for coming, Mr. Duddy. You would agree, I assume, that in many civil cases, there are contested issues of fact and credibility and possibly comparative negligence and so forth. So that, would you not agree that the refusal to settle is not unjustifiable 100% of the time?
I agree, Representative Moriarty, with that 100%. What I think needs to be the takeaway here is that there is room for adversary dealings, and there clearly is in litigation. What this bill does in these three steps is ultimately encourage insurance companies to reduce the adversarial issues to the real issues and removes from businesses the motivation, perhaps, to use a claimant's life circumstances, perhaps the pandemic, their geographical circumstances, their health circumstances that have nothing to do with their claim, but make them vulnerable to being leveraged. And I think if we were able to accomplish that, it would leave plenty of room for the adversarial nature of some of these claims to be fairly undertaken without anyone worrying if there was really unfair leverage exercised against people who are not in as good a position against an insurance company.
I'll just follow up quickly. I understand your point, but I'm not sure how the bill deals with unfair leverage. Clearly, if a plaintiff prevails, that plaintiff is entitled to significant prejudgment interest and so forth. But there still may be cases which would have justified the decision to go to trial where facts are in dispute as opposed to settling.
Yes, I agree with you. The insurance companies understand, and their very capable defense counsel clearly understand what is a justifiable adversarial position versus what is not. There is a very famous or infamous, depending how you look at it, law court case. I think somebody else, one of the other speakers, can give you this site called the Linscott case, that in really bold language or harsh language, the law court says under the existing law of Maine, really you, the insurance company, can use any number of leverages against an innocent injured person. Those leverage pieces, those leverage points having nothing to do with the injury, but having everything to do with their life circumstances. An insurance company can figure out what is it in those circumstances that is not fair leverage and that would render them liable to a third-party action against them versus what are those facts clearly that need to be, that are fair to be disputed. The insurance companies and their very capable defense counsel know the difference. All this act does is make sure that there is somewhere down the line a remedy if someone goes over the line and doesn't want to recognize that there's a difference between those two poles.
Okay, and I'll do one more if I can. Despite the fact that the courts are largely closed to civil litigation currently, is there nevertheless mediation taking place?
There is mediation taking place. In my own view, it is inefficient, ineffective, as you will know from your own practice. First off, the mediations are being done by Zoom, which I don't think is optimum by any means. I'm both a mediator on Zoom and have mediated on Zoom. I don't think it's as effective. But secondly, mediations and that sort of thing taking place in the present atmosphere are not fair because they haven't, in those cases where the facts have really not yet, that need development because it is fairly adversarial, it's hard to get cases settled when those fact disputes can't be submitted and subjected to discovery. So some mediation is being successful in incredibly straightforward cases. The larger, more serious cases where, as you say, it's fair to have an adversarial approach to it, those cases are not, in my view, going to be successfully mediated because you just don't know enough about them. Yep. And given the present circumstances, it's going to be a long time before you do really know enough about them to be able to fairly mediate.
Okay, thanks very much.
Any other questions, committee?
Committee members, are there additional questions for Mr. Duddy? And I am not seeing any raised hands. Mr. Duddy, thank you very much for providing testimony before the committee this morning.
Thank you very much. Sorry I couldn't appear in person.
That's okay. Mr. Mitchell, you can activate your audio and video and proceed as soon as you're ready.
Thank you. Can you see me and hear me okay?
We can.
Great. Thank you, Senator Carney, Representative Harnett, and the other members of the committee for giving me this opportunity to speak on this bill. My name is Dan Mitchell. I'm a resident of Scarborough. I'm a litigation attorney at Bernstein Schurer in Portland, and I'm a past president of the Maine Trial Lawyers Association. The focus of my remarks are Section 3 of the bill, which would allow those bad faith claims to be brought by an insured person against the insurer for the party that caused the injury if that insurer engages in improper conduct. And so what I want to emphasize I'll be very brief. What I want to emphasize is that this protection already exists in the insurance code for first party claims. So in other words, if you're bringing a claim against your own insurer for bad faith conduct, that's already in the statute, been in the statute for a long time. That protection exists. This bill simply would extend that to people who are injured when the other side's insurance company mistreats them and giving them an opportunity in the same way a first party claimant could to counteract improper practices. What kind of practices are we talking about? The statute lays them out. There's 5 of them. And I think we could all agree that these are things that we want to discourage. Knowingly misrepresenting to an insured pertinent facts or policy provisions relating to coverage. Failing to acknowledge and review claims within a reasonable time. Threatening to appeal from an arbitration award in favor of an insured for the sole purpose of compelling the insured to accept a settlement less than the arbitration award. Failing to affirm or deny coverage within a reasonable time after having completed an investigation. And finally, the 5th one, without just cause, failing to effectuate prompt, fair, and equitable settlement of claims submitted in which liability has become reasonably clear. So this is already the law with respect to first party claims. And in that respect, This provision of the bill is not a radical departure from the law as it already exists. And I'll just say that in my practice, I represent both plaintiffs and defendants from time to time in a wide variety of cases. And I will tell you that most insurers do not operate in bad faith. This statute, with respect to first party claims, is not one that gets invoked frequently. It doesn't tie up the court systems, but it's there when it needs to be there. And that's why that statute exists. And this bill simply would ensure that injured people who are third party claimants enjoy the same protection when they're dealing with an insurance company for the person who caused their injury. So I appreciate the opportunity to make the remarks, and I'd be happy to take any questions.
Thank you very much, Mr. Mitchell. Committee members, are there any questions for Mr. Mitchell? I am not seeing any. We thank you for coming before the committee today.
Thanks.
And our next speaker is William Herbert. And Mr. Herbert, you can activate your camera and your audio and proceed.
All right, good morning. Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Will Herbert. I am an attorney with the law firm Hardy Wolf & Downing in Lewiston, Maine. And I'm here on behalf of the Maine Trial Lawyers Association in support of LD 1160, specifically Section 3, which is the section we just talked about, that part that would extend Maine's unfair claims settlement practices to third-party insurers. I think just to truncate what I was going to say, I think the most important thing to look at is these cases where there is no good faith dispute. And as Attorney Mitchell just said, in the vast majority of cases with the vast majority of insurance companies in Maine, we deal in good faith. And when there are disputes of a factual nature, we litigate those things in an adversarial sense and get to the bottom of them. But there are cases where there is no dispute. The ones that I'm talking about, and really the easiest ones to think about this in that context, are these very simple motor vehicle accidents with low damages where there's no liability. I have two examples that I want to share. And again, these are not representative of the insurance industry in Maine as a whole, but a very limited subset of insurance companies that have implemented a very specific but system-wide strategy of exploiting every possible advantage against every possible potential claimant, regardless of what the circumstances are, simply as a means to force them into submission. One case we have is a rear-end collision case. Somebody stopped at a red light, they're rear-ended, and suffer $4,300 in damages. It's a small claim. And the damages are essentially one visit to a doctor, an emergency room visit that day, and an ambulance that took them to the emergency room. The insurance company offers $1,500 to settle that claim with $4,300 in medical damages. Their answer, when asked, what is your justification here? You have no dispute as to any of these reasonable issues, liability, damages. The answer is, we ran it through our medical database, whatever that is, and the costs charged by the ambulance, the ER, and the primary care doctor were not, quote, customary and reasonable, whatever that means. Another case we have, $21,000 in medical bills arising from a case where a driver looked at their radio, crossed the center line, and hit our client head on. $21,000 in medical bills, almost all from the emergency room that night and the ambulance. The insurance company's initial offer is $16,000. No explanation, no reason, simply an ultimatum. Submit and accept what is fundamentally and obviously unfair under Maine law or fight. Before 2020, that option was a false option for many people for the reasons we've talked about already today. Court delays for people who owe bills.
Mr. Herbert, your 3 minutes is up. Thank you very much. Committee members, are there any questions for Mr. Herbert? I am not seeing any. Thank you for appearing before the committee this afternoon now.
Thank you very much.
And our next speaker is Laurie Boxer-Maycomer, and you can activate your audio and video and proceed.
Wonderful. Thank you very much. Good afternoon, everyone. I am here as a trial attorney at the law firm of Kelly, Rummel and Zimmerman, and also on behalf of the Maine Trial Lawyers Association. I've submitted to the committee a pretty extensive letter outlining why this legislation is needed, listing a number of problems that we're facing in the court, including a backlog of slightly over over 27,000 pending criminal cases and over 13,000 civil cases, and an overview of what's going on with Maine people during both the pandemic and during delays that were already in place before the pandemic. I want to underscore, without repeating some of the things that you may have started to hear from others. One is the fact that the people most harmed by delays or behavior that may not be reasonable by insurance companies are some of Maine's most vulnerable people. We're talking about people that are English as a second language learners, people who are elderly, people who are low income. And those people, sometimes what sometimes occurs is that they're dealing with insurance companies independently, and they may not really need an attorney if they have a smaller case. But often they're treated in a way where the values of their cases that are put on their cases by the insurance companies are so low that they feel forced to file suit or seek the assistance of an attorney. And so in my testimony, my written testimony, I elaborate on details that are occurring in those situations. Another thing that's really important to understand is that with respect to the prejudgment interest, is people are incurring many out-of-pocket costs, whether they're well-heeled people like attorneys and doctors who are injured, or whether they're low-income people during the pendency of their personal injury case. And a lot of them can't control the fact that they've suffered a head injury, or that they're losing a limb, or that they are gonna face some type of long-term catastrophic problem with their body or life because of a crash. And in the interim, they're paying huge deductibles. They're unable, lower income people are unable to meet, their rent payments or their childcare payments because of harm caused by other people. And so when we look at solutions like a higher prejudgment interest, we're looking at how do we make a person whole when it may take 4 or 5 years for their case to move through a legal system, and what are all the things that they're putting on a credit card that maybe they're paying a high interest rate at in order to survive, and what are all the costs, financial costs to them over time versus those that may be holding money. And so that is what this legislation is designed to address. It's designed to encourage.
Thank you very much for your testimony today. And I'll just turn to the committee members and see if there's any questions. Committee members, any questions for Ms. Boxer-Maycomer? Not seeing any. Thanks very much for appearing before us this afternoon.
Thank you.
And now I'll turn to those who are in the attendee portion of the meeting. Is there anybody else here who wished to speak in support of 1160? I think I brought in everybody to the panel who wanted to speak. That
Yes,
yes.
Madam Chair, Dave Flores, Attorney Dave Flores.
I brought you into the panel and then I forgot that I had done so. Go ahead. You can activate your audio and video and speak. Thank you.
For some reason, my video's not activating. At least it's not showing. And so if I could just speak without the video.
Okay. Yeah, you can go ahead and speak.
Okay, I see it now. I see it just gave me the prompt to activate. Yeah,
great.
Good morning, Madam Senator Carney and Representative Harnett and committee members. I'm David Flores. I'm a practicing attorney with the largest share of my work being in the Boston area. However, I do live here in South Berwick, Maine, and I'm very familiar with this amendment and with this act to reduce the burden on courts. We have a similar law in the Commonwealth. In there, we have what's 93A that's also that gets combined with 176D. 176D is the portion of the consumer protection law that lays out and outlines what bad faith is by the insurance companies. What usually happens in that sense is we have the same thing as up to triple damages and attorney fees awardable in a bad faith dealing. What that does is it encourages the insurance company, since they got this 12%, max we have 12% plus triple damages, possible triple damages, and attorney fees. What it does to the insurance company, if they feel that they've done no investigation and they see that their insured is liable, but in the other attorney's scenario was $20,000 in bills, it's okay. Well, if we go to trial, maybe the most we'll pay is $20,000 and maybe a little bit of pain and suffering. So why settle now? Maybe we'll get lucky and the insurance company come out with $10,000 as opposed to that. Why don't we roll the dice? That is bad faith dealing. So what it does is it exposes that insurance company that if they do act in bad faith, not only are they going to have to pay the judgment, but a possibility of triple damages and the attorney fees. As you folks may know, here in the judicial system is you got the American rule where each side pays for its own attorney fees unless there's a statutory right. This would create a statutory right for the attorney fees. And as the first speaker spoke, this is something that is not new to me. It's already provided that protection for the insured. However, the most aggrieved party is the person that got hurt in that personal injury. This gives them a right to sue if they have to litigate. What's all the thing that's very important here is if you look at the dynamics in that, is the present law only lets the insured sue his own insurance company. That is somewhat problematic because these insurance contracts state that the insured cannot compromise the defense of the insurance company, which means they're both trying to prevent from paying. Because if the insured says, I want to pay, it's my fault, they're not allowed to do that. So automatically they're in an adversary situation, and the person's injured must come forward and bring a complaint against them. So the other thing is, what's happened is when I have served them with the notice of claim under this act, it actually gets settlement negotiations going and does reduce the burden on the court. I'm willing to take any answers the committee may have for me.
Thank you very much, Mr. Flores. Committee members, are there any questions? Not seeing any. Thanks for appearing before the Judiciary Committee today.
Thank you, Madam Chair.
And with that, I believe that we have heard from anybody who wished to speak in support of LD 1160. And so now, would anybody who wishes to speak in opposition to LD 1160, please raise your electronic hand and keep it raised until after you've provided your testimony. And I'll start moving people in, beginning with Daniel Bernier. Whoops. I think I inadvertently admitted Rory Whelan first. So Mr. Whelan, you have joined our panel. Why don't you activate your audio and video, introduce yourself and begin your testimony, please.
Good afternoon. I'm Rory Whelan. I'm the Regional Vice President for the National Association of Mutual Insurance Companies. I'm based in Saratoga Springs, New York. I will be brief. I have submitted written comments. NAMIC is strongly opposed to this legislation. And while I would agree, and it is obvious that there is a tremendous backlog in cases in Maine, I would posit that this proposed solution would simply make the problem worse. And I would ask you to consider this. What we have not heard yet is what is the increase in the prejudgment interest rate. Under this proposal, it is 350%. That provides an incentive for the plaintiff to hold off on settlement. What other investment today can you earn 12%? It is a fantastically high rate. And I would say that if this legislation were enacted, policymakers will be tilting the scales of justice to encourage and reward some plaintiffs for sitting on their claim until the end of the statute of limitations so they can run up the damages. In essence, it creates an investment opportunity for some. Likewise, individuals that can't afford that, who need to settle very quickly, you now create an inequitable structure for claim settlement and award. There are others who will speak to other facets, other provisions of the bill. But I would conclude by reminding the committee members that if this 12% interest goes through, that will be paid out by small businesses who are still reeling from the effects of COVID-19, as well as individuals, because they'll be saddled with higher insurance and litigation costs, because increased damage payments are insurance rate cost drivers that adversely impact affordability of insurance for all consumers. I would be happy to take other questions. And as I said, I'm sure other speakers will speak to other parts of the bill. I don't want to be redundant.
Thank you very much, Mr. Wellen. Committee members, are there any questions? Not seeing any. We'll proceed to our next opponent, Daniel Bernier. Mr. Bernier, you can proceed.
Good afternoon. My name is Dan Bernier. I'm a resident of Waterville, Maine, and I represent the Maine Insurance Agents Association. I'm particularly concerned here in my testimony on Section 3 of the bill, which would extend Maine's Unfair Claims Settlement Practices Act to third-party claimants. Maine has a very strong Unfair Claims Settlement Practices Act that protects the insured who actually is paying the premium to the insurance company. This would now extend that protection to the person who's suing the insured. You all have insurance companies, and they have a contractual obligation if you're getting sued to look out for you, not the person who is suing you. And this would change that obligation to that they now have to look out for the person who's suing you. This has very real ramifications. Take an example where you have a $300,000 limit on your insurance policy. If the insurance company settles that case for $400,000, that means you're pulling $100,000 out of your pocket and the insurance company is paying $300,000. One of the obligations insurance defense lawyers have is to try to get cases settled within the policy limits so you as the consumer don't have to pay any money. You can also, in directors and officers cases, errors and omissions cases, commercial general liability cases, have reputation issues and things that the insurance company needs to be looking out for. Extending the insurance company's duties to look out for the person who's suing their insured represents a major change in public policy here in the state of Maine. We've always held that insurance companies need to look out for their insured, not the person who's suing them. I will also touch upon Section 1 dealing with prejudgment interest of 12%. That does strike me as a punitive interest rate. And remember, in lots of cases, the issue is not whether money is owed, it's how much money is owed. And I think of a case when I was a young associate for an insurance defense lawyer, where the plaintiff's lawyer wanted $150,000 in settlement. The insurance company was offering $50,000 in settlement, and the jury awarded $11,000. I will always remember the face on the plaintiff's lawyer when the jury came in with their award. The insurance company was very justified in taking that case to trial because the amount of money being demanded by the plaintiff's lawyer was unreasonable. To tack a 12% punitive interest rate on just because people are exercising their right to a trial where there can be legitimate disputes. And like I say, many of them, the insurance defense lawyer that I was the associate for tended to stipulate to liability a lot and just argue over the damages, and often enjoyed a lot of success in getting the amount of damages he was seeking. So to penalize them for simply saying that the plaintiff's lawyers are asking for too much money would really seem to be unfair. I have a little bit of an issue of Section 2 dealing with post-judgment interest. The big thing there is that post-judgment interest applies during appeal. And that's, I think, my bigger issue with that. And I will close with 2 seconds left.
Thank you very much, Mr. Bernier. Committee members, are there any questions for Mr. Bernier? Not seeing any. Hold on a second, Senator Keim, go ahead.
Sorry, I was listening and I wasn't fast on my hand there. Yeah, I guess I just was hoping you would finish your remarks on the other section, Section 2 that you were.
Well, I actually did. I was hurrying it there, but I pretty much was able to finish, post-judgment interest, because you have a judgment now. So a little bit of a punitive interest rate may be justified to get people to pay their judgment. My concern is, what if somebody's exercising their legitimate right to an appeal? I mean, another case that I could mention when I was a young associate was when a partner in the firm I was with lost a $24 million case, but on appeal, the law court reduced the damage award to $500,000. They had a legitimate reason for that appeal, and I don't think a 12% interest rate is warranted when you have a legitimate appeal going on. When the case is totally final, people should pay their judgments. I tend to somewhat agree with that notion. So there's a distinction between pre-judgment interest while you're exercising your right to a trial versus post-judgment interest. The case is final and it's now been determined you owe some money.
That was helpful. Thank you.
Yeah, thank you for that clarification as well. Committee members, any additional questions for Mr. Bernier? Not seeing any. Our next opponent is Bruce Garrity. And Mr. Garrity, you can activate your audio and video and proceed, please.
Can you hear me?
We can hear you.
Well, I don't quite know how I'm not. Oh, there we go.
Oh, good.
Thank you, Senator. Senator Carney, Representative Harnett, members of the committee. My name is Bruce Garrity. I'm from Manchester, Maine, and I'm here today on behalf of the American Property Casualty Insurance Association, which writes the majority of insurance here in Maine. Let me start with some statistics I think are important, and much of this is in my written testimony. Maine is 50th in the country. We have the lowest insurance rates in the nation. New York proposed legislation such as is before you, and actuaries determined that would increase rates between 4.3 and 6.9 billion dollars, or between 9 to 15%. New Jersey considered the bill. That would have resulted, or legislation on bad faith, that would have resulted in a 13% increase. Florida, which has a law like this, has had its rates increase 21% overall, 14.5% on homeowners insurance, 17.4% on auto insurance. West Virginia had a bad faith law, did a major study through its Commissioner of Insurance, determined it was bad public policy and repealed it. California had a bad faith statute and then repealed it. One of the things I have not heard, and I'm very surprised at this, Maine has a statute that deals with third-party problems. It is Section 2164D, and it is part of Maine's Unfair Trade Practices Act within the insurance code. And what it precludes an insurance company from doing to a third party. An insurer cannot knowingly misrepresent relevant facts or policy provisions, cannot fail to acknowledge written communications promptly. It cannot fail to adopt and implement reasonable standards for prompt investigation and settlement. It cannot fail to develop and maintain files that the Bureau of Insurance can review. It cannot fail to affirm or deny coverage within a reasonable time after an investigation. It cannot fail, if it does not offer a settlement, to promptly provide an accurate reason as to why. These are all rights that exist today, and the superintendent of insurance can either suspend or revoke an insurance company's authorization to do business in Maine. Why none of the plaintiffs' attorneys mentioned this or have used this, I really can't say. Those are very, very strong protections. Let me say, in addition, briefly, what's the purpose of a treble damages provision? It has only one purpose, and that I see my time is coming to an end, and rather than get halfway down the road of treble damages, let me close with one quick comment. There's a very famous comic strip or comic in the New Yorker big table book that we all, at least I have on my desk. There's a client sitting in front of a lawyer's desk, and the lawyer is sitting there, and the client says, "So if I sue for $1 million, can I get 1,000?" There are people who take aggressive stances on both sides of this of any litigation, and to suggest that
Mr. Garrity, we're holding everybody to a tight 3 minutes, and we
fair enough. Thank you, Senator. I appreciate the time, and I'd be happy to answer any questions.
Senator Kime, go ahead with your question.
Thank you. Thank you for being here, Mr. Garrity. Nice to see you.
Oh, nice to see you.
I was wondering, it was good to hear all of the increase in the cost of insurance. Wondering though, do all sections of the bill equally, in your opinion, will equally increase the premiums on insurance?
No, I think that the most significant increase will come from the bad faith treble damages provision. That clearly is something that not only can be extremely expensive, but that's where you're forcing the insurance company to give up representing the rights of its insured and instead try to protect its own hide by trying to get out of a case rather than pay treble damages. I think that's the biggest hit in this bill.
Okay, thank you.
Any other questions for Mr. Garrity? Not seeing any. Thank you very much for appearing before the committee today. And Mr. Sultan, you can activate your audio and video and begin whenever you're ready.
Thank you, Senator Carney, Representative Harnett, and members of the committee. And a special shout out to Representative Poirier. We haven't met yet, but I just want to let you know that 40 years ago, I got to spend 4 years teaching high school in Skowhegan and have wonderful memories of Skowhegan. So hello.
Good to see you. Thank you.
Thank you. Members of the committee, you have before you a bill that really has 3 different issues in it, as we have talked about today. Each one of them could be an easy half day or more public hearing. And you've heard many factors about it. I'd like to put a little sharper point on a few comments. One, it has been expressed that the subrogation provision was in effect for years before it was repealed in 2012. That is just not the case. This particular section that is offered was only law for 3 years. It wasn't implemented until 2009 before it was repealed. In that time, and how this subrogation works is really, we are simply asking for the party who was at fault to pay for those medical damages. So what MedPay does is it gives you, as the injured party, the right to get immediately from your own insurance company coverage for some of your medical bills, up to whatever level you have. And then the insurance company who is acting on your behalf will go after the tortfeasor to try and recover those costs. Now the tort or the trial bar tried to say that you paid for that and you should get to keep it. We argue that you shouldn't get a double recovery for those costs. And if you do get a double recovery, like the bill suggests, we have to then raise your rates. So we actually keep MedPay coverage costs very low because of subrogation, and only really the tortfeasor has to pay the person at fault. I can give you some numbers that we gave to an earlier committee back in 2012. For example, in 2008, before the subrogation change happened, one of my members, and I'm sorry, I did not say I was from Winthrop. I represent the Maine Association of Insurance Companies, and that's bad on me. We are the domestic property and casualty carriers, one of whom is Medical Mutual, who you will hear shortly. I also represent, in this case, the Maine Association of Osteopathic Physicians, as well as the Maine Society of Anesthesiologists, because as Mr. Garrity said and Mr. Bernier said, this impacts all insurance that deals with injury. So businesses, physicians, health professionals, and everybody else. I'll submit more written testimony. There's a ton there. Please review it all. It's a ton. It's an important issue. And thanks. Sorry for.
Thank you, and thank you so much for fitting in your name, and your organization, your residence before I forgot to ask you to do it.
You think after 33 years, I would remember to do that automatically.
That's okay. Committee members, any questions for Mr. Sultan? Not seeing any. Thank you for joining us.
Thanks for the
today.
time. Yeah.
And Tim Schott, you can activate your audio and video and proceed, please. Start with introducing yourself.
Sure. Good afternoon. Can you hear me okay?
Mm-hmm.
Great. Good afternoon, Senator Carney, Representative Harnett, and members of the committee. I am Deputy Superintendent of Insurance Tim Schott. I'm an attorney licensed in the states of Maine and Iowa. I think I'm the only one who's in those two states, but I could be wrong. I'm also a resident of the town of Bodenham, and I'm here to testify in opposition to LD 1160. I'm going to give an abridged version of my testimony. Basically, traditionally, insurers' primary obligation is to protect and defend their policyholders, and our claims practices laws give them the flexibility to defend claims in a reasonable manner without fearing a suit from a third party. LD 1160 could change that dynamic and force insurers to manage claims in a way as to protect themselves against a direct civil action from non-policy holders. LD 1160 would also allow courts to award triple damages against insurers that commit prohibited claims practices. This provision may come at the expense of policyholders generally if insurers pass costs onto their insureds to increase premiums. Maine currently has one of the most affordable auto insurance markets in the country, and we are concerned about the possibility for increased premiums for Maine drivers. I'd also mention that we're one of the lower states for homeowners insurance, so that same concern would apply to homeowners policies. We're also concerned that failure to allow for subrogation may result in cost shifting and increased premiums because insurers are not able to recover costs from the responsible party. Thank you for allowing me to testify, and I would be happy to try to answer any questions now or at the work session.
Thank you very much. You came in at exactly half the allotted time, for which we are all really appreciative.
You're welcome.
And also you're very clear and concise, so thank you for that. Committee members, are there any questions for Mr. Schott? Not seeing any, and we would appreciate you being available for the work session.
I will be.
Thank you. Next we have James Poliquin to testify. Mr. Poliquin, if you can activate your audio and video.
I think I succeeded in doing that.
You have. Welcome
Thank you.
to the Judiciary Committee.
Good afternoon, Senator Carney, Representative Harnett, and members of the committee.
I think you've frozen.
My name is James Poliquin. I live in Cumberland for 40 years. I have been involved in hundreds of cases involving Section 2436A since its enactment in 1987. And I filed written testimony in opposition to the changes to that section, as well as to the changes in 2910A. I think one of the most important issues here is whether it's valid to proceed under some sort of assumption that's unsubstantiated, that there are more cases forced into litigation, so to speak, by unreasonable offers than by unreasonable demands. There's no evidence.
Mr. Poliquin, your audio and video are both cutting out. Could you try deactivating your video and see if we can get clear audio? Because nobody can hear, is that correct? Okay. Let's put Mr. Poliquin on hold for a moment and ask Mr. Herzer if he can activate and commence his testimony.
Good afternoon.
Welcome, Mr. Herzer. We appreciate you being here and jumping in. Go ahead.
Yes, I appreciate the opportunity. Senator Carney, Representative Harnett, and members of the committee. My name is Dave Herzer. I'm a resident of Cape Elizabeth, and I am the incoming Vice President of Claims for Medical Mutual Insurance Company of Maine. My prior career was 28 years as an insurance defense attorney dealing with insureds and insurers in litigation.
So I have two unique perspectives, or two good perspectives on these topics. People have made good points so far. I'm not going to reiterate those. I do want to recommend to you two compelling reads on the third-party liability provision. There's a lot of good written materials. Here are two that I really recommend to you. I provided in my package something Mr. Garrity referenced, which was the California's reversal of its bad faith law. And there's a case involving Fireman's Fund in my written materials, where the California Supreme Court, known for its consumer protective inclinations, I think it's fair to say, actually reversed itself, decided that a decision it made to allow third-party claims directly against insurers was a bad idea 9 years after it adopted that position. And it went through all the litany of reasons why it was a bad idea, and was, I would venture to say, a borderline apologetic for having allowed those claims to begin with, given all the problems California experienced over 9 years. That's a very good read, so I really recommend that to you. The other really good read is something Mr. Garrity also referenced briefly. The Office of Insurance, the Insurance Commissioner of West Virginia, did a study on West Virginia's statute allowing third-party claims against insurers, and really did a nice job of walking through all the problematic aspects of that law. And what they did differently that the California court did not touch on, and the reason I included the West Virginia study is because West Virginia got into the specifics of the economics and the measurable economics and the impact on premiums, on the value of claims being paid, and on the impact on the availability of insurance as well. So really good reads on third-party liability. I want to switch now to the interest rate provision that I also oppose. And I just want to rebut a couple of things that I've heard, and my written materials will handle the substance otherwise. Today, earlier this morning, I heard somebody say, or somebody's say, that insurers have this purpose of delaying, and that the only way we can motivate them to act quicker on claims and settle them is if you hit them in their pocketbook with a high interest rate. Well, the biggest hit on our pocketbooks as insurers is, as you might expect, defense costs, paying attorneys hourly rates, paying expert witnesses hourly rates, paying for depositions. That is a motivation in itself, without any added exorbitant interest, to resolve claims reasonably. And finally, I've never in my—
Mr. Herzer, I'm sorry, we just, to be fair to everybody, we're holding everybody to 3 minutes.
I understand. Thank you for the opportunity.
Thank you. Committee members, are there any questions for Mr. Herzer? I am not seeing any. Thank you so much for being testifying before the committee this afternoon.
Thank you.
And Mr. Poliquin has rejoined us, and please, okay, we're going to try. If we lose, if you're having connectivity problems, just turn off your video, because sometimes the audio continues to work effectively.
Okay, I'll give that a try. You can hear me now?
Yes, go ahead.
Okay, so I'm not sure where I got lost in the process, but as to 2436A, excuse me?
You were talking about the that it's not valid to assume unreasonable offers rather than demands are the problem. I think that's where you left off, or where we lost you anyway.
Okay, thank you. And so basically, the last time, the last reason to enact legislation of this magnitude is based on merely a hunch as to what the real source of that problem is. If there's some question about it, it ought to actually be looked into, and I think people would be surprised as to what really causes cases not to settle before going into litigation. With respect to 2436A, it does create for the first time a direct duty to the very person that is suing their insured. That's not a tweak to a statute. It's a wholesale alteration. It's essentially destructive of the existing and critical duty insurers owe to their insureds. As the saying goes, it can be difficult to serve two masters. It's impossible if those masters are litigation adversaries and your duties pertain to the very handling of that litigation. It just cannot be done. As a citizen and a consumer of insurance, if I am sued, it's unacceptable to me that I cannot defend myself as aggressively as I could, as the rules and the laws and the procedures apply, simply because I purchased insurance. The defense now has to be different. It has to have its hands tied behind its back just because you have insurance. And that really is, to me, it's unacceptable to not just, it would be unacceptable to almost anybody who finds themselves sued and they don't consider the claim meritorious. Turning to the treble damage provision, I'm not aware of any evidence or analysis that the existing penalties in 2436A have failed their purpose. It's an 18% interest rate right now, 1.5%. Someone who establishes a breach of that section has all consequential damages that have been caused, full attorney's fees. There is zero evidence the existence of that statute hasn't served its purpose. If it wasn't effectively preventing, in large respect, improper conduct, you would see all sorts of judgments against insurers, finding them liable under that statute. Thank you.
Thank you very much. And thanks for rejoining us. I know that that's tricky and difficult sometimes. Committee members, are there questions for Mr. Poliquin? Not seeing any. Thank you very much.
Thank you.
And I think our final opponent is Vivian McHale. Is that how you say your last name?
Yes, Senator, you got that exactly right. Thank you so much. It is a pleasure to be before you, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. I know you have had a very long day into afternoon, and I've been preceded by some very able speakers on this topic, so I will keep my comments brief. Again, my name is Vivian McHale. I live in Topsom, Maine, right on the shores of the mighty Androscoggin, and I'm here today representing State Farm Mutual Insurance Company. State Farm is opposed to LD 1160, and I just want to bring a few pieces of information to your attention as you consider these really complicated issues. First, I did want to reiterate that State Farm is the second largest auto insurer in Maine, and it does in fact have the lowest auto rates in the country. The issue of subrogation is particularly interesting here. As you have heard, it has sort of a checkered history and has created some real controversy. It's important to note that for a company like State Farm that does hold such a large part of the auto insurance market in Maine, most of their MedPay claims hover at about $15,000. So by capping subrogation at $20,000, you're effectively eliminating the right of subrogation for an insurer with the bill the way it's written. And the important piece of this is that a successful subrogation results overall in a benefit to policyholders, because it is not every case where a recovery is accomplished by an insurance company. There are plenty of cases where there are unrecovered costs, and that is how insurance works, that the risk has to be shared amongst all insureds to keep our insurance rates at the low rate that Maine is known for. So in effect, our Maine consumers will feel that pinch if insurance rates have to go up to make up for cases that can't be subrogated, as they have been for so many years. The treble damages provision is incredibly troubling, as you've heard. Not only do we fear that it will encourage cases to be possibly drawn out because of that extra recovery, but it could compel the settlement of cases that shouldn't be settled. While the bill has, of course, very worthwhile and reasonable goals in unburdening our court system, State Farm believes that it simply imposes a far too great of a reach and is going to have effects that may be contrary to, and in fact, even worse than what's intended by the bill in terms of the effect on the system. With respect to the duties that have been created for third parties on the part of an insurer, we note that it appears that simply negligence would be enough, and I will stop there. Senator Carney, thank you very much.
Thank you very much. Committee members, any questions? Representative Evangelos, go ahead.
Thank you, Senator Carney. Hello, Ms. McHale. Nice to see you again.
Nice to see you, Representative. Thank you.
You made a statement that State Farm has the lowest premiums in the state of Maine.
The auto insurance has auto
Ms.
in the
McHale,
country.
we're
If I
having a hard time hearing you. Could you please deactivate your video and try answering the question again?
Is that working better? Are you able to hear me?
We are now. Not now, though.
Can you deactivate your video? If you can hear us, turn off your video and then try speaking again. Sometimes that helps.
I believe I'm back. Are you able to hear me at this point?
Yes, go ahead with your answer, please.
I apologize sincerely. All these Zooms, it's the first time that has happened. Thank you for the question, Representative Avalos. What I intended to state, and I apologize if I misstated, is that State Farm is the second largest provider of auto insurance in Maine, and across the country, it has the lowest auto rates.
Okay.
Does that answer your question?
It does, but I know for a fact they don't have the lowest auto rates in Maine, so you might want to check that.
I'd be happy to follow up on that. Thank you, Representative.
Just to let you know, I personally, they've sent me quotes before, and they've been 200% higher than what the Vermont Mutual provides to people. So, just
fair enough. If I stated otherwise, that was not my intent. I can cite you a study that does support the statement that I made that it has the lowest rates in the country.
Thank you.
Thank you.
Committee members, any additional questions? Not seeing any. Ms. McHale, thank you very much for joining us this afternoon. And then I just want to check those who are in the attendee portion of the meeting. If you are here to speak with regard to LD 1160, please raise your electronic hand. And I'm not seeing any, so that will close our public hearing on LD 1160. And we will open our next public hearing, and I'm going to turn the virtual gavel over to Representative Harnett, since this is a bill that I'm actually introducing.
Thank you very much, Madam Chair. Our next public hearing will be on LD 1236. An act authorizing the Attorney General to enter into contingent fee agreements. And at this point, I would recognize the bill's sponsor, Senator Carney.
Thank you very much. Good morning, good afternoon, actually, Chair Harnett and esteemed members of the Judiciary Committee. As you know, I'm Ann Carney, representing Senate District 29, South Portland, Cape Elizabeth, and part of Scarborough. It's an honor to be before you today to present LD 1236, an act to authorize the Attorney General to enter into contingent fee agreements. This is a bill that has been submitted by the Department of the Attorney General. LD 1236 would give the Attorney General the authority to employ private counsel on a contingent fee basis to bring claims for civil damages on behalf of the state. It amends 5 MRSA Section 131 by adding a paragraph that allows the Attorney General to deduct from the damages recovered by private counsel on behalf of the state the amount that's due under the terms of a contingent fee agreement. The Attorney General is here to provide additional information about the bill. Thanks for considering your consideration today, and I will defer questions to the Attorney General.
Thank you very much, Senator Carney, and I would now ask Attorney General Aaron Fry to provide testimony.
I've just invited him to the panel, so he'll be with us momentarily.
Thank you. He is in. So Attorney General, whenever you're ready, if you could unmute your microphone and activate your video. and just begin your testimony when you're comfortable.
Yes, thank you very much. I hope you can all hear me. Good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Aaron Fry. I have the privilege of serving as Maine's Attorney General, and I reside in Bangor. I'm here today to ask for your support of LD 1236. And I want to express my appreciation to Senator Carney for her sponsorship of this bill so that I could talk with you about this today. For those of you that don't know, a contingency fee agreement is a form of billing under which, instead of charging an hourly rate, which is a typical practice with attorneys, the attorney is paid a portion of the amount that is recovered on behalf of a client. These agreements are important tools for recovering amounts owed to the state in other circumstances. Now, contingency fee agreements would prove valuable for my office. We need to retain attorneys that have highly specialized legal and technical expertise in order to assist in our asserting claims on behalf of the state. The key examples would be with respect to environmental or natural resource damages. These claims can be extremely time-consuming to litigate. Success is uncertain. So contingency fee agreements would not only significantly mitigate the financial risks if the state does not prevail. It also allows the office to expand its capacity without having to come to the legislature to ask for more full-time attorneys. The existing law that was referenced by Senator Carney, 5 MRS 131, it broadly addresses departmental collections, and collections by the state are supposed to be paid to the state treasury, quote, without any deductions on account of salaries, fees, costs, charges, expenses, refunds, claims, or demands of any descriptions whatsoever, close quote. So this general provision does not appear to have been drafted with contingency fee agreements in mind. And it's inconsistent with such arrangements because it appears to prohibit the state's recovery to be deducted and paid out. That's a necessary part of a contingency fee agreement. So absent clear authorization, it would hinder my office's ability to pursue important actions that are in the public interest to recover resources for the state. So I am respectfully requesting this committee to support this bill and vote out to pass. Happy to answer any questions and would certainly be available for the work session to bring back anything I can't answer today. Thank you for your attention.
Thank you very much, Attorney General Fry. I will now ask if there are questions from committee members for the Attorney General, and I will begin with Representative Evangelos.
Hey, Mr. Attorney General, how are you today?
Good to see you.
Just a quick question. What's the rate that you pay the outside counsels an hour?
So to the extent that the office does employ outside counsel on an hourly basis for the cases might be if, for example, the Department of Insurance needs a specialized attorney to provide advice. You could be looking at several hundred, depending on the level of expertise, 500, 600, 700. There has been outside counsel relating to very intricate main care regulation advice that we employ through a national firm that approaches $700, $800 for that advice. So for the hourly costs, it can be very expensive. And of course, with the hourly costs, that doesn't take into consideration the success or failure of the legal activity. That's paid out regardless of what the result is of the attorney that's providing the outside counsel services.
Okay. I remember in your annual report to the judiciary last year, there was an estimation of $300 an hour. So will this result in a fiscal note?
It should not. Again, the purpose of doing the contingency fee agreements is to enable to bring in this expertise with an arrangement where if there's success, then a portion of that success would be paid out. If there's no success, then there wouldn't be any compensation.
Okay, so this is just on contingent type cases then where they have to produce a victory to get paid?
Yes, that's right. That would be the arrangement.
Just, I don't know if you want to answer this one, but I'm sure you're aware we're in a tussle to get Maine Commission of Indigent Legal Services funded. You know, I want to support your efforts here, but given that we're really struggling on that, would you be willing to weigh in to help us support, get the pay raised for the lawyers that are only making $60 an hour?
So I'm certainly willing to work with the committee to move any issue forward that I can be supportive of. Happy to talk with the representative offline about how I might be able to be helpful in those efforts.
I'm only raising it because as Attorney General, you know, one of the first duties is to ensure the Constitution is being enforced. And, you know, if we're in violation of the Sixth Amendment and we're paying these private lawyers
I'd like to raise a point of order.
I'll finish in a second.
As the bill sponsor, we really are supposed to be hearing, doing a public hearing on this particular bill. And I would just ask that we stick to this bill, please.
Well, I'm trying to, but I'm raising the point that if the Attorney General's office is advocating for this kind of compensation for private counsel to assist them, and I get it, I'm wondering under his constitutional responsibilities whether he's willing to weigh in and help us on that other problem. That's all. Thank you.
And Representative Evangelos, I think you've posed your question. The bill is about entering into contingency fee arrangements, not the payment of an hourly rate. So I would now turn to Senator Keim.
Thank you. Nice to see you, Attorney General.
Good to see you, Senator.
So I have a few questions. One is are the attorneys working in your office part of a union?
They are not.
Okay. And I was wondering also, so this is a significant change in the way the state would be doing business with outside lawyers. And I'm wondering what specific examples like you could give me that this would apply to, where you would, you know, just a real life scenario where you would hire somebody to do this. And then I guess whether or not you see it saving the state money or not overall.
Certainly. So I want to start with the recognition that this is not about creating claims that the state could not already bring. You know, this is about activity that my office could engage in now. We just don't have the resources, both in terms of attorneys and expertise, to really make that the best use of resources. In terms of an example, maybe the best example is I've been paying close attention to what is going on with the PFAS contamination, right? The environmental contamination that's come from you know, firefighting foam is maybe the best way to describe it. I know there was a study that was done, I believe, that involved legislature, administration, you know, other advocates that wanted my office to look at litigating. Other states have begun that process of litigating. We don't have the expertise in the office to be successful at doing that on our own. From a resource perspective, I can't hire people at an hourly rate in the budget that I have. So the contingency fee agreement would allow for me to bring on the talent, and of course, it's not the attorneys also bring with them skills that they're obtaining from other actions that they're doing for other states, as well as you know, having that developed experience of litigating cases like this. So you know, that's the example. That's how it might work. And in terms of the cost to the cost, and I'm hoping I'm answering that third part of your question when I respond with this. So to the extent that there are resources out there that the state is not able to get. So if the state was able to get a judgment relating to PFAS, that would allow for that contamination to be cleaned up, or for, you know, property owners to be taken care of for the damage. If we don't have the people to pursue those claims that the state's able to pursue, that's money that's left on the table, right? Like that's a resource that's left on the table because we just don't have the capacity. do it. So having the ability to do contingency fee agreements, not only expands our ability to do what what in some cases we're being asked to do, but it it also ensures that we're not spending a lot of money, taking a lot of risk that we have to spend a lot of money to get that back. Is that responsive to the three-part question that you had?
Yes, it is. But so then this would, in essence, allow the state to not need to weigh whether or not they have the funds to start paying a lawyer to take on a case. They can simply say, well, if this looks good enough and a lawyer is willing to do it, then they can take it on. Then the state would be able to take it on with this arrangement, as opposed to having to pay up front.
That's right, and without having to increase our headcount, right? The legislatively authorized headcount to bring in new attorneys and new staff to pursue the case. We could, that would be what the private attorney would do. I would add, though, that present staff would still be supervising the work. It's still important that that we ensure that any work that's being done to represent the state is being done consistent with what's in the state interests. So while we would benefit from bringing in private counsel to be pursuing our claim, we would still be supervising that to make sure that they were acting in the state's best interest in that representation. But that wouldn't cost anything more in the office.
So overall, would you say if this bill passed that the state would be increasing its amount of litigation?
There would be the potential for an increase, but I don't know that it would be significant. I mean, I could count on one hand cases in which we would take a look at. But the last time that I can think of that there was a case in which outside counsel were brought on to pursue a state claim was the tobacco litigation, which was back in 1998, 1999 is when outside counsel brought on. So this is not something that, at least with what's been presented to me, we have a huge. It's going to involve 5, 6, 10 cases. This is more that we've identified 2 cases where we just. It's important that we protect interests of the state, particularly around natural resources, but we just don't have the expertise to do it. And having the option of the contingency fee would be useful. But I can't, based on what I've received, or, based on the position that I'm in, I can't say it's going to be a lot of litigation. That's not, I can't foresee that.
Thank you.
Thank you, Senator Keim. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Attorney General Frey. My question is in reference to the tobacco case, just as a concrete example. If in hindsight, if this had been applied in that case and those attorneys had been paid on contingency, would you anticipate that the state's net would have been more or less?
Well, with the tobacco settlement, what ended up happening, the best we could sort of trace back, what ended up happening is that the legislature ended up passing legislation that determined what the compensation for the attorneys were going to be. So there had been a contingency fee. When those resources came in, the legislature was involved in deciding how those resources were going to be directed and provided for what the compensation would be. To say if it would be more or less, I don't, because there wasn't clear what, we could not find in our records what exactly that arrangement was prior to the litigation. I'm sorry, prior to the legislation that passed that set the fees. But regardless, the fees that were paid out, the only way the money came in is because you had the attorneys there to make sure that the settlement occurred and Maine got the most resources that it could get through that process. If you didn't have the council doing the work, it's entirely probable that less or none of the money would have come in, because the state may not have been able to do this on its own. So I don't know that it's not a succinct answer. I certainly don't mean to be sort of confusing with my answer, only to say that it's hard to compare it to tobacco because the legislature did get involved on setting those rates. And it's not clear what the state would have brought in if it didn't have the outside counsel to begin with.
Right. So thank you for filling me in with the legislative piece, because clearly with that, it wasn't a straight up hourly rate that was then paid these attorneys versus if it had been a contingency. Okay. Thank you.
Right.
Thank you, Representative Libby. Are there other questions from committee members? Seeing none, I want to thank the Attorney General for educating us on this bill today, and look forward to seeing you at the work session.
Thank you for your time.
And with that, I will now turn to the attendee room, and I do see a hand up. I'm not sure what it is for, but I'm going to ask if there is anybody who wants to testify in support of this bill. And I'm assuming, since Mr. Schott's hand is still up, that he does want to testify in support. So if he could be moved into a panelist position. And Mr. Schott, as soon as your mic is unmuted and your video is activated, you can begin your testimony. But before you begin, I do need to alert the committee. At some point, I might be called away to present in front of another committee, and I will have to give up my hosting chair responsibilities, and I am going to ask Representative Moriarty, who is still present. If I need to leave, Representative Moriarty, could you continue calling on those in favor, those opposed? And then
Yes, I could.
the for nor against, and close the hearing at the appropriate time. I'll stay as long as I can then. Thank you. Mr. Schott?
Thank you, Representative. My name is Tim Schott. I'm the Deputy Superintendent of the Bureau of Insurance. I live in Bodenham, and I did not submit written testimony, but I just thought I briefly would let the committee know that our department has used, through the Attorney General's office, some collection efforts that utilize contingency fees. So it can be very helpful for us if we submit, if we fine an out-of-state insurer, for example, or somebody operating illegally, in order to collect on that, really the only way to do that is through a contingency fee agreement with an out-of-state attorney. So it has been a useful tool for us for consumer protection, and I just wanted to add that. So thank you.
Thank you very much, Mr. Schott, for sharing that with us today. Are there any questions from committee members for Deputy Superintendent Schott? Seeing none, again, thank you very much for sticking with us throughout the day and presenting that insight. Are there any other persons in the attendee room who wish to testify in support of this LD 1236? If so, please raise your electronic hand. Seeing none, I would ask if there are any persons in attendance who would like to testify in opposition to LD 1236 to raise their electronic hand. And seeing none, I will finally ask if there are any members in attendance, persons in attendance who would like to testify neither for nor against LD 1236. Please indicate by raising your electronic hand. And seeing none, having heard all testimony from those persons present regarding LD 1236, I now declare the public hearing on LD 1236 to be closed. And at this point, I will turn throw the virtual gavel through cyberspace back to Senator Carney.
Thank you. I caught it. So at this point, our morning public hearings have gone over by an hour and 10 minutes, and we do need to take a lunch break and perhaps a break for some caucusing. So what I would like to suggest to committee members and to members of the public who are here for the work sessions this afternoon, we apologize for the delay, but we're going to take a break until 2 o'clock simply because we all need to be able to reorient and get ourselves ready for this afternoon's work. So thank you very much. And so we'll be on a recess until 2 o'clock. And I would just ask everybody to be back very promptly, maybe a couple of minutes before 2, so that we can start up right away. Thanks, everyone.
Okay, thanks.
Hey, Jim.
Good afternoon.
I decided I needed some coffee.
Yeah,
It's been a long one already.
I just hope my golfing days are as good as my committee days. Oh, wait, no, it's supposed to snow.
Yeah, tomorrow may not be a good one, but the weekend, I don't know.
Yeah. Peggy? Is Peggy in a earshot?
I don't see her on the screen. Did you see there was no heat at the State House?
No.
I got an email from the executive director. They've had a heating system failure. Hope to get it working by tomorrow.
Yeah, that's not good.
No. No.
I had low pressure in my my cold water feed in my washer room. That been years and years causing problems, and finally called a plumber in yesterday. He fixed it. Opens up a whole new world.
Yes.
The rinse cycle will never be the same.
It's a reminder of how dependent we are.
Oh, it's the little things, you know.
Yeah.
And he did such a good job. I've asked him to come back and look at 2 more little things. You know, it's a rare thing when you get someone that comes in, treats you fair and good and does good work.
Yes.
You know,
And
it's
and
kinda like,
promptly too. Yeah.
yeah.
Yeah, I'd get on top of those other little things before they become big things.
I was just curious, just in case anybody knew when the public hearing on 803 was. That's just kind of a general question, if anybody knows.
Mike, hang on a sec. I do. April 6th.
Thank you.
Yep, sure.
think Lois is trying to reconnect.
Okay.
I also had to reconnect and had some difficulty, but I don't have Lois's excuse.
All right, did that seem like a super short lunch break to everybody?
It really did.
We started 2 minutes ago.
Yeah. All right, well, I think we need a couple more people before we can get going here. Actually, we do have a quorum, so
Yep.
let's begin. If Peggy and Sam, are you two all set to begin? Sam's good, thank you.
Hi.
Peggy, nice to see your smiling faces.
Sorry, I was on the phone.
No, we were all saying that 40-minute lunch break seemed like it only lasted 2 minutes.
Yes. Right. So I don't know which bill you want to take up first. Is Representative Babbage in the picture? Yeah.
I is.
Yeah,
What do you mean?
let's start with 719, please.
Oh, no. If we were going to do
Oh, okay.
The language reviews. Thank you.
Okay.
Thank you.
Let me just make an announcement so people know where we are and what we're doing. We're going to start with language reviews on 2 bills, and then we'll move on to our work sessions. And
Thank
with
you.
that, Peggy, you're take it away.
Okay, well, I'm going to ask you to review LD 222 first. That is the an act to update the Maine Parentage Act. I can share that on my screen if you want. It's a majority report. I sent it yesterday, and I think you've gotten it multiple times, and I'm sorry I have filled your inbox. Do you want to look at it? I just want to make sure that you have a chance anytime an amendment is ready to report out. That is what you want. And if anybody needs to make changes or wants to ask the committee to reconsider, that you have that opportunity.
Thank you. Yeah, and we did get it from you yesterday, and it was really great to have it so far in advance. Thank you.
Okay.
And I know I'll just speak for myself that I read through it really carefully and compared it to the work we did, and I think that you got the majority report exactly right. And I would just ask other people who were on the majority vote if they're okay with it as well.
Yes.
I am.
Great. Thank you very much. We'll have this reported out soon, I hope.
Thank you.
Actually, I think there's a process to get jacket signed, and I'm so glad I'm not involved in that. Okay, Sam's on the spot now. Thank you very much.
I have LD 159, and if you'll recall, this was an act to eliminate time limits for placing land in trust status under the Maine Indian Claims Settlement. There was two amendments, the majority and the minority. Both of them, I emailed them last week. Peggy emailed them again yesterday. The majority, nobody had expressed any changes to that. That was, it does one thing. It removes the timeframes for acquisition of land under the settlement. So it's just a strike of all those dates. Pretty straightforward. The minority was a little more complicated. This was Representative Babbage's minority report. So the minority, and I might pull this one up if that's okay, just because it might be easier to look at it because we've got some green lettering in it. So I'm gonna share this here. I have too many screens up. Make sure I share the right one here. So the minority report does a couple things. It adds this new category of land called designated area for land acquisition, which is a defined area of land, and it establishes that within the chapter itself. The change that Representative Babbage had requested is a pretty small one here. It adds a clarification that it is watersheds located within the state of Maine. So instead of rivers, sorry, I should have crossed out that whole thing there. It is watersheds. So it establishes this designated area for land acquisition, which is then referred to in a couple different sections here. Originally, as was discussed at the work session, I think the intent was to also remove the dates for land acquisition. I think upon further reflection, Representative Babbage requested that be changed to add a date certain of December 31st, 2040, by which time the secretary, and by secretary, we actually mean the Secretary of the Interior, would need to have acquired that land and certified it for trust status. So what I did go through is I did go through and mark up all those areas where that date is referenced and replace it with December 31st, 2040. And I apologize for doing it in writing form. It's hard when we have the Ross version to retranslate that into an amendment form. So this seems a little easier to follow to do it this way. So that change was made throughout. I think those are the only changes to the minority report. That was here.
Thank you, Sam. May I say something, Madam Chair, just very briefly?
Please do.
Yeah, I just wanted the committee to know that what I have done in the minority report is to acknowledge all purchases that have already been made in the land settlement, and for unpurchased land to restrict it to a designated area for land acquisition, which more closely resembles the land claimed by the tribes in the land settlement, which is primarily the Penobscot River Basin and all points north and east, which would include the St. John and St. Croix watersheds. But and so it does exclude the Kennebec River water basin, or other than what's incidentally within the designated area, which, you know, when you talk about watersheds, sometimes the line is like fingers interlocking. And so I merely looked at where they had claims of land and made sure that those that were near these boundaries were inside, and made them clear latitude and longitude lines for ease of identification. So that is parts 1, 2, and 3. I did decide, I think it was Representative Newell that moved to get rid of the, I think it was Representative Woods, wasn't it? Original end date of, I think it was January 31st, 2030. And I was initially supportive of that. But, you know, tribal sovereignty has been an ongoing discussion, and as it becomes recognized, which I think it will, if not soon, then later, I think having an open-ended date for which any Maine land could be purchased and therefore removed from jurisdiction is not a process or an open-ended thing that I think should be part of any treaty. And basically the Settlement Act has been referred by the tribal leaders as a treaty, and that's so I'm giving it a generation. the end of the decade technically is December 31st, 2020, 2030, 2040. And so that's why I figured in 20 years or 19 years, whatever that is, would be a date certain. And then I did one thing that is an expansion of tribal acquisition, and that is in part section 4.2a. I said, for the purposes of acquisition of the 150,000 acres by each tribe, if they're not meeting that threshold through the agreements of the Settlement Act specifically as specified, then they may do so. They may do so through acquisition of contiguous lands to their existing tribal plot. So and that I figured should be done within the next decade. So, but that is an expansion of the ability to try to meet the original agreement of the Settlement Act for each tribe to have 150,000 acres. So that's my minority report, and I appreciate the patience of Mr. Seneft in getting this done the way I would like. And so thank you so much, Sam. Thank you, Madam Chair.
You're welcome. Thank you, Representative Babbage. So Representative Babbage, the language is you're all set with the language in your report?
I am, as recently amended. Yes, thank you.
Great. All right. And thank you. Sam, do you need anything else from us?
Nope, I'll get this processed as fast as possible and so it can be reported out.
Thank you. Representative Newell?
Madam Chair, if I may.
Yes.
Can I just ask for clarification on what Representative Babbage is suggesting? Representative Wood initially submitted the bill to extend the time limits to, I think it was 2030, and then which followed, prior bill submittals during the 129th and 128th, which led to us learning that those extensions have been presented before this committee with other issues, relative considerations 18 times. So then I proposed an amendment to alleviate the tribes from having to come back to the committee to continue to ask for these timelines to be extended. So then the minority report being submitted by Representative Babbage is going beyond what would have been initially submitted by Representative Wood, extending the deadlines to 2040 rather than 2030.
Yes.
Correct?
Yes.
Whereas mine was to eliminate the timeline. Okay, so then you mentioned and you did some language revisions around the watersheds. You mentioned that you excluded the Kennebec River watershed. Where is that reflected in?
It in the very first section 1.
Oh, so there was no changes made to that, Representative?
No changes.
Okay.
No, I was explaining the minority report, not just the changes, Representative Newell. I was just trying to understand, I gave the basics of what the minority report and how it was different, that's all.
Okay, and so if I may, Madam Chair, another question. There was a line out, section B, line 27, line 28, approximately, of the word any. It says, and any 100 acres in Calais, mutually agreed upon.
Right.
I believe that's already been, I believe that's already been purchased.
Oh.
So I don't believe there would be any need to make any changes to that language.
Well, I will say that I have gone over each one of these properties in the, not that one, but each one of the properties that are identified in the original paragraphs of the Settlement Act. And I know that there have been purchases, but those purchases, I can't tell if it is the full ability of the tribe to make that purchase, or they've only purchased part of the township and would have additional ability to purchase more of it in the references that were there. So I did not distinguish between already purchased lands and lands to be purchased in future. And of course, if they're already purchased, they're grandfathered before this anyway. But when it said any, actually, I was thinking that the any 100 acres in Calais might say that, I mean, that is so specific that it sounds to me like you can't purchase 99, you can't purchase 101, you must purchase 100. So I didn't like that wording, so I wanted it to be up to 100 acres, and I preferred the contiguous part of 100 acres rather than have it checkerboard all over Calais. So that was the change in that was a change that I asked them to make since the
Yeah, I think Representative, I think if we would review the legislative history around the number of times that I had mentioned prior that the tribes have come before this committee, I believe there was something contained within there that reflected Calais acreage.
Yes, yeah.
And if it needed to be verified, we could probably verify it.
That's fine. But as far as any future purchases, it would be according to this language. This is a minority report. So that's what my report is. Thanks.
Madam Chair. This is a language review, correct?
Yes, it's a language review, but this particular language review is only for the minority report for which Representative Babbage is the only person who voted for it. And so the majority report, which involves striking the time limits in their entirety, is also, Sam, maybe you can put that one up on screen share.
Right.
Madam Chair, might I ask what the process is for the motion to reconsider?
Hang on a second, and let's just look at the majority report first.
What section would you like to see?
Just if you can just take it through and describe to us the changes that were made that constitute the majority report.
Okay, so the majority report, that all it is going through and striking out any time limit for the purchase of land by the tribes. So every time a date certain appeared, it is struck so that it leaves it with no timeline. So you can see throughout, and there's dates. The dates are all over the place. Some of them are, they're all different times here. 1991, 2021. So all of them are gone, and that is the only change in this amendment in the majority report. And then, I should actually have noted the fiscal note. There is a fiscal note, but it's a fiscal note that costs can be absorbed. Sorry, I should have mentioned that.
Thank you, Sam. And Sam, can you remind us of the vote on the majority report? And I'm sorry to ask you, but my head is swimming a little bit.
I'm trying to remember how many people voted in the majority. I can't recall offhand, unfortunately. I'm not sure what the final was, if there were late votes.
I have it recorded. Ought to pass as amended, 10 in favor, 1 opposed, 2 absent.
I'm just not sure if there are any absent votes afterwards.
So, yeah, so Representative Newell, this report that simply strikes the timeframes, this is the report of at least 10, if not more, members of the committee. And the other report, that's Representative Babbage's, he's the only one on that report, but because it's his report, I'm not sure that it's appropriate for us to reconsider his report. Our disagreement with that is noted by our vote for the majority report. Does that make sense to you in that context?
Yes.
Okay, thanks.
A motion, if I may, Madam Chair, a motion to reconsider is in order if somebody wanted to change their vote from one report to another, but that would be the only relevant thing. Thank you.
Okay. And you're not, Representative Newell, you're satisfied with the remaining on the majority report? Okay. Does anybody else wish to reconsider? Not seeing any hands. So I think that concludes, I hope that I'm right about this, Sam, that concludes the language review on 159.
Yes, and I should just also mention the minority fiscal note is the same cost absorbed, and I should have mentioned that the first time. But I will go ahead and run these back through Ross, and hopefully we can report them out shortly.
Thank you. Thank you. And Representative Moriarty, I'm really impressed that you were able to put your hands right on the vote on 159 so quickly. That helped move us forward. Thank you.
See, that is the advantage of being largely paper-based. I didn't have to scroll or go searching. It was right in front of me.
Thank you very much. All right, everyone, thank you. And I think at this point, we will shift gears a little bit and we'll start our work sessions for this afternoon. And the first bill that we're going to have a work session on is LD 719. And this is the resolve to establish a commission to create a plan to incorporate the probate courts into the judicial branch. And Peggy, I know you've done an analysis. I think between your excellent analysis and all of the other work that we did on this issue in a lot of different permutations in the probate related bills, that I think that the committee might be ready to move on to a vote. And I'll just check with those who are present. Is the committee ready to vote on LD 719? I'd entertain a motion. Representative Moriarty?
Yes, Madam Chair, I move ought to pass.
And Representative Babbage?
I second that motion.
Is there any discussion on the motion? Not seeing anybody. I think we're ready for the vote. Ms. Panett?
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
No.
Senator Kime votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Representative Thorne, did you vote yet on 719?
Nay.
Representative Thorne. Representative Thorne votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Khan voted, I apologize. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. I have 5 members voting in the affirmative, 4 members voting in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And the report of Senator Keim from those who voted no?
Ought not to pass.
Thank you. Thank you, everyone. That concludes our work session on LD 719. And now we'll move on to open the work session on LD 947. And on this one, Peggy, we would really appreciate hearing your analysis, maybe a sort of a top level, and then we can let you know where we'd like to do a deeper dive.
Sure. Okay. Thank you. The bill adds in an opportunity for the court to award as a reason for giving reimbursement, requiring the payment of reimbursement support in spousal support, the fact that there was economic abuse by a spouse, and it cross-references the definition of economic abuse in the protection from abuse statutes. So the 3 sections, that's really what it's basically saying is in a divorce, or also judicial separation, which means you're splitting, but not the total legal separation of a divorce, a legal breaking of the legal relationship of a divorce, that spousal support can be awarded. And there's different categories of support that the court looks at, and there are kind of statutory standards for each type of spousal support. Reimbursement support is not awarded very often. It's really extraordinary circumstances. And so I think at least one of the parties would have to show that there was economic abuse involved. And that would allow the court to award reimbursement support, which would be actual payments from the obligated spouse to the recipient. And it would be, and then the recipient can use that to cover whatever those debts or the economic situation, to address the economic situation that he or she is in because of the economic abuse. That's probably more than you wanted, but I'm happy. I know Pine Tree Legal Assistance had prepared some information, and I did put it in the portal, and I think some of you had received it by email as well.
Thank you, Peggy. I think that was just the right amount of information. And now I'll just turn to committee members and ask for any questions of Peggy. Go ahead, Senator Keim.
Thank you, Madam Chair. Peggy, could you explain, just practically speaking, how this works differently than the economic abuse that we put in statute that's part of like domestic violence? How this will be different, putting it in like the divorce statute?
So my understanding is that, I mean, you have to have a protection from abuse action in order to get a protection from abuse order that includes some kind of recognition of the economic abuse that took place, and what the court can order for in that protection from abuse order. And I'm actually looking for the exact thing that the court can order. So the economic abuse order, I'm sorry, the protection from abuse order can, it gives the court the authority to order payment of monetary relief to the payment for losses suffered as a result of the defendant's conduct. So it might be able to cover this, the same thing. You're still talking about economic abuse. You're defining it the same way. But I'm not sure if how long-term the order would apply for economic abuse. What the value of that order could be. In the protection from abuse statute, it allows the court to actually set a hearing so they can figure out what that amount should be and how it should be paid. It also says that because you have an economic abuse monetary relief order, it doesn't eliminate or exhaust any other available relief that the court could order. So you could actually have both if the court felt it was equitable. If anything that the plaintiff in the protection from abuse case hadn't kind of been made whole through the protection from abuse order, and there is a divorce action going on, that whatever that difference is, that could still be available under spousal support. And usually you kind of think of spousal support as ongoing for a certain amount of time, but it wouldn't have to be, I guess. So I think there's definitely some overlap. You're using the same definition, but you're using two different types of proceedings. And I'm not sure that you can actually get a protection from abuse order only if there's economic abuse. I think there has to be some other kind of abuse that happened, and the economic abuse was in addition to the stalking, the physical abuse for a protection from abuse order.
So then the court is already making a finding of economic abuse in the context of the protection from abuse order. Is that right?
Title 19A, Section 4007 in the Protection from Abuse statute allows the court to enter a finding of economic abuse. So if the court makes that finding, part of the relief can be awarding monetary relief or ordering the payment of monetary relief. So I believe, and you probably have lots of people in the attendee room, but I believe that the court would have to make the finding of economic abuse in order to order payment of monetary relief in response to the economic abuse. And I think in a spousal support case, if the court is going to award reimbursement support based on the economic abuse, then I think the court would have to identify, I don't know if they call it a finding in spousal support cases, but I think that the court would have to point to the economic abuse, say, here's how it's defined, here's what's occurred, and this is why I'm ordering reimbursement support.
Thank you. Yeah, I think that answers my question.
Okay,
Thank you,
good.
Peggy.
Thank you.
All right, let's see, I think Representative Moriarty, you were next.
Okay, thank you, Madam Chair. I'll just take a shot at answering Senator Kimes' questions here. And I stand to be corrected by anybody with greater knowledge. The protection from abuse concept is entirely different from the context of this bill, which strictly relate to the dissolution of a marriage. And as I think Peggy indicated, economic abuse standing alone would not justify a conventional protection from abuse order. So we used to use the term alimony in lieu of spousal support, and then that language sort of changed. So this bill, as I understand it, basically makes economic abuse a factor in determining the amount of money that the offending spouse must pay to the other in the form of support if there has been economic abuse perpetrated by that other spouse. Secondly, though, and this applies both when the parties are divorcing and when, for whatever reason, they choose to go the legal separation route, which in my experience is very rarely done these days. And that goes back to the beginning of my career. The other part of the bill deals with the disposition of property acquired during the marriage. It's called marital property. And there's a number of factors that go into the division of marital property. And this statute adds economic abuse as one factor that the court can rely upon in determining which spouse gets which property, or how much property goes to which of the two spouses. So this bill is not dependent in any way upon the finding of physical or emotional abuse in the protection from abuse context. So if that's helpful, that's all I had to say.
Yeah, thanks for filling in.
Yeah, thank you. Representative Babbage?
Thank you, Madam Chair. Yeah, I appreciate those questions and the explanation given by Representative Moriarty. That's how I understand it. And given a review of the testimony and so forth, I'm ready to offer a not to pass motion. So Madam Chair, I move ought to pass on LD 947.
Is there a second on the motion? Seconded by Representative Sheehan. Is there discussion on the motion? Representative Babbage, your hand is still up.
I'm
I didn't know if
sorry.
you wanted,
I shall
and you
take it
did.
then.
Yeah, you did offer some discussion. I didn't know if you wanted to offer more. Okay, thank you. Committee members, and we've just been joined by, I think both Representative Hagan and Representative Evangelos, and I just want to catch you up on where we are. We're on LD 719 and have had the bill analysis and then a motion ought to pass by Representative Babbage and a second, I think, by Representative Sheehan. Representative Keim, go ahead.
Actually, it's Bill 947, I think, isn't it, Madam Chair?
Oh, yes, you're absolutely right. My mistake. Thank you.
Okay.
Senator Keim?
Yes, I would request a short corner caucus.
Okay, that is fine. How much time?
5 minutes.
Okay, great. We'll come back in about 5 minutes. Thank you.
Senator Carney,
Yes.
did I miss a vote?
Yeah, we voted on LD 719.
Okay. I mean, you didn't get that whole list done while I was gone?
We tried.
What was the vote on 719? Could someone tell me, please? Was it a divided report or?
Yes.
545, Jeff.
5 absent?
Yes.
Okay, thank you. So follow the normal procedure, right? Right, the House leadership.
Yes. Yeah, for voting when you were not present, it's you contact leadership.
Okay, and which was the bill we did, Chris? You just mentioned it.
947 is the motion is on the table. That's
right. The one we did previously, 719.
Right.
Yes.
Okay. All right. Thank you.
And Jeff, we also did language reviews on 222 and 159.
Okay.
And those, Peggy had emailed those to us yesterday.
Right. No, I read them and I'm good. Thank you.
Yeah, you're welcome. And Representative Reckitt, thank you for joining us. And just wanted to let you know that we are on LD 947, the Act to Address Long-Term Impact of Economic Abuse by a Spouse.
Okay.
We have a pending ought to pass motion, and our colleagues have requested a corner caucus. So we're just giving them a couple of minutes.
Okay. Yeah, there's still be the cable guy's still going to be running around behind me trying to shift over the phones, and we're still not going to be entirely connected. I could like just shoot myself, but we now got to get an electrician back here again.
No, that's too bad.
Yeah.
Lois said, I realized that you were coming back. I would have held off on the motion.
No, that's fine. I mean, it was a ought to pass motion, right?
Right.
I need to hold. So what was their problem? Could you tell?
I don't think there's any. I think they just needed some time to talk about it, and they'll be back in about a minute or minute and a half.
Yeah. The one of the things that I got really clear about when I read some of the answers to the questions that were asked was the whole issue about the lawsuit that's going on about the original economic abuse bill. Seems very clear to me that this bill has nothing to do with that and is not impacted on it in any way. That suit is going on, but it's just not relevant to this bill.
Oh.
Could I just mention, we're not in caucus ourselves.
No.
This is
We are
live.
not in caucus, and we're also not in work session because our colleagues have asked us to give them a little time in caucus. So we should probably just not speak about the bill. I just wanted to catch people up.
Sorry, I thought we were in caucus, so no problem, not a problem. But Kim, Lisa's back, so they must be returning at some point here.
On 719, which is not what we're under discussion now, I just want to get my record straight. Was that an ought to pass 545?
Yes.
Thank you.
So I need to get in touch with Soupy to vote on these things?
We'll review that process once everybody's rejoined us.
Okay.
We'll take this vote and then we'll review the process for voting when you've been absent.
All right.
Because I think
thanks.
everybody would benefit from hearing that.
Yeah, I'm so sorry. This has been a totally screwed up day for me. It's like, you can't, if I could have controlled when Spectrum was coming, that would have been helpful, but I couldn't.
Yeah.
One can never control when people are coming to fix things. Or when they're gonna examine you if they're a doctor, there's the other thing, you never know either,
Quick question, Madam Chair.
Yes.
Evidently, you couldn't hear my voice on the last vote.
Yeah, I'm not sure why, but now you're coming through loud and clear.
Well, I had switched to my Bose speaker to hear you guys better, so it didn't sound so tinny on my computer. So I can't do that now. I got to stay on this in order to for you to hear me. So just wanted to explain that.
Yeah.
Thank you.
All right. I'm just gonna put on mute so you don't get to hear all the rumblings behind me here.
Okay, committee members, I think we have a motion ought to pass on 947 and a second. Is there any committee discussion on the pending motion? Not seeing any raised hands. Is the committee ready for the vote?
Yes.
Okay.
Representative Carney.
Yes.
Representative Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Can you tell me the number of the bill again?
947.
Okay, yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Libby.
Representative Libby did let us know that she's working other bills in other committees, so she's trying to do both, but that's apparently where she is right now.
Representative Libby is absent. The vote of the committee is 11 members voting in the affirmative, 0 in the negative, and 3 members are absent. That is the vote of the committee, Madam Chair.
Thank you very much, Ms. Panett. And with that, we'll close our work session on LD 947. And before we move on to our next work session, I just want to review with committee members how we're handling votes on when you're absent. The process is that our committee clerk, Ms. Panett, has actually come up with a great process. She will send the voting sheets. Soupy, do you want to explain this or shall I review it?
I think you're doing a great job. I
Okay.
will.
Tell me if I
Go
go,
ahead.
if I stray from the process. So Soupy will email us the voting sheets if we have missed a vote. And that is, that should jog our memory that if we've missed a vote, we should report our votes to our presiding officers for them to initiate the process for recording the votes. And you have to do that by noon the second day after the committee votes. Oh, I think I'm wrong there. Go ahead.
Second business day.
Second business day. Thank
Which
you.
means the votes from today will be due Tuesday at noon. Oh, maybe I'm wrong on that one because we count Friday. Oh, wait, Monday's a holiday.
Monday's a
holiday, so
Tuesday at noon.
Right.
Yep. Are there any questions about that process? Okay. And Soupy, thank you for coming up with that process. I think it's it's nice to have that reminder in our email that the votes have occurred and that we're.
And just so you know, I will do that evening. So you will get it. You will get it that evening of the work session. So.
That's great. Thanks. Representative Hagan, did you have a question?
Yeah, thank you very much, Madam Chair. I'd just like to say that this has been a godsend for me to have Soupy do that, where I've missed through school and missed a lot of votes. And to have it right there in front of me, then be able to print it, put it in my little notebook here, which is about 5 feet thick, has been fantastic. So I appreciate it.
So how many votes have happened this afternoon?
The only vote that we've done, well, this afternoon, we started with 719, which is the one that we're not available for, Representative Rackett.
Okay.
And then the one we just did, 947, I think all of us who are here, were here for that. So.
Okay.
All righty. Everybody ready to move forward? That brings us to LD 803, and I'll open the work session on LD 803. And Peggy, if you could again give us a more of a broad brush analysis just to start with, and then we'll ask you more questions.
Okay, so this section amends, this bill amends a provision in the protection from abuse statutes. It is when it applies when somebody violates a protection from abuse order. Our law right now just refers to violating a protective order issued under section 4007. And that the conduct that they use when they violate that order is reckless and creates a substantial risk of death or serious bodily injury to the plaintiff, or is actually an assault on the plaintiff. Current law says that's a Class C crime, What this bill does is it says it would apply to protection orders that are similar to orders issued in Maine under Section 4007, but weren't issued in Maine. And so somebody with an order from out of state who engages in that conduct that violates the order would be able to be prosecuted for a Class C crime. And that's the intent of this.
Ann, you're
I'm
muted.
muted. Thank you. What I'd like to do is bring the bill sponsor onto the panel just while we're having this conversation, and then call on Representative Reckitt. I think your hand was up first, so go ahead with your question.
Well, to me, it looks like what this bill does is to implement in the state of Maine what the Violence Against Women Act has done nationally on full faith and credit. So that there's full faith and credit on protective orders from one state to another. But I don't believe we could enforce it here easily unless there were a state law. Is that the intent of what's going on? That's how it reads to me. That's why I'm.
So this is actually an enhanced penalty because it's a Class C crime. Usually the violation of a protection order is a Class D crime if it's kind of the more violent based. So this makes it a Class C if not only did the person violate the order, but their conduct was reckless and created a substantial risk of injury, or it was an assault.
Or it was the third violation, which is already a Class C.
Which is subsection 5. You know too much about this law.
Yeah. All right. I'll be quiet now.
Senator Keim?
Thank you. So Peggy, so if they violate an order, just because the order's been violated without actually doing another crime, right?
Right. It could be just being too close,
right, like
following
it's
somebody
or contacting them on social media. So does that then also become a Class C crime?
No.
With this bill?
No, subsection 4 says the conduct has to include this kind of egregious conduct. It's either putting somebody in substantial risk of harm through their reckless activity, or it's actually an assault.
Right, but the egregious conduct would already be a crime.
Chances are it would be. I mean, if somebody from New Hampshire assaults somebody in Maine, it's a crime in Maine. That assault is a crime in Maine. So there's already that crime. What this is saying is if they violated, they have an order from another state, they come into Maine, they not only do they assault the person, but they violate the order. So now they've done 2 crimes if this passes. One crime is the assault, the other crime is violating the order. And the level of the violation of the order brings it to a Class C crime. I mean, they'd have to, when the prosecutor here in Maine prosecuted that case, they would have to show, if this bill passed, that the order that had been issued from another state was similar to an order that could be issued under 4007.
Right, and I guess so. What I'm trying to figure out is if they violate their order, is in Maine. So, and it's just the contact is too close, or they're contacting them on social media or whatever. Is that captured in this bill as well, or is it only if they have egregious conduct and it's also violating the order?
We do have Shira Burns from the Maine Prosecutors Association, and I think that I know that her testimony on this bill addressed the point that you're raising, Senator Keim. So maybe what I'll do is bring her in and you could ask the question. Does that seem like?
So in general, if I do ask a question of Peggy, it's because Peggy is independent and unbiased, right, and an analyst. And so I tend to ask some of my questions to her because when I want to ask an advocate a question, I ask an advocate. And when I want something that I feel is certainly unbiased, then I tend to ask Peggy. So that's just how I generally go about the questions. But if somebody wants to hear from her, that's fine. I think the question is sort of basic to the law. So I think probably Peggy could answer. I don't think it's that intricate of a question.
Okay.
I'm happy to try to answer that one. And then ADA Burns can fill in the gaps. How's that?
Sounds great.
So I put all of section 4011 in the bill analysis. And so if you're just talking about a violation of an order that was issued in another state, that's covered by subsection 1, paragraph A. So it's a class D crime if somebody violates a temporary emergency, interim, or final protective order, an order of a tribal court of the Passamaquoddy tribe or the Penobscot Nation, or a similar order issued by a court of the United States or of another state, territory, commonwealth, or tribe. So yes, they as somebody with an out-of-state or an out-of-state order against them comes into this state and violates that order, no matter what it is in that order, they are it's either committing a class D crime if it's one of those more kind of abuse related as opposed to some of the more economic things. It would be, they've committed that crime here in Maine. We recognize those orders for that purpose. And I don't know if you remember, but John Pelletier said this was just kind of an oversight to not include that language in subsection 4, because in subsection 5, as Representative Reckitt mentioned about repeat violations, it's for a person who commits a violation and has 2 or more convictions prior to that. That does include for engaging in substantially similar conduct in another jurisdiction. So you would be able to capture those too. So I can understand why someone would look at that and say it's an oversight. I do think that you're actually capturing more people in a crime. And so you are kind of creating a new crime. You're not saying this kind of behavior is a new crime. You're saying these people now can commit this crime where they right now they can't.
Right, understood. Thank you.
Representative Moriarty.
Thank you, Madam Chair. A question for Peggy. I'm a bit turned around, I think, and I just want to regain my my balance. So let's suppose there's an order from another jurisdiction which, in a very detailed way, says that there cannot be any conduct between the parties and so forth. One of the parties moves to Maine, and let's say the order, among other things, said neither party shall call the other one on the phone. Somebody then moves to Maine and initiates a phone call to the other party. And that's it. That's the only violation of the order. As I read this, that would not be considered to be a crime in Maine, because there's no violence involved. There's no substantial risk of death or injury. It is a violation of the out-of-state order, but it's relatively minor.
But the way the statute defines it is a violation of the order is a class D crime unless it's a violation of paragraphs F, F1, or H through O. So now you have to go back and look at section 4007. So subsection 1, this is the relief that the court can order. One of the things the court can order is paragraph D directing the defendant to refrain from having any direct or indirect contact with the plaintiff, including via social media. So if that is part of the order and the defendant violated it, then my understanding is that's a Class D crime.
Right.
But that's a main order though, right?
That's a main order, but, right? So 4011, which is where you get the penalties for violating it. A temporary emergency interim or final protective order, it's a Class D crime, and the exception is if it concerns relief. Everything's a Class D crime, and then we're going to carve out the things that are just remedied by contempt of court because you violated the order. So contact, direct or indirect contact, is something that's considered really bad, and we're going to call it a Class D crime if you violate that part of the order.
Well, I'm not quite there yet.
Okay.
Suppose you've got a Wyoming order which says no social media contact. One of the parties moves to Maine and initiates a social media contact. Is that a crime in Maine?
You know, maybe this is when you want to bring in ADA Burns, because my reading of the statute would say, yes, it is, because they violated a term of a similar order issued by a court of another state. And it's not one of those things that we've carved out and said we're going to enforce that by contempt of court. So that's how I read the statute. I'm not the one who actually prosecutes people. So maybe you do want to hear from the prosecutor on that.
I'd be interested in hearing.
Let me bring her into the panel.
Can I just add a little wrinkle?
Go ahead.
Please do.
I mean, I think one of the things that Representative Moriarty said is not exactly accurate, in the sense that if there's an order in place, only the person against whom the order is made can violate the order. If there's two people involved, they can't both violate the order. Only the person who had the order served on them is eligible to violate it. The victim cannot violate their own order.
So, that is a wrinkle. So if the protected person moves to Maine,
right,
and the person in Wyoming contacts them through social media, does Maine have jurisdiction over them might be an issue. But, and this is where I stopped talking.
Right. I was just worried about the fact that it sounded like there was a discussion about both people being able to violate this order, and that's not possible.
Lois, you could have an order which says neither party shall initiate contact with the other.
I don't think so.
I think you could.
Well, I think it would be a wrong order. I mean, I don't think that they're allowed to issue orders.
Comes from, you know, that's time to call in the pros.
Yep.
All right, Ms. Burns, thank you so much for being available for our work session. You've probably been listening to our conversation, and we would love to hear your answer to the questions that we've raised.
Yes, I mean, I can start with that last example of, let's say there is an out-of-state order, put it in any state you want, and the victim moves to Maine. Part of the protection order that's issued from the other state says may not contact the protected party by social media. And then she receives a Facebook message from the defendant. We would have jurisdiction because the protected party was in Maine when she received the message, and then it would be prosecuted under 4011 subsection 1A as a Class D, as in dog, crime. That same order, if they're issued again from out of state, and the defendant is not to abuse the victim, then comes to the state of Maine and assaults her, that would still only be a Class D crime as the current statute reads. However, what this bill is trying to do is to make this a class, that one circumstance of assault or reckless conduct that creates a substantial risk of death or serious bodily injury, a Class C crime, because we already consider it a Class C crime if the victim got her protection order in the state of Maine.
Thank you, Attorney Burns. And Representative Reckitt, is your hand residual?
Oh, yes, it's residual. Sorry.
Next, we have Senator Keim. Go ahead, Senator Keim.
Thank you. Thank you, Attorney Burns, for being here to answer questions. So then what class crime would it be for assault if there wasn't? So if there wasn't a protection order, it wouldn't be a Class C crime?
Correct. It would be a Class D as in dog crime.
Thank you.
Representative Moriarty.
So just a question for District Attorney Burns. So if violation of the no social media contact order is a Class D crime, it isn't elevated to a Class C crime by virtue of this bill.
Correct. It is not getting, this Class D will not be enhanced in that circumstance.
Okay, thank you. I think that was sort of a lingering concern here in our discussion. Thank you.
Representative Hagan.
Thank you, Madam Chair. So I have a question, I don't know anything about these things. Can a person who moves into the state with a PFA go to a court and have a Maine version made, or do they have to wait for a new set of egregious behaviors in current law?
So they do not need to register their protection order. That goes back to the full faith and credit clause that a victim, wherever she or he is, gets their protection order and then may purposely move out of state to get away from their abuser and may not want to register a new protection order, because that means you have to give notice to the offending party, and that would put them on notice of where the victim is. So that's why the full faith and credit clause, the Violence Against Women's Act, makes it so federally we recognize all states' protection orders. So a victim can come from California to Maine and she can show law enforcement it, saying that I have this, but she does not need to make any new action in the state of Maine.
Okay, so this person would be fully protected under Maine law from another state or tribe or whatnot. And so basically I'm to understand, I think I have it now, that the only thing this bill does is if the violation does occur and it's serious, egregious, or assault, then it becomes a C instead of a D. And are there I'm kind of thinking that there are varying kinds of assault that would be a C or even higher. What happens there?
So if the defendant comes to the state of Maine and strangles the victim and meets the definition of strangulation under our statute, it would be prosecuted as a domestic violence aggravated assault Class B crime. If there's a protection order in place, there would also be a violation of protection from abuse or Class D crime as it currently stands if the protection order was from out of state. If it was an in-state protection order, the abusing party would also be facing a Class C crime. Again, this bill only is trying to make the statute consistent, that it doesn't matter where a victim gets a protection order. We're going to treat the protection order the exact same, making any abuse that happens to her in violation of protection order a Class C crime.
Thank you very much.
Committee members, are there additional questions for either for our analyst Peggy or for Assistant Attorney General Burns? Representative Sheehan, go ahead.
Madam Chair, I'm prepared to make a motion ought to pass.
Thank you, and it's seconded by Representative Newell. Committee members, is there any discussion on the motion? Peggy has her hand raised. Go ahead, Peggy.
Thank you. I'm just wondering if we also need to amend subsection 1, because right now it says, except as provided in subsections 2 and 4, a violation is a Class D crime, and 4 is the one we're talking about, but 5 makes it a Class C crime if they have 2 or more convictions. And I just wonder if we need to clean that up. And it really isn't, it's not really related to what this bill is doing, but if we needed to clean that up, we could do that in this bill. And I know this is a brand new question to ADA Burns, so maybe that wasn't fair to raise it right now.
If that question is addressed to me, I do see what you're talking about. It would make it cleaner, saying that there's more exceptions, specifically in the new statute, subsection 5 of the new Class C crime, when somebody has 2 prior convictions, which would make it more an exception. So I do see except in subsection 1 being except as provided in subsections 2, 4, and 5.
That's a thank you for raising the issue and addressing it. Let's just, for the purposes of the committee, could you please screen share, Peggy, and show us or I can screen share the bill analysis if you'd prefer, but just so that we can visualize the change, and then I'll ask Representative Sheehan and Representative Newell if they're comfortable with changing to a motion to amend to include that as well.
Just a minute. It won't let me open more than one document at a time. I'm going to trick it.
Okay, thank you.
Okay. Okay. Woo, whoa. German. So here's what I am talking about. Okay, here's 4011. And the bill is amending subsection 4 down here. And I'm talking about this very first subsection that says, except as provided in subsections 2 and 4. So 2 is when it says, violation of this, we're only going to treat it as contempt of court. 4 is what we're talking about. It's already a Class C crime with a main order, and you engage in this kind of conduct. And then 5 is a person who violates this, commits a Class C crime if they have 2 or more prior convictions. So it's really just kind of warning people in this first subsection. Okay, it's a Class D crime, except if 2 applies, in which case it's really a civil court act idea. 4, if it's that really bad, reckless conduct or assault, and 5, if you have prior convictions. Is that clear?
Yeah, thank you. That's crystal, at least I think it's clear. And let's just, if you don't mind ending the screen share, and let's check in with the committee. Is everybody clear on what that change is? And thank you for catching it, Peggy. And then Representatives Sheehan and Newell, do you accept that change to the amendment, to the motion?
I do. That was really helpful, Peggy. Thank you.
Yes, thank you, Madam Chair.
Yeah. And thank you for catching that, Peggy.
Okay, well, I hope I was catching something that was really an issue.
And then I see that we have a couple of hands up. Representative Hagan, I think your hand was first.
All right, thank you, Madam Chair. One for ADA Burns. Thank you for being here and answering these questions. Could you go over the basic sentencing guidelines for a Class D and a Class C crime?
Yes. So for a Class D violation of protection from abuse order, you could be up to 364 days in jail. And it would be, it's usually 1 year probation, but if certified batterers intervention program is that's ordered, it can be 2 years probation, but then statutorily it will automatically turn to 1 year probation if the defendant completes the certified batterer intervention program and also is in compliance with his probation or her probation otherwise. I have caught myself using the pronoun he as a defendant, and I'm sorry, statistically that is what's accurate, but I very much recognize men can be victims of domestic violence too, and women can perpetrate it. As far as a Class C crime, it's up to 5 years in jail and 2 years probation. So even if a defendant is ordered certified batterers intervention program and completes it, the defendant still would be doing the whole 2 years if ordered.
Thank you very much.
Representative Reckitt?
Peggy and I don't think I'm out to lunch, but it seems to me there was a good catch grammatically and to put everything in one place. But it's not a change in this law or any other law. It's just a matter of putting it in the logical place so that it's more prominently visible to a person who's being sentenced or prosecuted.
Right. It's not changing the sentencing. It's not changing the crime. It's just making it consistent that it's a D except in these cases.
Right.
I mean, when you get to subsection 5, you
grammatical
realize
thing.
it's
Yeah.
Class C.
Yeah. I mean, to me, it's like when you were doing the errors and omissions things, or, you're just putting the right thing in the right place kind of stuff.
Right. I consider this a technical
Yeah.
correction.
Thank you.
Committee members, is there any more discussion on the pending vote? I mean, the pending motion, excuse me. Representative Hagan?
Thank you very much, Madam Chair. I'd like to do a very brief corner caucus, if that would be okay.
Yeah, that's
Thank you
fine.
very
How
much.
much time would you like?
Oh, up to 5
Okay.
minutes. Yeah,
All right.
thank you.
So we'll be in recess committee for 5 minutes. And thank you.
I forgot to mention, I'll mention this when the committee reconvenes, that I think this needs review under Joint Rule 319, Senator DeChambeau, because it's a new crime or it's enhancing the penalty. So we should come and see you in criminal justice.
No comment.
At least you'll know what it's all about.
Yep. No problem. Thank you, though. I expected it, really, I did.
Okay, good.
Yeah. So, Peggy, that's something you share with Jane Overton, right?
Yes, actually, Jane and I talked about this, and I was originally just going to ask you if you thought it needed review. And the more Jane and I talked about it, the more we realized it was the right thing to do, to ask for review. Because it really is, you're subjecting somebody who is not committing a Class C crime to, a Class C crime if this passes.
Well, I've spoken to a few of them in there, and you know what my committee is. If they could make it a D crime, they would try, right? So, but no, it's pretty much they understand. It's what's the word I want to say? Yeah, or a similar order. That's the one that drives this. So
Right. You're not really creating any additional conduct that you're criminalizing. You're just
Well-
applying it to somebody else.
Like I said in this testimony too, it's, if you don't do this, then you're just asking the person to get beaten again, and have no protection before that, you know, and try and get a main order after they got, you know, assaulted again. So
Right. I mean, it would still be a Class D crime for them violating the order, but this is, you know, a level of conduct higher than that, I think.
Well, and I truly appreciate ADA Shira Burns and DA Slattery for, you know, especially Miss Burns is a specialist in that and sex crime. So those are the people we should be listening to. They're not advocates per se. That's their job. So.
So Senator DeChambeau and I were just talking a little bit about the fact that Joint Rule 319 applies in this case. Anytime that you create a new crime or enhance the penalties, Joint Rule 319 directs you to have the Criminal Justice and Public Safety Committee look at that so they can kind of have an overarching view of the effect on the criminal justice system of all the bills that are changing crimes. And so if this does go forward affirmatively from the committee, I will work to put in a memo together for the Criminal Justice Committee to review.
Thank you.
You're welcome.
Committee members, are we ready for the vote? Representative Moriarty? You're muted.
I left the room and I obeyed instructions. Is the motion actually ought to pass as amended as opposed to ought to pass?
Yes, the motion is ought to pass as amended, with the amendment being the inclusion of the numeral 5 in the first paragraph.
Okay. Thank you.
Of the statute. And I think we're ready for the vote, Soupy?
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
I'm sorry. Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll call the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckitt. I have 11 members voting in the affirmative, 0 members in the negative, and 3 members are absent, Madam Chair. That is the vote of the committee.
Thank you. Thank you very much, Ms. Panett. And with that, we will bring our work session on LD 803 to a close and move on to our next work session.
Thank you, everybody, and bye-bye.
Thank you so much, Senator DeChambeau.
Great.
And thank you, ADA Burns.
Thank you, ADA Burns. And so committee members will move on to our next work session, and that's on LD 1030, an act to expand court's authority to protect children when a parent has been awarded sole parental rights and responsibilities. And Peggy, if you could please present us with your bill analysis, and we might need a slightly deeper dive on this one because it's so complex.
I agree, and I'm really hoping that you'll also invite some of the other folks, especially Professor Deirdre Smith, in to answer questions. So the purpose of this bill is to address the termination of parental rights. Under current law, parental rights can be terminated in the child protective context. They can be terminated in the adoption context to allow a child to be adopted by somebody else. And there's one provision in Title 19A that allows a parent or the parent of a parent, if the parent of the child is a minor, to petition to have the other parent's parental rights terminated because the child was conceived as a result of a sexual assault. So if there's a conviction, there's a little bit lower standard of proof. If there's not a conviction, but you can still prove by clear and convincing evidence that the child was the result of a sexual assault, then the court can go ahead and terminate that other parent, that assaultive parent's parental rights. What was happening in the courts was there were situations that didn't fall into any of those three categories, where a parent thought it was appropriate to protect the child to terminate another parent's parental rights. And although the court at one point said, yes, you can do this, it wasn't clear. The law court said, yes, the district court can entertain that motion. It wasn't really clear what that process was. And so the judicial branch, the courts, actually asked FLAC to try to sort that out. And FLAC spent quite a bit of time trying to figure out the best way to go about that. And so that's what this bill does. Section 1 is addressing a slightly different situation, but so Section 2 amends the existing provision of law that allows a parent to file a petition to terminate the other parent's rights, parental rights, when there's the child was conceived as a result of a sexual assault. It expands the situation where a parent can petition to terminate that other parent's rights in a narrow category. And the first step is parent, we'll say parent A, the custodial parent, even though we don't use custodial parent in 19A anymore. So parent A, the child lives with parent A. Parent A has a court order. They've gone through a parental rights action and has an order for sole parental rights. Parent B is not provide. The only thing that parent B, the only responsibility or right that parent B might have is to pay child support. No right for contact, no right for access to records, no right for decision-making for school or medical care or medical decision. So when that order has been in place for at least 12 months, and parent A still thinks it's a really good idea to terminate a parent B's parental rights, parent A can file a petition in the district court and has to allege that, I want to get this exactly right, the grounds for the petition. So there's that order of sole parental rights, and it's necessary. The termination of parent B's rights is necessary to protect the child from serious harm or the threat of serious harm. So that's kind of the next step. It's not just I don't like the other parent, or the other parent wants to get out of paying child support. It really is necessary to protect the child from serious harm or the threat of serious harm. And that's something that the petitioner has to actually allege in court. And then, I'm looking at, if you're looking at the bill, that is paragraph C of subsection 2 on page 2. So the rest of that's kind of the key. And then there's the procedure that the court has to go through in looking at all of this. There can be appointed counsel. The court has to appoint a guardian ad litem if the petition to terminate if the petition says we need this termination because it's necessary to protect the child from serious harm or the threat of serious harm. So you're going to have a guardian ad litem there to assess the situation and make sure that's necessary. And parent B can say, okay, you're right. Let's just have this go ahead. I will consent to the termination. That has to be done after the judge has explained to them what it means to have your parental rights terminated. And then in subsection 3A, there's the procedure that the court actually has to go through. So current law says if you have a conviction for the gross sexual assault, the court has to grant that petition. That's what paragraph A is saying. Paragraph B is the rest. So if so paragraph B, subparagraph 1, that is also existing law. That's, you don't have a conviction for sexual assault, but you can prove it. And that's a may for the court. And then paragraph B, subparagraph 2 is what the new part that this bill is doing. That the petitioner has proven the allegations that here's the order that's been in the sole parental rights order that's been in place for at least 12 months. And this termination is necessary to protect the child from serious harm or the threat of serious harm. And then it goes on to explain that little a and the little b explain some examples of what evidence the court is going to look at to determine whether or not it's necessary to protect the child from harm or threat of serious harm. That last block paragraph, lines 28, 29, and 30 are saying, okay, this is it. This is the only other way you can terminate parental rights. You can do it through the child protective statutes. And you can, and that's something that's not necessarily filed by another parent. And the only other way is in the adoption statutes, 18C, section 9204. So no other ways you can terminate parental rights. I mean, the other, all this is important, of course, but I'm just trying to hit the highlights here. So after that, section 3 is amending the child protection laws, the Child and Family Services Act. And it's clarifying, it's trying to make consistent who else can bring a motion or a petition, who can file a petition to terminate parental rights. So it's tracking back to what you're doing in section 2 of the bill. And I'm just really relying on Professor Smith to fill in all the gaps. And then the last piece to talk about would be section 1, I think, which is about appointment of a guardian. And although this isn't about terminating parental rights, you're still dealing with the same situation where you had an order for sole parental rights and responsibilities. You have parent A again with that order, sole parental rights and responsibilities. And something happens, parent A dies in a car wreck, hit by a bus. Current law says that unless the parent B's rights are terminated, so if we haven't gone through this section 2 of the bill, all the rights of being a parent devolve on the surviving parent. And there's a concern that if parent A had gone through the process and proved to a court that sole parental rights and responsibilities are the appropriate way to go forward with this child, and parent A, and parent B should have nothing to do with the child, this gives somebody else in the family, a grandparent, somebody, it doesn't even have to be somebody in the family, but somebody who is an interested person with that child. It gives them an opening to go to court and ask for guardianship, file a petition for a guardianship to say, look, here's all the information we had about why parent B should not be the parent in this situation. Instead, appoint me as a guardian while you sort this out. So that's what a section 1 does. Basically, and they call that the devolution statute because it refers to the devolution because Title 19A, I think it's section 1502, says all those rights devolve on the surviving parent. If parent B's rights have already been terminated, then that section doesn't apply. Not a parent anymore. Okay. And now you need to invite Professor Smith in so she can cover everything I didn't.
Thank you so much, Peggy. And I think that there might be some committee members' questions for you. So let's initially take those questions. Go ahead, Representative Thorne.
Thank you, Madam Chair. I'm not sure if Peggy can answer this, but maybe another panelist coming on. In section 1, where you referred to if the scenario was that parent A, who has custody, determined that parent B wasn't fit and went to court and deemed them not fit and took away their parental ability, and then years passed, parent A dies for whatever circumstance, and in order to award guardianship, does that eliminate the ability from parent B from then at least attempting to say, hey, you know what? I got it taken away years ago. That was when I was in a bad place. I've cleaned my act up. I'm working. I got a place to live, and I would love to have custody of my child back under these circumstances. Is that, once that parental right is taken away, does that mean a judge can never award custody, or is that always able to be assessed down the road?
So termination of parental, that's a great question. Termination of parental rights is permanent as far as I can tell. So if they actually went to the step of terminating parental rights under section 2 of the bill, then section 1 never even applies. There's no guardianship that would have to happen in that situation because parent B is not a parent anymore. It's just B now. But if parent A has a sole parental rights order and never went through the step of termination of parental rights, so they just have sole parental rights and responsibilities, on parent B, no contact, nothing, what would happen is in section 1, that's what that little b is. There is neither a substantial change in circumstances between the time of the entry of the order and the parent's death, nor other facts that would render a finding based on the order to be inequitable or unjust. So parent B comes in and said, look, I haven't had anything to do, but I have cleaned up my act. I've been gainfully employed. I built this house for my, a home. There has been a substantial change in circumstances from the time of that original order, and I really want to step in and parent my child now. That's written specifically for that case. And so the person who would be applying for guardianship has to prove that there hasn't been a substantial change in circumstances. that the burden is on the person asking for guardianship. So parent B could come and oppose the guardianship, and the court would look at all the circumstances and say, okay, you're right, guardianship is not appropriate in this case. It's just kind of the entry into the guardianship question.
Right.
Yeah.
Yep. Thank you.
Mm-hmm.
Thank you, Madam Chair.
Go ahead, Representative Moriarty. And you're still muted, Steve.
Yeah, sorry. Thank you. Peggy, just to make sure I understand this, if at the time of the divorce, sole parental rights and responsibilities are given to parent A, that is not the same thing as termination of parental rights and responsibilities of parent B.
Correct. That's exactly correct. In fact, you could have a sole parental, what's considered a sole parental rights order, but parent B still has to pay child support. But the idea is parent B has nothing to do with raising this child, making decisions, providing, support, home, education, other than child support. They're not involved in the child's life. That's what a sole parental rights order is.
So just to put this in sort of colloquial language, termination of parental rights is a much more serious thing than determining custody.
Yes, and actually, FLAC really struggled with this because they knew termination was really a drastic step, and you don't want to take that step unless, in this case, it's necessary to protect the child from serious harm or the threat of serious harm.
Okay, great, thanks.
Committee members, additional questions for Peggy?
If there aren't, I do need to raise one more thing, which is the Department of Health and Human Services is concerned about some of the language, and they have been working with FLAC to put an amendment together, and Deirdre Smith has that amendment that I think the department has signed off on it now. She knows more of the details. She's been involved in the discussion with FLAC and the department, and I would appreciate it if you could have her explain that, and I can email it to you if that's what you want, or we can do a screen share.
Thank you, Peggy. I just moved Professor Smith over, and here she is. Before we, well, first of all, welcome, Professor Smith. Let me just turn to Representative Reckitt, who has raised her hand, and see. Did you have a question, Representative Reckitt? And you're still muted.
For some unearthly reason, I can't get myself a copy of the bill to look at right now, even though I know I have printed it and put it someplace in my office. So if anybody has the capacity, tell me how to find it again, or to send me a copy, I would be thrilled.
Are you looking for the bill itself?
I'm looking for the bill itself.
I will email you a copy.
Thank you. My second question is, do I recollect that this bill has a line in it that gives allows judges to be mandatory, or insists that judges be mandatory reporters, or is that a different bill?
Not in this bill.
Okay, excellent. Because I don't want that to be, so I just want to make sure I didn't miss it on the flyby. Thank you.
Thank you, Representative Reckitt. And now we'll turn to Professor Smith. Professor Smith, welcome back to our committee. And would you like to, I'll let you start wherever you think is appropriate. I know you've been listening and also have some information about an amendment. So
Sure, I'm happy to. And actually, it does tie in with Representative Reckitt's question just a moment ago. What I'll just focus on, I'm happy to answer any questions. I think Peggy covered this very comprehensive bill in wonderful detail. I don't have anything really to add about the bill itself. But the Office of Child and Family Services did submit some written testimony at the time of the public hearing. And FLAC reached out to OCFS, and so I am not a member of FLAC, but I am a consultant, and I've been working with FLAC on this project for a few years now. There was a meeting between OCFS representatives, which I attended, as did Assistant Attorney General Debbie Willis, who I think is also here today, who works in child support enforcement. And it was a meeting we went through in some detail, all of the concerns that were raised by OCFS. And the outcome of that meeting was 2 points that OCFS wanted reflected in an amendment. So we worked with OCFS representatives, that is FLAC did, and we prepared a proposed committee amendment, which I have shared with Peggy, that would make two small changes, but important ones, obviously, to the department that FLAC is agreeable to, and I believe OCFS has communicated to the committee chairs that they are also in agreement with that amendment. The first does pick up on what Representative Reckitt was just saying a moment ago, which was a question about whether a mandatory report would need to be made to the Department of Health and Human Services if a petition alleging allegations that termination of parental rights is necessary to protect a child from serious harm or the threat of serious harm is filed. And the department was concerned that there may be allegations of serious child abuse, or I should say there's an incident of serious child abuse that had not come to their attention. And they wanted to have the opportunity as appropriate to run that through their usual process that they do when they received reports from mandatory reports. My understanding is that this is already a regular practice of representatives of the judicial branch, is to make reports where they thought that it was appropriate, that something needed to be brought to the attention of the Department of Health and Human Services. OCFS requested that that be reflected actually in statutory language in the bill. So that is the first proposed amendment, which would be adding language, a new section under subsection 2A, which is the procedures section, adding a new paragraph G that would say the court shall make a report to the Department of Health and Human Services under Title 22, Chapter 1071, which is the Child Protection Act, including notifying the department a petition for termination has been filed and providing the department with the allegations of serious harm or threat of serious harm contained in the petition. So the report would be of essentially the allegations in the petition itself. So that was the first proposed amendment that is agreeable to both FLAC and OCFS. The second one would be to amend subsection 3A of the bill, which is the findings, how does the court make the finding of threat of serious harm or serious harm or threat of serious harm. And as Peggy explained so well, that there were some examples of the types of evidence that a court could consider. And the OCFS wanted clarification that the reference in subsection A to a parent's conduct demonstrating an intent to permanently forego all parental duties or relinquish parental claims regarding the child. I'm on page 3 of the original bill at line 26. That just an additional line be, line 24, an additional phrase be added to that when it results in harm or threat of harm to the child. So the court can consider as part of its finding that termination of parental rights is necessary to protect the child from harm or the threat of serious harm. It may include, that proof may include, but is not required to find, parents' conduct demonstrating an intent to permanently forego all parental duties or relinquish parental claims regarding the child when it results in harm or threat of serious harm. So essentially, if a parent's conduct in this respect itself results in harm or a threat of harm to the child, then it's appropriate for the court to consider it as part of the proof when it makes the ultimate determination of whether to terminate a parent's rights based on a threat of serious harm or a threat of serious harm. So those were the two aspects of the proposed committee amendment that were discussed between FLAC and OCFS since the public hearing.
Thank you very much. And I'm just, because I was having a little bit of a hard time following that. Peggy, could you please screen share the proposed committee amendment with us?
Yes.
And then Representative Reckett, once we've, because I just personally need to visualize it, then I'll take your question. Is that okay? Okay.
I did email it to you and I did upload it to the portal. But let me make this bigger. That's smaller. Okay, whoa. Okay, so this is the first one. It would be adding a new paragraph G, and this is where I totally blew the answer to Representative Reckitt's question. It would add a new paragraph G at the top of page 3, right after F and before the 3 that's crossed out. So the court makes a report to DHHS when this process is happening. And then the next piece is in the new subsection 3A, paragraph B, subparagraph 2, division A, adding this bold language about the parent's conduct demonstrating an intent to permanently forego all parental duties or relinquish parental claims regarding the child when it results in harm or threat of harm to the child. So I think I can also do this. Here, I learned this new skill. Let's see if this works. So this is the bill, and this is where paragraph G would go. This is page 3. And then this is where that new language would go in a division A.
That's pretty nifty.
I'm not sure I can make it get bigger though.
That's great. Thanks, Peggy.
Are you set?
I personally am, but let me just ask other committee members. Does anybody have questions while that require screen sharing? If so, please raise your electronic hand because I actually can't see anyone right now. All right, I'm not seeing any hands, so go ahead, Peggy. Thank you. That was really helpful. And now, Representative Reckett, did you have a question or a comment?
Yes, I'm very concerned because I don't think there really is any precedent for judges being mandated reporters, and certainly not just when they've received a petition. I think that you have to understand the dynamics of survivors of domestic abuse, whose children are most often used as weapons against them, or their custody and their, there's the department. Once the department gets involved, it's just a huge burden on the survivor, and whether or not the department's going to get involved happens from a variety of sources already. But it seems to me that to add get the word I want to use, but the gravitas of a judge making that report will scare the bejesus out of the survivors. And I am worried that as a result, they will be less likely to make this kind of petition, which may very well be important for the safety of the child. So I think I would like to know, who's been observing that these cases are not already being reported by somebody. There's so many mandated reporters around these families. I mean, I was a mandated reporter, as was 30 people on my staff. There's probably 200 people in the state, just in the domestic violence network, who are all mandated reporters, as are anybody else who sees anything about this child. But I'm just really concerned about adding another whole layer of mandated reporters. I absolutely believe it may well be that in the course of a consideration of such a petition, the judge may feel that it's really necessary to notify the department. That may well be. But I think when you look at a whole class of people as mandated reporters who are not trained, frankly, to be mandated reporters, all the rest of us who are mandated reporters, or I'm not anymore, but I was, always went through trainings probably every year on when's the appropriate time, what do you do, how fast do you have to do it, who do you have to do it to. There's a whole rigmarole system that was actually developed by the Muskie Institute some time back that's followed by all of the domestic violence and I assume sexual assault people who come in contact with these families. But judges, God bless them, and I'm a fan of judges. I think you might have gotten the impression over the months we've been together. But I don't know that I'm a fan of judges being a mandated reporter on this potential crime, because I think it's going to intimidate the heck out of survivors were they to know that. They would be terrified of what they were going to say to that judge. They're already terrified in these circumstances because they're very concerned they're going to lose their kids. And so it's really, I just am not happy with the first of the amendments, the short version of my concern.
Thank you, Representative Rackett. And I guess let's get some feedback from Professor Smith. And then also, Professor Smith, if you could include in your thoughts on Representative Rackett's concern, whether you've spoken to the judicial branch about this change as well. Thanks.
Yeah, absolutely. Happy to. I have not spoken with the judicial branch, although I have spoken with the judicial officers who are on FLAC. So there are, of course, some judges who are members of FLAC, and they are aware of that. And it did not raise any concerns for them. And I could only speculate. As I said, my understanding is that there have been occasions where court representatives have made reports to the department, even if it's not mandated to, but out of concern that something may need to be investigated. So it did not stand out to them as truly being a significant change. That's all I can say in terms of what was reported to me, but I have not had any discussions with anyone in the capacity of the judicial branch. And I don't know if a representative from the judicial branch is here today who could perhaps address that specifically along those lines. So I will say that this was something that was requested by the Office of Child and Family Services out of concern that there may be unreported, uninvestigated incidents of child abuse that should come to the attention of the department, even if the parents' rights are ultimately terminated. Perhaps there may need to be a substantiation finding that would, as part of the department's normal process of investigating allegations. So, like I said, this request did come from OCFS.
Could I ask Anne if we could invite into this conversation the representative from the domestic violence programs that I think is in the participant list?
Is that Andrea Mancuso?
Yeah, Mancuso, yeah. She's a lot closer to it than I am at this point.
While she's, did you have a question that you were gonna ask her, Representative Rackett?
No, I would just like to have her commentary on this proposed amendment.
Thank you. Go ahead. First of all, welcome Ms. Mancuso to the Judiciary Committee, and thank you for listening this afternoon. And we would welcome your comments on this issue, please.
Thank you, Senator Carney and Representative Rackett. Good afternoon, members of the committee. I really appreciate Representative Rackett's comments and would echo her concern and urge you all to really think very cautiously about creating a mandated report for our judicial officers. I think our network has a concern that it would have a chilling effect on litigants, particularly survivors and low-income survivors who tend to get a disproportionate amount of DHHS's attention, sometimes with mixed results. I think it also represents a slippery slope towards other types of proceedings. As Professor Smith noted, judges now have a practice of optionally making a report to DHHS if, after hearing some of the facts and the testimony from the litigants, they believe that facts warrant it. And I would urge you to trust our judges to exercise their discretion and evaluate when that needs to happen, as opposed to risking a litigant having to choose, on the one hand, filing and having to navigate a companion DHHS investigation, or avoiding filing a proceeding where safety for themselves and their child might actually be enhanced. I would also point out that the initial requirement for filing this petition is that there has been an order, a parental rights and responsibilities order, in place for a full year, where the offending parent has had no contact with the child. Oftentimes that's going to mean no contact with mom either, no access to records. There's not this type of a petition, because of that baseline requirement, will not involve imminent or present or recent abuse or risk to the child. What the litigant is alleging here in bringing this petition is that future involvement of the parent who has used abuse is likely to cause serious harm to the child. The child's not in present danger. And so I think as you look at the benefits and the potential costs, the balance here doesn't support creating a mandatory obligation for our judges to bring in the department on the basis of a petition that's filed in these cases. So I appreciate the opportunity to share some concerns with you, and would really urge you to have caution about supporting this paragraph.
Thank you, Ms. Mancuso. And Senator Keim, did you have a question that you wished to ask now or later?
I don't know about Senator Keim. I have my question is whether or not Ms. Mancuso has a commentary on the second part of the amendment.
I had the benefit of working with FLAC a little bit on this bill, and was part of the conversations that have taken place over the last year to 18 months. And I'm very grateful that FLAC addressed many of our concerns in the development of the original legislation that went before you. So I don't have concerns about the second piece of the amended language. I think that appropriately just restates the standard that was already put in place.
Thank you.
Committee members, do committee members have questions for Professor Smith or Ms. Mancuso regarding the first suggested revision? Senator Keim, go ahead.
Thank you. Nice to see you, Professor Smith. I don't have a question specifically about the amendments. I wanted to ask you about just a little bit about the background process with FLAC, and if when this bill was, I know it's been, I think you said a year in the making, and just, is there reservations on the part of any of the members around any portion of this bill, things that you could highlight for us that maybe weren't, that folks weren't in 100% agreement on?
Yeah, thank you, Senator Keim. Yeah, I'll just very briefly mention it was far more than a year. And I mean, I think you're familiar with FLAC and the perspectives of FLAC and the membership of FLAC. And FLAC does also obtain input from folks such as Ms. Mancuso, who was invaluable in terms of assisting FLAC with bringing all the considerations and making sure that they were reflected in the final bill, as well as Assistant Attorney General Debbie Willis, with respect to what she has seen for some of these proceedings in district courts around the state. So I'm happy to answer more detailed questions about the process, but it consisted of a lot of research, a lot of conversation, reviewing numerous different variations on the proposed language, and talking through it in extensive detail. And I have always enjoyed working with FLAC because everyone speaks up and they have really useful insights from a range of perspectives to offer. And I think that this final bill reflects the product of input really from every single member and all that they've seen FLAC did highlight in the report that it submitted to the committee one area where there was not complete consensus. And so that was the only area in which there was not complete consensus. So that was highlighted. And the one area that was described in the report had to do with when a parent consents to the petition to terminate their parental rights in these serious harm, threat of serious harm. There were some members, I would say it was minority of FLAC, that thought that there should not be a requirement of making specific findings, that the allegations, there was evidence to support the allegations of serious harm or threat of serious harm, that parent's consent should be sufficient to grant the petition to terminate parental rights. The benefits for that, as explained in the report, would be to eliminate the need for the petitioner to have to put on proof of that there was a basis to it. Other FLAC members were concerned that there could be, that there might not be proof for this very, very drastic and serious and permanent lasting legal measure that would be severing the legal parent-child relationship, obviously depriving someone of their constitutional rights, without there being a factual basis for it. They wanted to ensure there was a factual basis for it. There was also some concern that there could be perhaps pressure put on a petitioner where there wasn't perhaps the full factual basis to it, but a pressure put onto it even from the parent whose rights were being terminated to try to get out of a child support obligation or some other parent responsibilities. So ensuring that there's a true factual basis for it would essentially eliminate the ability to do that. And FLAC members, also the majority of FLAC members, felt it was very important for the judge to exercise their role to make a best interest determination in all such cases involving the threat of harm and serious harm. Again, preserving the existing law with respect to conception from sexual assault.
Thank you, that's helpful.
Committee members, are there additional questions either for Professor Smith or for Ms. Mancuso? And I don't know if committee members are aware, but we do have Debbie Willis also in the attendee portion of the meeting if anybody wanted to hear from her. I'm not seeing any questions at this point. Let's open it up to discussion among committee members, either on the bill itself or with regard to the proposed committee amendment. Go ahead, Representative Moriarty.
Thank you, Madam Chair. We've absorbed a lot of new information this afternoon, and at the same time as having listened to it, we've had to sort of put it in context. I'm wondering how difficult it would be to obtain a new copy, a new draft of the bill with the two amendments shown in green or blue or whatever, just to distinguish them from the other underscored language for our review. I guess I'm suggesting that I'm not quite ready to act on this at this point.
Would it be helpful to committee members, because we've also been going for over 2 hours at this point, could we take a 10-minute recess and then reconvene and decide whether we want to move forward with a vote or table? I just feel like a little bit of a break to digest all of this would be really helpful. Is that okay with everybody?
Sure.
Okay. So it's 4:12 now. Let's rejoin the meeting at 4:25. Is that okay with everybody?
Sure.
All right, great.
Okay.
Thank you.
Wait, where am I?
Lois, we can hear you, but we can't see you. And you're
Well,
echoing.
I think I'm in 2 Zooms at once, you know?
You are.
So I got to get out of one of them.
I can turn you off one of them if you'd like me to disconnect you.
That would be great.
I say that, I'm not sure that I could do that. Let's see. All right, now, I think we only have one representative Reckitt now. Lois, are you still on?
Yes, I am. I don't know that I'm visual, but I'm on. So let
We
me
can hear you.
Yeah, I can hear me too. Well, that's good because I'm sitting right here with me, but let me see if I can click here to join and not come in twice.
All right, it looks like we're back. So
am I only one here now?
There's just one of you.
I think part of what I think I need to do is get off my iPad, which is what I was on. So let me just shut that off and then come in the other way.
Okay. Welcome back, everyone, and thank you for the short break. Senator Keim, go ahead.
Thank you, Madam Chair. Yes, if the committee's amenable, I would move to table this bill and just give us a little more time to digest the language and what we're considering. It is big. Obviously took experts a couple of years apparently to work on. So I think I would feel better with a little more time. So if the committee's amenable, I would move to table.
Representative Hagan.
Thank you, Madam Chair. I have difficulty receiving an amendment same day as a vote with several minutes left.
For a second to the motion?
No, I'm not. Yes, I'd like to second that, I guess. But I'd just like to say that I don't like receiving amendments just before votes. It troubles me greatly, and it makes me want to vote no on something I may have voted yes on. Just because I can't stand voting for something that I really don't know, I haven't had a chance to look at or digest. And I would want to table or you know, I'd rather, if we have to receive an amendment and then vote on it, generally even if I like the bill, I can't do it. I can't vote for something I don't know much about or have had a chance to really get into and think about, having seen it briefly, extremely briefly. So I wish we wouldn't do that. And if we do, just go to a table and finish the bill later after we've had a chance, say a day or so later, to digest
I think
the
a
information.
motion to table is not debatable.
No, I'm just expressing my
You can't do it.
concern. I'm not debating.
So on all those
I'm not
in favor,
talking about debating.
all those in favor of tabling, please raise your hands.
Madam Chair, may I ask that you raise your electronic hands?
Thank you.
Representative Hagan?
Did I do it?
Perfect. So I have 11 members voting to table and 3 members are absent.
Representative Babbage has lowered his hand.
Oh, you're not tabling?
May I continue?
No, I mean, I am tabling.
Do you want us to keep them up?
No,
You're all set?
that
Okay.
was perfect. Thank you.
All right. Thank you,
Yeah.
everyone. We covered a lot of ground on this bill today, so I'm going to not shake my head so that I can remember it all for when we vote on it. And thanks, everybody, for your hard work on LD 1030. That has been tabled. And so now we will move on to our final bill, which is LD 1068. Go ahead, Representative Hagan.
I'd just like to finish my thought, if I may, and that I don't like receiving amendments and then having to vote. This will be the third year I've been on judiciary. It happens all the time. And I would like to say that if this happens, I would like to just do an automatic table as opposed to just getting into voting. It's really difficult to vote on what you don't know.
I
can't do it.
I appreciate your desire to have amendments ahead of time, Representative Hagan. I agree with you that that's ideal. We're at a time in the session, and because our committee has 170 bills, it's would be challenging to always have an amendment ahead of time. It's just a little bit.
Yes, bills like this are really important bills. These are big bills. And if we need to take extra time in the night or what have you, say tomorrow or whatever, I think it's really critical and important that we don't vote for the sake of voting to get rid of bills, that we vote intelligently and have an opportunity to look at these things thoroughly with a clear, crisp mind, and then do a correct vote for the people of the state of Maine. That's all I have. Thank you.
Yeah, I don't think anybody agrees with you. I mean, disagrees with you about wanting to do our best job for the people of Maine. I think as a practicality, I mean, we're all working very hard. We're in committee meetings from 9 o'clock in the morning until late in the afternoon every day. And we are all working as hard as we can to get the committee's work done. Did somebody else have a hand raised? Thought I missed it. No. Okay. Oh, Representative Babbage, go ahead.
I just wanted to say I'm sympathetic with Representative Hagan's comments here. I also understand the reality of the task of this committee, and I think the committee. I mean, if each of us as individuals has reached a decision, laboriously so, it is frustrating to table, but we don't all arrive at that point at the same time. And I think we have been observing each other's, through courtesy to vote as we just did to table. So I don't think there's disagreement on anybody's part here, actually. Thanks.
Any other comments on tabling and amendments? Not seeing any. All right, great. Thank you. At this point, we're going to move on to our last work session of the day. That's LD 1068. I did want to raise for committee members. So that's a bill that I sponsored. And we do have a committee rule about bill sponsors not questioning other people who testify on bills in public hearings. That doesn't apply to work sessions, but I did want to raise that and let people know that because my co-chair, Tom Harnett, is not available this afternoon, that I will be running the work session on LD 1068. And with that, does anybody have any questions? Not seeing any. So with that, we'll ask Peggy if you could please begin your bill analysis.
Okay, great. Thank you. So LD 1068 is an act to restrict access to weapons pursuant to court order in cases of harassment. So I'm just going to tell you what the bill does, and if you want more information about context or protection from abuse, let me know. So this bill amends the protection of harassment statute, which can be applicable to anybody who engages in conduct that is harassing, and the statute defines what harassment is. And in some cases, it has to be 3 or more instances of conduct, and or it could be a single act or course of conduct constituting a whole series of crimes. And what this bill does is it specifically says, it specifically gives the judge authority in ordering relief. The judge has already found that somebody has engaged in harassment, and now there's going to be an order to, the protection from harassment order can direct the defendant not to possess a firearm, muzzle-loading firearm, bow, crossbow, or other dangerous weapon for the duration of the order. And if the court does that and says a dangerous weapon, the court has to define what that is. And so Section 2 of the bill kind of gives the process, what happens if the court prohibits the defendant from possessing one of those weapons. Then there's the process where the defendant has to relinquish the weapon within 24 hours. And how, when the defendant gets it out of the defendant's possession, what happens, where the police can confiscate it. Senator Carney sponsored an amendment that she had distributed before the public hearing, and she introduced it at the public hearing, which allows that same order to be issued on a temporary order. So harassment orders, if it's an emergency situation, the court can issue an order ex parte. So it immediately has to happen to protect somebody, because the order can be used, for example, by a business if somebody has been threatening the business. So this would allow an ex parte order to require that the defendant not possess a weapon. So that parallels the Protection from Abuse Act. And the current law provides that if there's an ex parte order, the defendant, the person who's the recipient of that order, who's subject to that order, can go to court and ask for it to be reviewed within 2 days. So I don't know if you need me to go through all the details of the amendment. That's what it does, that the bill applies to an order that's issued after the opportunity for a hearing. And the amendment says same thing, but we're going to allow it in an ex parte when there's an emergency situation. So I'm going to stop there because I could go on forever. And you can ask me questions about this or about the Protection from Abuse law, or you can ask me about the policy, the law enforcement agency policy about taking possession of firearms and what they're supposed to do to keep them safe.
Thank you very much, Peggy. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Peggy, I'm just curious. I don't see anything in front of me, but that doesn't necessarily mean that there's not something there that indicates, is there a different, trying to think of, form of harassment? In other words, is there verbal harassment or threatening harassment or annoying harassment? Does it have to reach a level in order for this to take effect, that weapons come into play or seizing of weapons comes into play?
You're asking, for example, does a weapon have to be used in the intimidation or the threatening in order for the order to be issued?
No. In other words, I've harassed somebody, but I haven't threatened them. Okay.
Right.
I'm an 89-year-old woman who has no weapons, but I've been accused of harassing somebody. Does this automatically say that they got to step in and issue a search warrant to seize my weapons? Because there's no saying I'm just wondering if there's a different type of harassment that constitutes this, or does it have to be that there was a physical or verbal threat of harm in order for this to go into effect? Or is it just, if I harass, then this kicks in?
So the court is authorized to issue an order that's necessary to bring about whatever's happening. The cessation, it says, the court, this is section 4655 subsection 1. The court, after hearing and upon finding that the defendant has committed the harassment alleged, whatever that is, may grant any protection order or approve any consent agreement to bring about a cessation of harassment, which may include the following. And Senator Carney's bill would include surrendering the possession of a weapon. So whatever is in the order is supposed to be designed, the judge can select and can craft the order to stop whatever the harassment is that's going on. If the dog is barking, then I don't know that that actually works, because I'm not sure if that's intimidation, confrontation, physical force, or intimidation to or damage to personal property. But if there's somebody building over the property line and is I'm just trying to think of a harassment action that does not rise to the level of where somebody is actually threatening use with a weapon.
Right.
Where somebody's intimidated. It could just be a lot of yelling outside a business. I don't see that a judge would find that telling the people out there who are causing a commotion outside the business to not possess firearms is going to resolve that. The order would direct them to be off the property. So it's kind of discretion, but the order has to be designed to stop the harassment that has been alleged and that the plaintiff has proved. I don't know if that answers your question, but I think that's
you gave a noble attempt, but it really didn't. I guess I'm just trying to get into the, if my form of harassment is my dog's barking, and then he goes to a judge and gets a harassment order because my dog barks at him at the fence. And then he's also going to say, by the way, because you got a harassment order, we need to seize all your weapons. If I've never threatened him, does it automatically kick in, or is it only when harassment involves a threat, or, that's, I guess, what I'm trying to get at.
Right.
Does it?
I do understand your question. Nothing automatically kicks in. The judge is supposed to look at what's happening and put whatever's in the order to stop the harassment.
But it doesn't specify that in the language of the bill. That's just open to interpretation.
Well, yes and no. I don't think there's anything that says this automatically has to be part of an order. None of it, none of the options, A through H. I don't think any of those are options that have to be part of an order. The order has to be tailored to the type of harassment that's happening that brings the parties to court. For example, paragraph I is prohibiting the defendant from destroying, transferring, or tampering with the plaintiff's passport or other immigration documents in the defendant's possession. That was added because people who were involved in victims of human trafficking were stuck in a situation where the person who was controlling their work or their housing was confiscating their papers, their passport, and they couldn't do anything about it. And so they could go to court, say, this is what this person is doing. The court could order the defendant to provide those back to the victim of the human trafficking. But that doesn't mean that in that situation, the court is also going to say, defendant, stop destroying this person, stop making noise outside the building, or don't go on the premises of the plaintiff's residence.
Right.
The order is supposed to be tailored to whatever the harassing conduct is. I'm not really sure a barking dog rises to the level of a protection from harassment order.
No, I'm just
No,
trying.
but no, you're right. I think I started to use that as an example myself.
There's many different types of harassment, and my question was just that, according to the words and the verbiage that I'm reading, if there's a case of harassment, regardless of whatever the harassment or whatever the type of harassment is, that this says you restrict access to weapons, and it doesn't specify the type of harassment. If there's harassment, this kicks in. That's the way I interpret it.
I can maybe help out here a little bit, in the sense that harassment in the part of the statute that you have before you that's subject to the amendment does not include the legal threshold for establishing harassment in order to be able to even bring a claim for harassment. That's provided by a different section of the Protection from Harassment Act, and it's Title 5 of the main statutes, Section 4651, and it defines harassment as 3 or more acts of intimidation, confrontation, physical force, or threat of physical force directed against any person, family, or business that are made with the intention of causing fear, intimidation, or damage to personal property, and do in fact cause fear, intimidation, or damage to personal property. Or it could be a single act that is a violation of certain listed sections of the criminal law. So it's actually kind of it actually is a very high threshold in order to establish, even to bring a protection from harassment claim.
Getting beyond that, harassment's been established. Someone's they're a paraplegic, or they're a quadruple amputee, and they have weapons. Does this mean that the judge is going to say, you got weapons, you got a harassment order, I'm going to seize your weapons, just in case you figure out a way to use them because you've made harassment or threats? You got no way to physically use them, but you possess weapons, so I'm going to confiscate them. Is it an automatic? Am I wrong in assessing that? Or is it only at the judge's discretion that he's going to ask and determine if there's weapons and whether or not they need to be confiscated? Or is it an automatic that the judge is going to say, okay, you got a harassment order, you've established that threshold, you're guilty of harassment, if you have weapons, I want them? That's what I was trying to get from Peggy, is it an automatic? You've been guilty of harassment, so therefore, if you have weapons, you need to turn them over. That's what I guess I'm trying to get at. If this bill says, if you're guilty of harassment, we're going to restrict access to weapons, period. There's no discussion, there's no arbitration, there's no judge interpretation of whether or not you're going to use them. If you're guilty of harassment and you own weapons, we're going to go in, we're going to confiscate your firearms, your crossbows, your bow and arrow, your muzzle loader, and any other dangerous weapon you have in the house. That's my question.
So my understanding of the protection from harassment law is nothing is automatic. So that would not be automatic. If the judge thought that was necessary, if the harassing activity is threatening someone with a firearm, then that would be something that the judge would consider and might include that in the order, that because this person is threatening others with a firearm, it's appropriate to remove the firearm so the person is no longer engaging in that harassing conduct. If the person is threatening someone with a wrench, I mean, a dangerous weapon is based on how it's used. So somebody has, a great big pipe wrench and they're
So the judge is
facing
going
their
to say,
neighbor around
hand over all your wrenches. You didn't threaten them with a firearm, so your firearms are okay. You threatened them with a wrench, so we're going to confiscate all your wrenches.
Well, or at least maybe the wrench that they're using. I mean, those little teeny ones. So the law is written to allow the judge to identify what behavior needs to stop, and that's what the order says.
Okay. Thank you, Peggy.
I've
been very helpful. Thank you.
You're very kind.
Okay, I think Representative Libby was next, and then I have no idea what the order was. So go ahead, Representative Libby.
Thank you, Madam Chair. Peggy, I have a couple of questions for you. I am very concerned about the burden of proof and due process. And I understand that there is process here. I'm just not convinced that it's the due process. So two scenarios that came up frequently in testimony I would like to run by you. One is, I'm a really annoying neighbor. I mow my lawn at 5 a.m. every Wednesday and Saturday. My neighbor can't stand me, plus I'm just really annoying in other ways. Can that neighbor, I mean, theoretically, what would that neighbor have to do if they were so angry that they just, well, I'm just going to file one. I'm going to make up some stories and file for a protection from harassment because my neighbor's really driving me crazy. Not true, anything that they say when they file their protection from harassment. But they're pretty litigious and they feel angry about my habits and my annoying things that I do. And so they decide that they're going to say that I've threatened them 3 times or that I've threatened them really severely once. What is the due process and the burden of proof to show that I truly have before my constitutional rights are stepped on?
So I'm assuming that there can be an ex parte order, and if you're, I'm forgetting who the plaintiff is. Is it you or your neighbor?
No, I'm the annoying one.
You're the annoying neighbor. So yes. Your neighbor says she's engaging in horrible conduct and goes to court and says, in fact, I'm worried about.
I think she's gonna come after me. I think she might even come after me with a firearm. She's that unhinged.
So your neighbor can go to the court and ask for an emergency order, and has to make a reasonable showing. It is a one-sided showing for an ex parte order. They have to swear that it really is true that they're in danger and that you did come after, you came after her with a firearm, and so she might get the order. And as soon as it's served on you, you have the ability to go to court and ask the court in 2 days, and the court needs to respond to modify or get rid of that order. So and that would be a hearing for both of you. And at that point, I believe that the plaintiff, your neighbor, would have the burden of proof of showing that order needed to stay in place.
So is that burden of proof, that hearing, that we are both at, is that before or after my weapons are confiscated?
So I'm not sure how fast the weapons could be confiscated in that situation.
Because this says 24 hours, but I'm unclear when that 24 hours is.
Right. The amendment would authorize that to happen, I believe. Relinquish within 24 hours after service of the order.
Which would be before a hearing, in all likelihood.
In all likelihood, yes.
Okay. So the same thing, if there was the scenario we heard in testimony multiple times, if there was someone who had been abused and and they had gotten away from their abuser, but their abuser decided to use this new statute to go after them again, they could theoretically lie, file a protection from harassment, and continue to, using protection from harassment, continue to harass that person. That's correct? Theoretically?
I guess, theoretically, I'm not sure that would work more than once. Because they would have to, they might be able to get a temporary order, an ex parte order, but as soon as they were in a hearing, then just like in your situation, the court would find out what the actual facts are.
Thank you.
In a protection from abuse case, that could happen as well. If they fall into the family or household member definition, they could be using that now and wouldn't have to rely on this change in the law.
Thank you, Peggy.
All right, and then when I called on Representative Libby, I think Representative Moriarty and Reckitt had their hands up, and I don't know who was in what order, so go ahead, Representative Moriarty.
Okay, thank you, Madam Chair. In my file, I have a 2-page proposed committee amendment, which adds a section 2-A to Title V, section 4654, which seems to allow the court to direct the offending party not to possess firearms and so forth if the complaint demonstrates that harassment involves firearms or the other designated weapons. I'm unclear whether this is really an amendment that's before the committee now, or I printed it on, well, it's dated April 5, which was the day before our public hearing. So I'm not clear what the status of this is.
So Senator Carney is the sponsor of the bill, and she sent that out ahead of time. She wanted to make sure it was included in consideration of the bill. So we distributed it to all the interested parties as well as the committee, and she offered it as an addition to her bill. So, and you were right that it does, for the temporary order, the complaint does have to demonstrate that the harassment involved the dangerous weapon.
So to going back to one of the questions raised a moment ago, if the harassment involves a barking dog and nothing more, the court would have no authority to order anyone to turn over firearms.
Certainly not under the proposed subsection 2A.
Okay. Okay, thank you.
Representative Reckitt?
Seems to me that there's a large-scale misunderstanding about how often or whether the police will even do this. I mean, this is the law in domestic violence cases now, and I could challenge you to find 20 cases in the state in an entire year where somebody actually did that. And part of the problem is that most victims are terrified that if they try to do that, it's going to get much worse, so they don't. But mostly the police, before they will pick up weapons, they will tell you there's no place to safely store them. The weapons might get damaged in storage and they'd be liable. And so we've never been able to answer the problem of where do you put these weapons so the weapons will be safe, never mind the people. But the point is that the police are very reluctant to do this. The judges are very reluctant to order it in domestic abuse cases. I can't even imagine they're going to be gung-ho in harassment cases, particularly not without totally clear and present evidence that somebody's about to get shot. So I can't even, I mean, to me, it's a very minor piece that will only be invoked, 5 times a year, maybe. But even then, I'm not sure that it will be invoked, because they may get invoked, but whether the guns actually go away, another problem entirely, because there is a huge resistance to seizing guns for any reason. And I've talked to police department after police department who claim they don't have a way to do this because there's no place for the guns to be safe. Now, my personal view is less charitable about that statement, but the reality is it's made all the time. So I don't see this as a big deal, in the sense that, my harassing neighbor was from fireworks. I didn't get a harassment order. I went to the city council and got fireworks banned. So it's like, there's other ways around these things. But the reality is I don't think it's going to be effectuated very often. But on the moments when it needs to be, when you've got a neighbor who's waving a gun at you that's not related to you in any way, shape, or manner, I would want to be able to go to a judge and say, oh my God, somebody's got to do something. So anyway, I'll be quiet now. But I mean, it's really, it's not a simple matter to seize guns, is the end of my discussion.
I think that I'm losing track of people because their squares are moving around. I think Representative Hagan and then Senator Keim. I think that's the order of hand raising.
Well, I actually, Representative Babbage was before me and Senator Keim, so I would gladly defer if you'd like.
Well, why don't you just go ahead? Because
You want me to go ahead?
Yeah.
Okay.
Thank you.
Well, thank you very much, Madam Chair. I appreciate it. I do have concern with this bill in a lot of ways. One, Peggy, is a question that I have. I'm a deer hunter and a bird hunter. I have a concealed weapons permit, like one of the ones you take the class for and do all that. You pay the money and blah, blah, blah. But I don't carry a concealed carry. I just like to deer hunt. And my wife is a more avid deer hunter than myself. And one of our kids is a hunter. We have about 40 firearms in this house right now. I'm looking at about 10 of them right over there. If, say, one of these harassment issues came upon me, and the police came and they confiscated the dangerous weapons, which I have about 40, like I say, my wife, her Second Amendment constitutional right to be able to go hunting, and my son would be denied them. Is that true through this bill? I can't hear you.
I'm muted. That's a good question. And I don't know that is, it depends what the definition of possession is. Is it possible for you to relinquish possession, but them still to be available to your wife and your son if they're not part of the harassing activity?
Well, under this bill, don't the police have to confiscate all dangerous weapons? They couldn't leave 2 or 3 rifles, because if I still dwell in this house, I would have access to them.
If the order said Representative Hagan may not possess any firearms, then the police would be responsible, I believe, that the court would direct that you have to relinquish your firearms, and that within 24 hours, after the order is served on you.
Is there anything in the bill? Go ahead, sorry.
To either a law enforcement officer or to another individual for the duration of the order. So if your son lived in another place and him having possession of them did not mean you had possession of them, then you could do that to comply with the order.
Well, let's say my son and my wife live in this place, and I've moved here just recently, and I don't have any friends in the state of Maine. My guns, all of the guns, according to this bill, would have to be relinquished to the state police or sheriff or municipal police to be impounded, and then the Second Amendment rights of my other significant others would be denied.
I know that in the past there were opportunities for other people who had rights in those weapons would have an opportunity to make that case, that depriving you of those, of making you surrender those was depriving them of something. But I don't know that I don't know what the weighing is that goes on in that situation. It must, there must be something established if it happens at all under the Protection from Abuse statute. I know that Representative Reckitt says it hardly ever happens. The court hardly ever orders the surrender of firearms or other dangerous weapons in the Protection from Abuse situation. But there must be a balancing that goes on there for somebody to figure out those issues.
Well, the fact that the courts might or might not wouldn't matter if this becomes law. Is that true? Whether they do a lot or a little. I just was curious in thinking about it. This is a question that I had when we did 1811, and we're not talking about 1811, and I know that from a year ago or so. But it was a question that I had, and it was a curious question, and they did find ways around it, or they thought they did this and that. And I was just curious about if I'm an unstable person or what have you, or I have a harassment thing against me, how do we get around in this bill the denial of the Second Amendment rights of the people that live here? And there is the case in the bill where it could go to, say, my neighbor, but if I don't know my neighbors and everything is gone, is this a violation, or am I a little off base? It's not a, I don't know the answer to it. It's not a loaded question. It's just a question that I have that I haven't seen as I've read through this thing.
And to tell you the truth, I don't know what the answer is to that. And I know we talked about it in the context of 1811, and I think the bill before that was 1312. And I must admit, I don't know, and I certainly don't remember what kind of resolution we came to. I don't know if there's anybody else who has an answer to that, or who's worked with a domestic violence court that has actually taken, made somebody surrender their firearms. I don't know.
Well, I thank you, and we'll just keep going forward. Thank you very much.
Thank you, Representative Hagan and Peggy, for trying to answer those questions. We do have both the Attorney General and an Assistant Attorney General who is really familiar with the Protection from Abuse law, which is the law that these provisions were essentially imported from. And so I'm going to admit them to the panel, because I think that will help us. That may help us get answers to your questions, Representative Hagan.
Pardon me, I missed that.
What's that?
I'm sorry, I missed the last couple of sentences that you said.
Oh, that's okay. I think that I've invited the Attorney General and Assistant Attorney General Laura Usack onto the panel because they, particularly AAG Usack, is familiar with the protection from abuse statute, and I believe that they may be able to help answer some of your questions.
Well, I appreciate it. Thank you very much.
Welcome, Attorney General Fry and Assistant Attorney General Usack.
Thank you, Senator. And just before I hand it over to Laura, I appreciate the question that Representative Hagan was asking, because that's when I was in private practice, that ended up coming up quite a bit when I'd represent individuals who ended up losing their firearm rights because of a domestic violence conviction, because of protection from abuse order, because of a felony conviction. And that is a challenge that families face when when there's an order that applies to one of the individuals in the household. The right to use, possess, purchase firearms by the non-ordered family member is only infringed in that they don't get to choose to keep the guns in one particular place where the prohibited person has access. I understand that creates some complications about how that family member would be able to use, purchase, possess. But that is something that families already deal with for firearms prohibitions already. So I don't know that, I understand that might not be satisfactory under the fact pattern that I heard you lay out, but that's already something that exists when there's firearms prohibitions. And the bill does, the amendment does mirror what the protection from abuse statute provides for, where it does have the ability to hand over the guns to an individual, which, by the way, might be a family member who maintains those firearms in a storage unit in a safe place that is separate from where the prohibited person can access. There's no prohibition on who that individual would be in the statute that mirrors the PFA. And I'm looking to Laura Usack. I don't know if she has anything to add to that, but hopefully I didn't misrepresent how this works.
Well, thank you. I appreciate that.
I'm sorry, Attorney General Fry, good afternoon, members of the committee. I do not have anything to add to that very complicated logistical question that arises when you have an order, whether it comes from a protection from abuse order or a bail condition or a probation condition or a person's status of having been convicted of a felony level crime. It presents a very real logistical problem for the persons in the household. And an order stemming from a protection from harassment order would present the same type of issue.
Thank you.
I think that you're next, Senator Kime.
Thank you. Thank you for bringing the AG and Assistant AG on, because they were who I was going to ask the question to. I had sent this question, actually had reached out to Chris Taub about this, but my question I had two. One is that existing law authorizes a court to impose any other orders deemed necessary or appropriate in the discretion of the court, which would be including an order prohibiting a weapons possession when issuing a protection for harassment order. So I was wondering if one of you would answer why you thought that this extra language was necessary and how that is not covered under current law.
I'm going to defer to Laura. We had talked about this earlier.
Good afternoon, Senator Kime. Chris did mention that question to me, and that's something that I looked into very quickly. But what helped me is I went back and I looked at the history of the addition of the specific language with respect to authorizing the court to prohibit firearms in the protection from abuse statutes. And the protection from abuse statutes also have that catch-all language where the court can enter any other appropriate order. But in 1997, the legislature introduced the explicit language regarding firearms. And buried in the statement of fact to that, the summary to that LD was a statement saying that this doesn't mean that we're not doing away with the court's general authority under that catch-all provision with respect to firearms, but we are adding this explicit authority with respect to firearms. But what it was doing at the same time in 1997, it had also added some language related to firearms regarding whether or not the defendant presents a credible threat to the physical safety of the plaintiff. And the Maine Law Court in subsequent decisions tied the explicit firearms prohibition to that credible threat language. So you have that linkage of the two concepts, the explicit prohibition of firearms and the credible threat language. What that 1997 language was also doing was making the protection from abuse statutes consistent with requirements under federal law, so that an order for protection from abuse issued under Maine's protection from abuse statutes would qualify as it would be a qualifying order under the federal statute that prohibits possession of firearms if you're subject to a certain type of order. And that type of order, and you've probably heard this before, but there has to be notice, opportunity for hearing, a specific prohibition not to harass or threaten or assault or stalk the plaintiff, and also that the defendant represents a credible threat to the plaintiff. So there's a lot of history here. And if you are tracking if you're tracking the protection from abuse statute, one of the things you may want to consider is including in the protection from harassment statute the same credible threat language that's in the protection from abuse statute. If you go back and look at that 1997 legislation, it was added at the same time as A1 was added to, I think it's section 4007 of 19A. The credible threat language was added.
So just to clarify that before I move on to my next question, but so you're saying that in 1997, Maine legislators crafted law to mirror federal legislation around protection from abuse? I didn't quite understand how we were trying to match the federal part. That's why I'm asking you to clarify that.
Okay, so what we did was the legislature amended our protection from abuse statute so that an order issued under Maine's protection from abuse statutes in which the judge made certain findings would qualify as a prohibiting order under the federal law that prohibits possession of firearms.
Okay, I understand. Okay.
Because any old protection from abuse order doesn't prohibit possession of firearms. It has to include certain findings, and on the form itself, certain boxes have to be checked representing specific findings made by the judge. And if the order doesn't include those findings, then firearms are not prohibited.
Understood. Okay. And then, so one of the major concerns I have with the bill, and I don't, whichever one of you would like to respond to this, but so with the protection from abuse, we're limiting it to the people who have a close relationship, right? A household or familial sort of relationship. With this order, it can be anyone, right? There's no relationship. I don't even have to know the person at all that's saying I'm harassing them. And there's no due diligence required on the part of law enforcement to go check on this at all, right? There's no check for that.
I guess I'm not clear on, I mean, yes, you're completely right that the protection from harassment statute applies to a different group of plaintiffs and doesn't require that there be a family or household member relationship or that or the other types of relationships that are recognized in the protection from abuse statute. So yes, it can be neighbors, for example, in the protection from harassment statute. But I apologize, I didn't quite follow what you're asking about the law enforcement.
Right. Well, I guess I was just saying, so since there isn't an obvious relationship, it can be it can almost be no relationship at all. Like there doesn't necessarily have to be a relationship that is that is ascertained before this order gets in place.
That's right, because the order is based on the conduct between the parties, not the relationship between the parties.
Right, and the conduct as reported by one person.
Yes, as reported by one person, and then has to be presented in court. So at that point, it's up to the judge.
Right, but they make this judgment based on one person's testimony, not the other person. In the beginning.
Initially, if there's a request for an ex parte order, yes, that's right. My understanding is that there's not always a request for an ex parte order, and that sometimes there may just be a complaint and request for a protection from harassment order, which gets scheduled for hearing, and nothing happens until there's a hearing.
Good. Thank you so much.
And if I may just add in on that question about police being involved, I think Senator Carney earlier referred the committee to the definition of what constitutes harassment for purposes of a protection from harassment. And one of those definitions, it refers specifically to a number of different crimes. So it's entirely probable that law enforcement may be involved. Because this behavior may involve terrorizing behavior, criminal threatening, assault. You know, you go through all the different type of conduct that triggers a harassment. This isn't exclusive from the criminal process. It just it provides a way for somebody to get to ask for relief from the court through a protection from harassment, from what might happen with a criminal case that could also be pending and have its own orders associated with it.
Mm-hmm. And since this is work session and not a public hearing, I'll just add my comment that to this, that I think that what we just passed, the yellow flag law, really addresses the type of behavior that we're talking about here. And your support of this when it's such a serious allegation against someone, and then to have the court move against a person without trying to just, beef up what we have with the yellow flag and make sure that people are actually able to use it, which we see as problematic. That I find really concerning coming from your office. Thank you.
I would like, as the bill sponsor, I would really like to respond to Senator Kimes raising the concern about the yellow flag, because the yellow flag is a process that really goes initially to healthcare providers to make an assessment regarding somebody's mental health. And that what this bill is designed to deal with is, is not somebody who has a mental health issue, but somebody who is engaging in criminal conduct and threatening to harm another person for reasons unrelated to mental health. And not everybody who commits a crime or threatens to hurt somebody is suffering from a mental health condition.
Right. I think that's a mischaracterization a little bit, because I think we tend to call it a mental health issue when sometimes I think really what we should be referring it to is a mental health crisis. Because if someone is so much at a loss with themselves that they're threatening another person, I would assume that that's a mental health crisis, whether or not they have a diagnosis, right? I think those are two different things. And I think we get confused when we look at that. And if that's what the law is trying to capture, is when people are in crisis, how do we get them help? And it does involve law enforcement.
Yeah, and I guess I see this as more like the case, and I think the name was Renee Henneberry, that caused this committee to change the protection from abuse statute just 2 years ago to include people who were related by marriage as well as by blood. And that was a clear case where the brother-in-law who killed Ms. Henneberry was angry at her and threatened her and shot her out of anger. And that also happens between people who are not related by blood or by marriage. And that's what those are the types of situations, as well as business situations, actually, where this legislation could save lives. I want to move on to, because we have had a number of hands up for quite a while. And I think Representative Babbage has not yet spoken to this, and then Representative Evangelos, who also hasn't spoken.
Thank you, Madam Chair. Yes, I'd like to make a statement and ask if I am accurate in the statement. The harassment qualifications are pretty significant in themselves, it seems to me. And then what we are doing, and this is based on behavior, that the judge, we're giving a tool to the judge that if the complaint demonstrates harassment that involves a firearm or a dangerous weapon, that he judges that there's immediate and present danger to the plaintiff and a heightened risk of immediate abuse, he now has a tool due to that behavior of removing the firearm or dangerous weapon, whatever. And the rest of the bill, and there are specific examples that would be examples of that dangerous behavior. And the rest of the bill, to me, is addressing the Second Amendment rights by making sure that if it's an ex parte procedure originally, that there is a prompt hearing and judicial decision based on that. So, I mean, this is behavior based, and the judge is now given more explicit clarification that he may, if the harassment involves a firearm or dangerous weapon, and he judges that there is an immediate and present danger, that he can use this as a tool in his tool chest. And given the fact that judges are maybe not often confronted with this, but they are professionals who deal with these kinds of decisions, that discretion, in my mind, is in good hands if it saves a life. And my impression, for instance, in Kennebunk here, let's say that we have some homes that have been divided up so that there's an apartment now. If the apartment separate apartment in a dwelling is owned by a family member and they have a gun, it's my impression that that gun would not be seized. It's a separate dwelling. I mean, it's a separate living space, locked, separate entrance within a dwelling. Is there anything that I've said that is untrue, as in the opinion of the Attorney General or Assistant Attorney General or any of the Peggy? I'm looking for criticism of accuracy of something that I've said in order for me to understand.
Maybe if we start, Peggy, I don't know if Peggy could maybe take the first crack at that, or Laura.
I'm not asking for a personal opinion. I'm wondering if there's any inaccuracy in what I've characterized.
I think that's the way it works, that I think that in all these cases, you do expect the judge to use his or her training and experience and good judgment to figure out what's the appropriate conduct to be prohibited in any of these orders. Anytime the judge is ruling to actually tell somebody what they can or cannot do. There are lots of, there's lots of guidance in the statute, and in some cases, you have specifically told the judge what they can consider and not consider. But yes, you are relying on the judicial discretion almost entire. I can't think of a place where it says the judge shall order this result.
Thank you.
Representative Evangelos?
Thank you, Madam Chair. I got a couple of things. First of all, for Laura or Attorney General Fry, if somebody is, in a neighborhood situation or whatever, somebody is threatening somebody with a weapon, harassing or threatening is the way it was worded. Don't we already have a statute called criminal threatening that deals with that?
There is. Criminal threatening, terrorizing may cover criminally that conduct, and depending on how it's threatened, it could be a Class D crime. If a firearm is involved, it would probably be a Class C crime, because it would be terrorizing with a deadly weapon or criminal threatening with a deadly weapon. It would elevate the charge. And so if it's a Class D crime, if there was a firearms prohibition, that would probably only last as long as the criminal case was lasting. There's an outside chance there might be some probation that would be involved. If it's a felony level right, obviously, if they were convicted, they lose their firearm rights to use, possess, purchase forever. So that is a separate way in which the conduct would be addressed.
So Peggy, in some of the scenarios that we've outlined, so somebody's made a complaint against somebody, whether it's a legitimate complaint or not, it goes forward. So they get to Grampy's house, and I assume the police get to the house, and how do we know from the beginning whether Grampy had a gun? If he didn't have any registered handguns or anything, he just had a shotgun. How do we know he even had a gun, and what happens then? Do they tear his house apart? If he says, I don't have a gun, I don't know what you're talking about. Do they ensue to get a warrant and tear his house apart?
I actually think there isn't. The court, they certainly, after the fact, the court can subsequently issue a search warrant authorizing law enforcement officers to seize them. But initially, I don't think there's a warrant involved. I think, I'm assuming Grampy is the one who was reportedly using a firearm to threaten somebody.
Well, the bill doesn't require the harassment to be involved in a firearm at all. And this could be a dispute where the neighbor cut the wrong tree down and they're threatening each other over that. There's no predilection that a firearm has to be involved to file the harassment complaint.
Right, for the temporary order, it does. But in order to have the order surrendering, the way Senator Carney has drafted her amendment, the complaint actually has to demonstrate the harassment involved the weapon, the firearm or other dangerous weapon. That's how that new subsection 2A is drafted. That is not part of the more formal order, I guess, the after hearing order.
Right, but the section 2A is A or B. A says involving a firearm, but B doesn't involve a firearm.
Right, but there's a whole lot of findings there for B, that a heightened risk of immediate and present danger to the plaintiff. So arguing over who cut down whether the tree was on, one person's land or the other person's land, if that argument rises to the level of threatening or intimidation, if you can show that there's a heightened risk of immediate and present danger to the plaintiff, then the order could include that.
Dave,
Can I just respond as well to your question, Representative Evangelos?
Sure.
So there's if you look at 2A, paragraphs A and B, so the intent of this is to prevent people from getting killed by dangerous weapons. And so paragraph 2A, subparagraph A, would be harassment that involves a firearm or other dangerous weapons. So I'm going to shoot you with my gun, or I'm going to use this machete to hack you to pieces. B involves a heightened risk of immediate and present danger to the plaintiff or a business or employees. And so that could be something different, like, a non-specific threat of death that doesn't mention a specific weapon, like I'm going to kill everybody in your workplace, or I'm going to kill your clerk, or we're going to do something, we're going to kill people, but it doesn't mention a specific weapon. And then there are, as Peggy pointed out, there's a list of very specific criteria that have to be met. And I would just encourage you to be open to thinking about this, not from the perspective of somebody who is, to look at it from the perspective of somebody who has been subjected to a threat of violence. And you put yourself in the shoes of the woman whose death led to the legislation in 2019. I mean, she received a death threat from her brother-in-law, and then he carried it out. But because at that time, the language of the Protection from Abuse Act was not broad enough, there was nothing that could be done to issue a protective order for her. And that statute, the Protection from Abuse Act, was expanded just a tiny bit to allow it to apply to threats made by in-laws. But particularly, I'm thinking of situations like schools and workplaces, both of which I've been involved in protection from harassment actions as an attorney, that those are also situations where people can be subject to death threats or threats of harm with weapons. And where there has been that kind of a very specific threat, particularly with a specific weapon by somebody who possesses that weapon, this gives the people who are subject to the threat, and also to law enforcement agencies who are responding to that threat, to pursue a mechanism for making sure that threat isn't carried out.
I understand, but in the case you've outlined, the guy was already guilty of criminal threatening. This bill wouldn't have helped that situation. I mean, he threatened to kill her. There it is. That's criminal threatening. There was enough there for law enforcement to act. But anyways,
I think that he spoke to a court and she spoke to police, and she was told there was not a mechanism to help her.
Well, the Attorney General just said there was. Anyways, let me talk a little bit about the unintended consequences of, obviously, what are the good intentions of the bill. I'm not questioning you on the intentions, but I want to tell you where I live in my town. If somebody makes a false complaint against somebody and the police show up at least 50% of the houses in Friendship and tell somebody that, you know, they want them to surrender the guns, I can guarantee you now that, Attorney General, we're going to be into another possible situation with police use of force and another case, another tragedy, because half of my rural folks in my town won't surrender their weapons without a fight. That's just the way these people are. They're tough as nails, and they love their weapons, and they're not going to surrender them without fighting. I can guarantee you that. And so I see this bill as putting law enforcement in danger. And the other thing, the idea that people aren't going to make false complaints in this state, we just heard in previous testimony from Ann Head on the COVID squealer line that 12,000 people made complaints. And I'm not going to ever believe that 12,000 of those were legitimate. We know for a fact people have been harassing people. I had a case right here in the town next door, Warren, where there's two convenience stores, and one convenience store squealed on another convenience store on no grounds because they're competitors and they're both after money. So I have no confidence that people will not make false complaints. They do it all the time. And so I'm worried about the safety of law enforcement arriving at a house when you've got this angry guy who is not going to surrender his weapons under any circumstances if you feel he didn't do anything wrong. I just don't see that as a positive outcome. And then the last thing I'm going to say is I've spent 7 years in this committee defending the rights of every individual to, you know, a fair trial, to due process, to the right to a fair hearing, and to the presumption of innocence. And I'm not going to support an ex parte hearing on somebody based on possible false information. I'm just not going to. It runs counter to my beliefs. The concerns you have are legitimate, Senator Carney. They are. You're concerned about the safety of people, but there are so many loopholes in unforeseen circumstances that would develop. And I'm in here every day, you know that. I'm in here defending the right of indigent legal defendants and everyone else to get their fair hearing, their fair representation. And I'm not going to support something that suspends somebody's constitutional rights for 2 days in the event they're innocent. That's just not the way we operate in this country. And I'm never going to believe that there aren't going to be false complaints. I was enlightened by some of the members of the committee, and I was ignorant. I didn't know there was this squealer line, on a COVID squealer line. And I mean, people in my town are feuding all the time. I mean, my town's famous for making newspapers with it. And I'm just 99% of the time, nothing ever materializes except for a lot of swearing and rough talk. And I don't think I'm the only rural town that shares that situation, but I can't support the bill. It's the same way with the red flag bill. I'm not doing it from necessarily a conservative right to bear arms point of view, although I do believe in the Second Amendment. I'm doing it for my belief in the other parts of the Constitution, your equal protection rights, your right to due process and a fair hearing. I can't get there on a bill that violates that, even for a few days. 1 day is too many. If you're the victim of it and you're innocent, 1 hour is too many. And I am worried about law enforcement walking into these situations where there's anger between neighbors, and that anger led to a complaint, which forced the police to arrive at a home. And the Attorney General knows these things escalate, don't they, Aaron? I don't think he wants to answer.
I'm sorry, I was nodding yes.
Okay.
The potential's there.
Okay, thank you. So that's all I have to say.
Thank you, Representative Evangelos. I feel like we are shifting from questions toward a vote. I'll call on folks who have their hands up, and then I think we should move the vote. Oh, okay. Go ahead, Representative Thorne.
Thank you, Madam Chair. And I hope you'll give me my due course. I want to take a page out of Representative Babbich's playbook. If you'll give me about 5-7 minutes so that I can address the many questions and concerns I have about this bill. And one is, I don't know if Peggy or maybe even Attorney General Fry could answer. I don't see anything in the verbiage about ammunition or arrows. Does that mean that ammunition won't be confiscated, just the weapons, and arrows won't be confiscated, just the bows? Anyone?
I have to look. If it's not included in the statute to be vulnerable to being prohibited, then it's not there.
So ammunition wouldn't be confiscated and arrows wouldn't, because it doesn't specify arrows, only bows?
I can take a look at the language while we're talking, but if it's not in there, then that would likely be the result.
Okay, thank you. And, you know, I can't help but think that this is going to open up a door. I'm going to give you a brief scenario that relates to this and how I feel this bill, this direction is going. And I'm not directing this to you, Attorney General Fry, just in general, that when my daughter was in high school, there was a rash of restraining orders issued. In other words, it was kind of a Mean Girls Gone Wild case of there were a bunch of restraining orders that kept getting issued. Girls would bring restraining orders against other girls just because they were chasing their boyfriend, or they called them a bitch, or they did something. And there was a rash of those. And I just can't help but think that this, you know, evidently last year's or the year before's 1811, that was a protection of abuse that opened the door for this. And now we're going for harassment, and maybe next session will be assault charges or trespassing charges or restraining orders. I'm not sure what's going to constitute prudent gun confiscation on the charges front. So I'm just worried that this is just a follow-up to the protection from abuse, that now harassment and on and on and on, and every time that one goes down, they're going to open up another one to open it up a little bit more. And unlike Representative Galgay-Reckitt, I do think this is a big deal. You know, she said, what's the big deal? This is a very big deal because it sets a precedence. And, you know, again, like Representative Evangelos said, you know, there's a certain fine line where once a precedent's been established, we'll just tack on to it. And sometimes, you know, even though it's the glass is half empty, the glass is half full of, we're all prudent adults. We don't want anyone to get hurt. We don't want anyone to get shot. We don't want anyone to get killed. But at what cost of our liberties do we err on the side of caution? And I really have to think that, you know, judges have the ability at this point in this day and age to identify without a specific bill listing cases of harassment. We can confiscate your guns, weapons, bows, crossbows, muzzle loaders, whatever we constitute as a weapon. I'm just worried that this is going to be something else that's just another cause to create more problems than what it's going to solve, because the judges now have enough discretion to identify if somebody's unstable. You know, if somebody, California had the 3-strike law where, you know, you had to initiate something. If somebody has a bad day and goes off the rails on someone, it doesn't mean that they're going to kill them. People go off the rails all the time. So I'm just not sure that throw a blanket over every harassment order and say they made a threat to them, therefore go to their house, confiscate their weapons. They don't, Grampy doesn't say he has any weapons, but the next door neighbor says he hunted deer back in 1954, therefore he must have weapons. Let's issue a search warrant and go through his house, because he's not telling us the truth. He's not disclosing that he has all the weapons. So I'm reluctant, I'm hesitant, and I'm skeptical that this is going to accomplish anything along the lines of what it's established to do. So with that, I'm done.
Thank you, Representative Thorne. Senator Kime?
Thank you. I have hesitated to share a situation, but I think that it's important that we consider this as well. And I understand the intent of this bill is safety, and everyone wants our communities safe. Recently in Turner, there was a double murder, and this person used a knife, right? And so the idea behind community safety, and something that I personally went out on a limb for, is the yellow flag law, because it does seem, you know, to take away someone's freedoms without due process, but it does in fact put due process in there. But the goal is to get the person to a place where they're getting help and they're not going to do damage. Simply taking away someone's weapons may only aggravate the problem, but it certainly does nothing to keep people safe, because you just can't take away enough weapons. And so we put this law out there that it takes away constitutional freedoms. It's sort of a feel-good approach, because that person, whoever it is that's threatening someone or is unstable, they're still going to be able to get something. I mean, it's just those two people, and they're, you know, they died from a knife, and so you can't remove enough knives, right? So it's about, what do we do to interrupt the actions of a person? That's what we have to do. And I just don't believe this bill interrupts the actions of a person. It just aggravates a situation, and it allows someone to walk in and lie about another person and remove their freedoms and possibly put them in danger. So if someone is intent on harm, it's the person we have to focus on. And so that's why I will be voting to pass on this bill. And I would strongly encourage our committee to look further at the issues surrounding how we help people in that moment where they are a threat and where they are in mental crisis or the issue arises, and not focus on the thing that they can get in their hand. And I would make a motion not to pass.
Seconded by Representative Hagan. And I know we're going to have some committee discussion, and first I'll turn to Representative Moriarty. You had your hand up.
Good. Thank you, Madam Chair. A question for you as the sponsor. From the Mile High perspective, my understanding is that the intent of the bill is to place a protection from harassment matters on a par with protection from abuse matters.
That
Is that a
that is
fair
correct.
say? So in other words, the same options in terms of the processing of a harassment claim, the receipt of information, and the remedies available to the reporting person in a harassment case will parallel those in an abuse case.
Exactly.
And we've had the abuse statute for quite some time. I'm not sure exactly how long. It may not be fair to ask you, but I don't know if Peggy knows off the.
Actually, I think Assistant Attorney General Ustack told us earlier that I believe it was 1996, I believe.
I think it was enacted in 95, became effective in 97. I believe that's it. I'm not exactly sure on that.
I actually think it might have been around a little longer because Title 19 was recodified into 19A in 1995. So there was something there before. It might not have been as organized. But I mean, we've had the ability to get some kind of protection from abuse order for quite a while.
And then just to wrap up my questions, with the amendment, Senator Carney, as I understand it, that when we get to the sort of the central issue, which is possible seizure of weapons, firearms on a temporary basis, the harassment itself must involve the threat to use firearms before the court may exercise its discretion to temporarily seize firearms.
Yes, it either has to be harassment involving a firearm or other weapon, or a heightened risk of immediate and present danger to the plaintiff or the plaintiff's employees, for example.
Okay. And then finally, the authority of the court is discretionary, and there is no mandate, as I read the language, to seize firearms or other weapons.
Correct.
Okay, thank you. That helps clarify things for me. Thank you.
Representative Evangelos?
Well, that brings up a differentiation that I think is important, because I'm looking at 5B. So my neighbor's pit bull kills my cat. And I tell my neighbor, your dog comes on my land again, I'm going to kill the dog. And he files an action against me. I think if his pit bull is killing my animals and he doesn't have it leashed and under control, that I have a right to threaten him. I have kids, grandkids around. He's got a pit bull running loose. I've already killed my cat. Why should I face the music? Because his pit bull's running crazy on me.
Well, a couple of things. One is that one threat does not constitute harassment, and you wouldn't get anywhere with the court in that scenario. But secondly, there are probably other steps that you could take in addition to threatening to kill an animal. I don't know if the Attorney General would be willing to weigh in on this or not. I don't want to put you on the spot, Attorney General, but I'm not a law enforcement official, so I don't have a lot of insight there, other than also knowing that you could report if your neighbor's dog killed your cat, I think you said, then you could report it as a dangerous animal, or Maine has a dangerous dog statute that also impose some limits and ways to deal with dangerous dogs that you could pursue civilly without any criminal intervention.
Right, but if that woman you mentioned that unfortunately died couldn't get help from the police, I'm not likely to get much on this one from the police. I just think that the good intentions of the bill aside, there's so many unintended consequences to this bill. The trouble is, not everyone's honest. This, as Jim said, people aren't going to tell the truth, and they are going to file complaints falsely, and judges make mistakes. And I know for a fact judges make mistakes because a family I was helping won a Supreme Court case today. You'll be interested to know, Attorney General, that Ben Hodgson was cleared today. So judges also make mistakes, and I just wish there was another way to get at this besides arriving at someone's house that's been falsely accused, who's a big burly guy who will fight rather than surrender his weapons when he hasn't done anything wrong. And I'm telling you, in my town, they will fight. There is no question about it. And I don't own a gun, you know, but I know people, they'll go to the mat defending their rights because it's constant in the Constitution. So that's enough. Thanks.
Yeah, I appreciate your concerns about, I mean, you're worrying a lot about people who aren't telling the truth and questioning the, and I guess I would just say that I'm worried about people who are subject to legitimate threats of violence, who do not have a way to access the courts to protect themselves unless they're in some kind of a family type relationship with the person who's threatening them.
They can call the police. You know, my neighbor's threatening to kill me with a gun. I mean, call the police.
Representative Thorne?
Thank you, Madam Chair. And I want to go back to something that Representative Moriarty want to get through that. Moriarty said when he referenced, does it have to reference a weapon? In other words, does the threat have to include a specific weapon in order for this, the way that I interpret the bill, to have weapons confiscated? And there was an or clause in there when you read that or that seemed like an all-inclusive, and I can't reference the condition that had to occur.
Yeah, no, I can answer that again. It's either harassment involving a firearm or other dangerous weapon, or a heightened risk of immediate and present danger to the plaintiff, employees, and in determining whether a heightened risk of immediate abuse is present, the court shall consider, and then it lists a bunch of factors.
Right. So specifically that after or doesn't include a specific threat with a specific weapon in order for this to kick in, for a judge to say your weapons need to be seized because you've satisfied the after or portion of it without a specific mention of a specific weapon or anything like that.
Yeah,
just
the difference,
you know, even if it just was, I'm going to get you. I'm going to get you. No specific mention of any particular weapon, no particular method, just I'm going to get you. Would that, I mean, and maybe Attorney General Fry could chime in on, is I'm going to get you constitute a threat to have weapons seized? In this case?
Well, if I may answer, I don't know that that falls within any grounds that would constitute harassment on a single basis.
So someone could say, I'm going to get you, and it wouldn't a judge wouldn't say, no, that's not enough heightened threat for me to issue it. You know, that's all open to interpretation, because a judge could say that I'm going to get you constitutes an immediate threat and insinuates harm. Possible?
It's hard to predict, although looking at the harassment definition, I don't know how a judge could look at that and make that finding credibly. A single action of that without anything else. If they say, I'm going to get you and they're pointing a gun at somebody, obviously that's a different situation than, you know, I'm going to get you someday. But I just saying one time, I'm going to get you, I don't see how any competent judge finds that meets the harassment definition in the statute.
Thank you.
Representative, excuse me, Senator Sanborn.
Madam Chair, I was just going to ask, I apologize, I joined shortly after at some point after the work session started, and I wasn't sure if there was a motion pending.
There is a motion. It was Senator Kimes' motion of ought not to pass. And seconded, I forget who seconded it, but it was seconded.
So I've been on the call for about 40 minutes. I'm not sure anyone's persuading anyone of anything or changing anyone's mind at this point, or really working on the bill. And so I wondered if it wasn't time to call the question on that motion at this point, given that it is after 6 p.m. and we seem to be sort of spinning horrible hypotheticals and asking the Attorney General to play judge, as opposed to actually trying to convince each other of how we should vote on this bill.
I think that would be appropriate as well. I'm kind of in an awkward position of being the chair, and so I appreciate you calling the vote.
Well, I'd like to call the question. I'm not sure exactly what the procedural mechanism is for that. Perhaps Peggy can help me with what the procedure is, but I'd call the question.
I have a point of order. I had my hand raised before Senator Sanborn, so I would appreciate the ability to speak before the vote is called.
I will recognize Representative Libby, and then we'll call the vote.
Thank you very much. I have to say that I strongly agree with Representative Evangelos. I think there's substantial risk for abuse of this proposed statute. And I understand that it may be unlikely to be used, but I doubt that. I don't think it's going to be used often, or it hardly ever happens, is going to be a cold comfort when our Second Amendment rights are being stepped on. I think we should have a much higher bar for taking away someone's constitutional right. And with that said, I'd like to ask for a corner caucus.
That's fine. We can have a corner caucus. I would just like to thank all of the Attorney General and Assistant Attorney General Ustack for being here and for working late into the evening hour on our behalf. We appreciate your participation today. Thank you so much. And then corner caucus, I know that we have some hands raised, but let's do the corner caucus first, and then we'll come back.
How long is it going to be?
Yeah, let's a 5-minute corner caucus.
Thank you.
And Dems, we can also caucus on our same caucus site, please.
Okay. Yep. Gonna mute up.
Well, Peggy, the independent's just gonna caucus by himself here in public. You sound soft.
I'm gonna worry if you talk to yourself.
Well, Soupy around?
She just put up that it's a brief break.
All right. Well, the hockey game's on tonight. We could talk about that.
Not talking to you.
What was the 3-3 you posted?
I don't know. Was that you that asked me that, Soupy?
It just went to you. Why? Did it go to everybody?
Well, I don't know how to reply on this stuff.
Oh.
I just
Okay.
said panelist.
You pick my name.
Your name isn't on there.
I know, because she puts the LD number up.
Oh, okay. Now my new name is on a brief break.
Okay, well, there you go. There, I've been falsely accused. I was asked a question of what the score of the Red Sox game was by a certain member of our staff. And apparently, since
Peggy, are you doing things like that?
They lost.
That's right, Lois, 4-3. It's
Yeah.
about time. We won 9 in a row.
Yeah, I saw
I
that.
think it's time to
It's
fire
never a
Cora.
time to lose.
Yeah, I
Never a
want
good
Cora
time.
fired.
Yeah, we want Cora fired.
I can't find the corner caucus, so I'll be chatting Red
Okay,
Sox.
Lois, let's talk
Join us,
baseball.
but this is the Red Sox caucus.
Yeah.
That's right.
Oh, bye.
We just picked up Steve. All right, I have to go do some work. I have to reply to a question here.
Well, you two drive safe tonight.
Thank you. I plan to,
I'm not
Load up
ready
on
for
the
tomorrow's
caffeine.
work session.
what's that?
That's why I want you to drive safe tonight. I know you're going to be late.
Well, right. When you guys work all night, it means I won't be ready tomorrow.
I know. I
So
got up.
I hope you'll be ready tomorrow.
I have to get up at 4 to do all this work. I actually got up at 4 again this morning.
And it's all work sessions
Just
too,
like
right?
Lois said, you know, it's 24/7 for us to keep track of everything.
Yep.
It's hard. I'm not well informed like I used to be. It's hard, you know. I'm not going to lie about it. And I confess, the way legislature's operating is it's just not as comprehensive a body of knowledge that we come into these bills with, and I'm trying my hardest.
I feel like we have a lot more harder bills this year.
I don't know, it was pretty hard last session. I mean, we did monumental ones, task force, post-conviction, we had some biggies. So while we're on when we did the post-conviction bill last year, the Hodgson family and their allies from Hancock County appeared. I don't know if you all remember that. Testifying in favor of post-conviction. The Supreme Court ruled today that Ben Hodgson did not get a fair trial, and they threw out all the counts against him.
Wow, what's his name? Hodgson?
It was Ben Hodgson. Hillary Hodgson testified, and several nice women from Hancock County testified as well. Just crying to us for the need for post-conviction review. And he had a post-conviction hearing November 20th and 22nd of 2019. And the judge ruled that ineffective legal counsel on all of the counts, but the one other count that would have freed him was the introduction of evidence. And because Ben's evidence was more than 1 year old, the judge didn't let it be heard, and he ruled against him, and Ben sat in prison for 5 more months. He served his entire sentence, 3 years, and today the Supreme Court ruled that he didn't get a fair trial and should not have been convicted. That's why I said judges make mistakes, and it's kind of an unfortunate outcome when somebody sits in a cage for 3 years for something they didn't do. I hope we're going to do that bill next week, so hopefully.
You've got something every single week, Josh.
Well, I hadn't until I got scheduled.
Yeah. Well, you put in big bills.
I only put 9 in, or 8. I mean, I've been good. I mean, I know people that put 40 and 50 in, but they're important issues, and we need to have good hearings. So I'll do my best. I do my research, but we're all tired. Every person on the committee is working so hard, and the staff is. And it's just different. Like you said yesterday, it's just different.
So can I go back to this decision in the law court?
Yeah.
So it says, we vacate the judgment and remand for entry of a judgment granting his petition in full.
In full,
so
right.
Did he ask for a new trial or just post-conviction?
Right. This was his post-conviction review. The judge didn't give him everything. He left one count in place, which left him in prison. But the court ruled today that his ineffective legal counsel was so bad that it likely affected the outcome, and he would have prevailed on the innocent side of the remaining count. The prosecutor had the one we brought up in the indigent legal bill I put in for the fair hearing. The prosecutor, for the second time, had destroyed exculpatory evidence. You know, the first time was filler. Same prosecutor. 15 days after she promised Justice Gorman not to do it again, after she faced 7 bar violations, Justice Gorman didn't follow the bar's advice. And I think she got suspended for 30 days. Promised she wouldn't do it again. And 15 days after the promise, she did it again. I was at the 2-day hearing. Walter McKee was the expert witness. A lot of happy people today. This does not happen very often in our state.
Are you talking about the Hodgson case?
Yep. The Supreme Court said he should have prevailed in his case, and they threw everything out.
Everything? So he's like nothing?
Nothing. Didn't get a fair trial, they said, and that the prosecution destroyed exculpatory evidence that would have freed him.
I had heard that had happened. I wasn't sure, and you had the details, so that was interesting.
No, somebody sent me the decision. Peggy, that's exactly what it said. And then in their conclusion, they said it again. That
Yeah, that's what I'm looking for. I'm on page 18.
yeah, scroll up to the bottom to see the conclusion, and it's there where they the remaining count that kept him in prison was tossed today. But what good does it do? You know, I mean, it clears his name, but he did 3 years in a cage. It's
All
not
right,
okay.
committee members, everybody, are we all back?
Yeah, we were doing a sidebar. Sorry.
Okay. I just know that it's late and we started at 9 and it's been a very long day for all of us.
How long are we going to go tomorrow, Madam Chair? Do you know?
9 to 12:30. We'll stop at 12:30.
Regardless of how many we got through.
Yes.
Oh, really? Oh,
Steve's happy.
well.
I'm hoping that is an
Go
incentive
running. Hey, all right.
through our work efficiently. So when we took a break, thanks everybody for coming back so promptly. We took a break and I think Representative Moriarty and Sheehan had their hands up, and so I'll recognize Representative Moriarty.
Yes, Senator Sanborn made a motion to call the question, which is a motion to cut off debate. I raised my hand to second the motion, and then we went into caucus mode. So I will then, at this point, second the motion.
Okay, so committee, we are moving. We are going to vote on the motion to call the question. And for ease of counting who's voting in favor and who's voting against, when I ask for the votes, please raise your electronic hands because that's easiest to count. So all those in favor of voting on the question, please raise your electronic hands.
Faster this way. Oops, my mic's on. Hold on.
And it looks like 11 to nothing in favor of moving on to the vote. And Soupy, thank you very much for coming to take the vote. So committee members, let me lower my hand. The motion is Senator Himes ought not to pass motion. And Soupy, you can go ahead whenever you're ready.
I will be happy to, except I will tell you, I see 2 hands that are up and I don't know if, I think it's just left over.
Thank you for pointing that out.
Thank you very much.
That's great.
Senator Carney.
No.
Senator Carney votes no. Senator Sanborn.
No.
Senator Sanborn votes no. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Muted.
You're muted, Jeff.
Yes. Thank you. Thank you, Lois. Yes.
Representative Evangelos votes yes. Representative Newell. I will call the absentees. Representative Harnett. Representative Harnett is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. I have 5 members voting in the affirmative, 6 members voting in the negative, and 3 members are absent. That is the vote of the committee, Madam Chair.
Thank you very much, Supi. And Senator Sanborn, you have your hand raised?
Yeah, I didn't know if you just wanted to take a report from the other side or if you wanted another motion.
I think we can take a report from the other side, which would be ought to pass as amended, that being the sponsor's amendment that was introduced at the bill hearing last week.
Well, we did. Do we need that? Because you were on the winning side. You don't have to explain, right?
The motion was an ought not to pass.
Oh, I see. Right. You're right.
And so we're ought to pass as amended.
Right. Okay.
So everybody
You-
all.
Yeah. Usually you poll each member, but yes, we're all on board, I think.
Thank you. Peggy, do you need anything else from us?
I was just going to tell you I'm a little behind on the bill analyses for tomorrow, so you might be winging it tomorrow. No, I'll help you as much as I can. You have some very difficult bills. I know that AAG Molly Moynihan is going to be here to help you with some of the involuntary commitment questions. In fact, she can walk you through the involuntary commitment process. I really feel like I will not be as prepared tomorrow as I wish I were, and I apologize. But I get to spend all this evening with you so far, so that's the trade-off.
Peggy, we appreciate you. You did yeoman's work today with all of our bill analyses, and we will all work together effectively tomorrow.
I'm sure you will.
Thank you very much. We appreciate your analyses. And
Madam Chair?
I have my hand up, Chris.
Oh, I'm sorry. Go ahead, Jeff.
Go ahead, Jeff.
Thank you. Senator Carney, at the total discretion of the chair, I wouldn't have a problem with it if you would talk to Peggy and outline what you would like the priority bills to be, so she doesn't have to do homework on the impossible. And, you know, if we think we're going to do 3.5 hours tomorrow, why don't you select the 4 or 5 bills you'd like to get through as her priority, and then that would help her prioritize her work and not force her to try to stay up till 3 in the morning. Just a thought, but it's a good one.
If I may interrupt, I really appreciate that. I won't stay up till 3 in the morning, and I'm partly done. So, and I really hope you get through all the bills. So thank you. I appreciate that.
Thank you both. Representative Babbage?
Yes, my request was to ask for the order of the bills tomorrow so that Peggy could know that.
Well, Peggy and I will talk once we adjourn tonight, and we'll make sure that we're ready for tomorrow. Anything else, committee members? Representative Thorne?
Thank you, Madam Chair. I just wanted to thank the committee for providing me an opportunity to vote yes.
Very good.
Got 2 yeses in, moving the question and voting on the motion. So, all right, everybody, is there a final motion to adjourn?
No, his dog voted yes once, but they wouldn't count it.
Okay, all right, you get that motion, Representative Thorne. Thank you, everyone. See you bright and early tomorrow.
Good night, everybody.
Hey,
Good night. Thank you.
Good night.